We'll take from that side. Yes. Order for 10 is.
I mentioned the matter before vacation. My lord,
What is this for?
assignment. My lord has my lord
It
observed
is appearing in the list.
in the daily leave one. I remember 114. My lord observed that I will fix up a particular date for taking up assigned matter. My lord, it is pending for last 3 years.
Right, you are right.
114. Time for the respondent, I am suffering a stay. My execution is pending for more than 6 years.
Did not mention it separately. We'll consider regarding these assigned matters. এই অনিন্দিত শুনুন, বলছি যে একটু আমাকে না এই কালকে একবার মনে করে দিবেন তো, আজকে বিকেলে একটা দিন ফিক্স
for non-prosecution.
প্লিজ।
Order 41 and one application.
Application.
Yes, please.
Hello, order 41.
Order, yes. Please.
Lordship, may I permit to mention one inclusion in the list?
What is the matter?
Modification application.
Hand over.
Lordship, another one is one money suit is there. Inclusion in the list, Lordship.
What is the matter?
That
Hearing?
money suit, Lordship.
Money suit is not taken up by our code. We take up appeals and application.
Application, Lordship. Application heading in money suit.
It's an application.
Yes.
Hand
Lordship.
over.
Your Honor, this is a matter for inclusion in the list.
What is the matter? Application or hearing or what?
Application.
Application hand over. Applications and order for 2, please hand over.
My lord, application, my lord. 2016, my lord.
Pardon?
Hearing matter of 2016.
No, hearing.
Application.
In this matter, my lord, I am leading Mr. Shah in this matter, your lordship. This is an FAT, your lordship. This appeal arose from the
If
judgment.
it's a hearing matter, please don't mention. We are not including here.
Lordship, the other side is dealing with the matter, your lordship.
Understood, but no.
Dealing with the
Sorry,
participant.
no. Applications you are taking, but
Lordship,
hearing we cannot have.
as your lordship desires.
Thank you. Next. Call on the list.
Like number one, my lord, this is
Don't want to proceed?
No.
Fair.
My lord, the instruction is there, but my lord, I am not for the my lord, advocate on record, my lord. Sabana asked me the advocate on record. He could not come, my lord. The instruction is with me.
Very well. Learned counsel appearing for the appellant submits that the appellant does not want to proceed further with the matter. Full stop. Accordingly, FA 181 of 181 of 2009 is dismissed for non-prosecution without any order as to cost.
Only instruction is
Uh,
on the record.
Interim order, if any, stands vacated. The written instruction filed today in court be kept on record. Thank you.
Item number 2.
Is that matter, my lord, the divorce suit?
Oh, you don't want to, yes.
My lord, because there is no written instruction as on date, my lord. My lord keeps it on Monday, my lord, I will get the.
On the prayer of the appellant, let the matter stand over till June 23, 2025, when it will be listed under the same heading.
But item number 3, my lord, I appear for the appellant, my lord. This is a application for restoration along with section 5. And my lord, an application and section 5 in connection with the appeal, my lord. This is appearing for the first time, my lord.
Regarding the first one, recall of what order? It was dismissed for
Mr.
non-compliance of court's order, or default,
Default one.
at the order 41 stage.
At the order 41 stage, my lord. It's an application for restoration is Can 2 of 2024, my lord.
And the
Can 3 of 2024 is the section 5 application in connection with
That.
the restoration application.
what is the delay, Mr. Shen?
But delay is substantial, 309 days delay,
390 days.
8 days, my lord.
1495.
In
What?
the appeal, my lord, there is also a delay that is 308 days.
No, that
And
we'll consider later, but this is
Whereas the application, my lord, there is a
1495 days.
14.
What is the reason for the delay?
My lord, the reason for the delay is, my lord will kindly take Can 2, my lord. My lord, the appeal was dismissed on 3rd of December 2019, my lord.
Yes.
Thereafter, my lord, on the 2023, my lord, the petitioner came to the honorable court, my lord, to file the application for section 5 in connection with the appeal. My lord, it was then found, my lord, that the appeal had already been dismissed for default on 2019, my lord.
What was the reason for the absence on that date?
But absolutely, the advocate, my lord, missed the list and did not appear, my lord. My lord, to that regard, my lord, I have filed a supplementary affidavit, my lord. Para 6, my lord, page 2, para 6. I mean,
মিস করে গেছে লিস্টে বলছে হতে পারে করে দিচ্ছি A supplementary affidavit filed today on behalf of the appellant be kept on record. First up, next para. From the explanation furnished in Can 3 of 2024, comma, we find that sufficient reasons for the delay in preferring the application has been made out. Full stop. Read in conjunction with the reason for the absence of the learned advocate for the appellant on the relevant date when the matter was dismissed for default, comma, we find that the application merits to be allowed. Full stop. Accordingly, Can 3 of 2024 is allowed, thereby condoning the delay in filing Can 2 of 2024. Full stop. In view of the reasons for the absence of the learned advocate for the appellant on the relevant date having been made out, comma, Can 2 of 2024 is also allowed, comma, thereby restoring SAT 321 of 2017 and the connected applications to their original file and number. Full stop. The appellant shall serve copies of
can 4.
Can 4 of 2024 on the respondents, indicating that the matter shall be listed under the heading Order 41 Rule 11 of the Code of Civil Procedure along with the said application on July 8, 2025, when an affidavit of service in that regard shall be filed by the appellant. আগে একটা নো অর্ডার রেজিস্ট্রি কস্ট করে দেবেন ওই আগের গুলো এটা অর্ডার 41 হেডিং আসবে ক্যান সহ ক্যান 4 সহ
Item number 4.
Item number 4, my lord, I have for the respondent, my lord. Alright, this is 2022 matter, my lord.
Mr. Shen, please come a bit closer to the microphone. What is the matter about?
2022 matter, my lord, the revocation application was allowed, my lord. Against that, appeal has been filed, my lord.
Appeal was admitted. What is the application about?
My lord, the application is stay of the impugned
It
order.
has to appear under order 41 heading then.
What is the first appeal, regular appeal?
বোর্ড দেখাচ্ছে না এটা কত নম্বর আইটেম ও আচ্ছা ইয়েস
Most probably, my lord, the prefix was subsequently changed, my lord.
ah right thank you but then we'll adjourn for a day then let us they're
But,
not there
Let it be on next week, my lord. I have to give notice to the other side then,
you had mentioned the matter.
my lord.
Gotcha. None appears for the appellant at the time of appellants at the time of call. Full stop. The learned advocate appearing for the learned advocate on record appearing for the respondent, comma, at whose instance the matter has been listed, comma, shall serve a notice regarding the pendency of the matter in the list to the learned advocate on record for the appellants and file a receipt in that regard on the returnable date. Full stop. Let the matter be listed next on June 23, 2025.
My lord, I beg to appear for the appellant petitioner. This is my appeal and
Yes.
it's my application for injunction. My lord, an unregistered will, my lord, probate has been granted, my lord. My lord, I have,
Unregistered will, there is no bar.
there is no bar. Now, difficulty is this, my lord, I am the widow destitute and peculiar facts and circumstances, my lord. My lord, this widow destitute had initially participated in the proceedings below. Thereafter, my lord, due to poverty, she could not carry on the case. She approached the legal services committee. There, in the meantime, my lord, the probate proceedings became ex parte. Now, my client had approached the legal services committee and sought for contesting the appeal. My lord, that was not considered and probate was granted, my lord.
You were the widow of the testator.
I was the widow of the testator, and another peculiar fact, my lord, there were two sons. The elder son was the executioner. The minor son, at the time of filing, the second son was minor. Now, when he attained majority, he gave his consent to these probate proceeding.
What was your ground of challenge?
My lord, my ground of challenge, my
You
lord.
could have been deprived by any reason has been given in the will. We have to go on the prima facie case also. Have you got annexed a copy of the will?
No, my lord.
That should have been annexed, Mr.
Difficulties is, my lord, will not take me amiss, my lord. Since I have been appointed by the legal services committee, my lord,
Oh, here also legal services.
I tried my level best to get whatever documents I could have.
The present appeal has been preferred against an order granting probate of a will executed by the deceased husband of the present petitioner. Full stop. Learned counsel for the appellant submits that the appellant is a destitute widow lady and there were sufficient suspicious circumstances surrounding the execution of the will, comma, since the appellant, comma, the widow, comma, was entirely deprived and the estate of the deceased was bequeathed to the respondent number 1, comma, one of the sons of the deceased testator, comma, also depriving the respondent number 2, comma, who was the other son of the testator and a minor at the time of execution of the will. Full stop. Next para, subsequently, comma, on attaining majority, comma, the respondent number 2 granted consent to the probate. Full stop. However, comma, it is further submitted that due to the strained financial condition of the appellant, comma, the appellant has all along been contesting the suit and suit through legal aid, and there were certain difficulties in contesting the suit at the final stage. Full stop. Next para, keeping in view the above circumstances, comma, in particular the fact that the widow of the deceased was deprived in the will, comma, we find a sufficient prima facie case on suspicious circumstance as well as on other grounds have been made out. Full stop. Accordingly, now we further find that in the event the property which is the subject matter of the will is dealt with in the meantime, comma, the petitioner may suffer from irreparable injury. Full stop. The balance of convenience and inconvenience is also in favor of grant of injunction. Full stop. Accordingly, both the respondents,
Yes, my lord.
accordingly, the respondents shall remain restrained by an order of injunction from changing the nature, character, possession of the suit property and/or from transferring and/or alienating the same, comma, in any manner whatsoever, comma, till disposal of the present application. আচ্ছা, যেখানটা বললাম suit property বললাম না, সেখানে বললাম করে দেবেন suit property বদলে the property which is the subject matter of the will. আচ্ছা, full stop. Next para, the appellant stroke petitioner shall serve copies of the application on the respondents, indicating that the application shall next be listed for hearing in the monthly list of July 2025. Full stop. The petitioner shall file an affidavit of service to that effect on the returnable date.
My lord, only one thing, my lord has recorded that the other son has also been deprived. No, both the sons were.
আচ্ছা, একটা জায়গায় বললাম the respondent number 2 is the minor son, was the minor son. একটু আসুন পড়ে দিন একটুখানি। respondent number 2 এর জায়গাটা বলতে হবে একটু। Also deprived না করে
Only the
was also bequeathed a portion of the property. Also deprived কথা বাদ দিয়ে এটা ঢুকে যাবে, বাকিটা যায়। Thank you.
Item number 6.
Please come to the microphone.
Appellant petitioner.
Yes.
Lord, this application is for recording the death of respondent number 13. Her heirs are already on record.
Great.
Paragraph 4. Madam.
The present application bearing Can 6 of 2025 has been filed by the appellants for recording the death of respondent number 13, comma, whose heirs and legal representatives are already on record. Full stop. We find from the averments made in the application that the same is in form. Full stop. Since the respondent number 13 met her demise on January 29, 2025, and her children, comma, who are her only heirs and legal representatives, comma, are already on record as parties to the appeal, comma, Can 6 of 2025 is allowed, comma, thereby directing the name of the respondent number 13 to be expunged, full stop, expunged, and recording the factum of demise of the said respondent. Full stop. Next para, the necessary consequential correction, comma, deleting the name of the deceased respondent number 13 in the memorandum of appeal, comma, shall be carried out by the learned advocate on record for the appellants during the course of the day. This is the only application.
This is
Paper book
the only
directions.
application. The appeal is ready. Paper book has been filed. If your lordships kindly fix it up any day. my lord.
Don't even think about it, Mr. Yes.
Item.
Thank you. আচ্ছা একটা কি অলরেডি ডিসমিস ফর ডিফল্ট হয়ে
My lord, the affidavit of service is not prepared in this matter till now, my
we
lord.
directed you to serve.
Yes, my lord.
What is the application for?
This is the restoration application, my lord. My lord,
We had not directed you to serve.
my lord, kindly keep it in short passover counseling.
No question of short passover. Is it within time?
Yes, my lord.
When was the appeal dismissed for default?
Yes, my lord.
Yes, it is within time. Why are you asking for time?
My lord, counsel in this matter is still not arrived, my lord, for this heavy rain. Kindly keep it in short
You are
passover.
allowing the application. Who is the counsel?
Mr. Arun,
Mr.
Mr. Arun Das.
You are not in this matter at all.
No, 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 no. I am
Been requested by his clerk.
proxy counsel only.
You are
Proxy counsel, my lord.
proxy counsel.
Request.
Passover করে রাখুন তো। Passover. Tell him that we will take up the matter whenever it comes.
My-
Whoever has told you, tell him.
Village man.
We'll allow this application. Why keep it pending unnecessarily? Ask your proxy instructor that when the real counsel comes, so that he appears and we'll take up the matter. Let him mention the matter whenever he comes in. We'll take it up out of turn and allow it.
My lord.
Yes.
I am appealing with the appellant petitioner.
Yes, Mr. Das, what is the
Application for direction of the speedy disposal, preparation of paper.
no directions were passed?
At the time of injunction order, then no.
Acha, respondent is appearing? No.
No. After.
So all the formalities have to be.
Yes. Every service.
Very well.
Can two laws.
No other application is pending.
No. Can one dispose of?
Right. The present application bearing Can 2 of 2025 has been filed by the appellants for expeditious hearing of the appeal and for passing necessary directions in that regard. Full stop. In view of the innocuous nature of the prayer, comma, prior service of notice on the respondents in respect of the application is dispensed with. Full stop. Can 2 of 2025 is allowed, comma, thereby directing the appellants to put in postal costs and due requisites for service of notice of the appeal on the respondents, comma, within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a week. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. No address to cost structure. যেটা পাসওভার ছিল সেটা কোন ম্যাটারটা হলো 7 months. Yes.
In this room.
My lord, 9, I'm for the appellant, my lord, that
All right.
during pendency of this appeal, we have filed one application
led by
under
Mr.
order
Analogous.
1 rule 10-2 before the learned trial court. That application was allowed at page 18 of my
So
application.
that person has to be added here also. The appeal is against injunction order.
No receiver.
Receiver.
Now,
Well,
led
we're
by
adding
Colbert
the-
first. Yes, I
It's a
have.
usual, formal application.
Yes.
My lord,
Been
one.
already added in the.
Added in the trial
My
court.
lord,
Right.
that reply may be filed, my lord,
And-
against the.
Opposition
The
and reply to
opposition.
this. Why?
My lord, to the main.
To the main receiver.
Receiver application.
Ah.
Can 1.
Very well. Can 2 of 2025 has been filed for addition of which parties are
My lord, proposed respondent number 4 to 6. At page 3 of my application.
very well. For addition of proposed respondent numbers 4 to 6, comma, who have already been added in the trial court. Full stop, since the appeal itself arises out of an order under Order 40 of the Code of Civil Procedure, comma, in view of the addition of the said proposed respondents in the suit, comma, the present application is formal in nature. Full stop. Accordingly, comma, upon hearing learned counsel for the parties, comma, can 2 of 2025 is allowed, comma, thereby directing the proposed respondents stroke opposite party numbers 4 to 6 to be added as party respondents to the present appeal. Full stop. The necessary consequential corrections to the cause title of the memorandum of appeal and can 1 of 2024 shall be carried out by the learned advocate on record for the appellants during the course of the day. No order as to cost. What about the main can? You have
And one is the receiver.
can one এর উপর একটা order করুন, can affidavit in opposition and reply filed today be kept on record? Would you like to move that application?
My lord, kindly fix, that was running in the list, my lord. Kindly fix a date, my lord. That
You can move it today also.
My lord, kindly fix a date.
My lord, kindly keep it under after day after tomorrow. My lord, Kollol
My
bus.
lord,
No
Madam-
time on the ground of Mr. Bas. He doesn't have the locus standard to appear online. Not day
Sorry.
after tomorrow.
Actually,
Day
my
after tomorrow
apologies.
is the appeal hearing day. So we'll keep it next Monday, Mr. Basu.
Yes.
Next Monday.
Next Monday? Yes, very good. On the prayer of learned counsel for the parties, comma, can 1 of 2024 is adjourned till June 23, 2025.
Deeply obliged.
Opposition reply কিন্তু বলে দিয়েছি। Thank you.
My lord, affidavit of service has been filed, my lord.
আচ্ছা, আরেকটা লাইন অ্যাড করে দেন প্রথমেই affidavit of service filed to be kept on.
Good.
Yes.
Hold
Yes,
on,
Mr. Aditya, what is the matter?
There is a delay of 75 days, my lord.
What is the reason for the delay?
My lord, you lost me, please to see the order sheet that I have annexed. My lord, against
Appearing
the
for the respondent number
1 to 6.
1 to 6.
The difficulty is that my advocate on record has received the instruction for appearing for 1 to 6.
And he?
No, one, I am appearing for respondent number 1, 1 to 3 here.
Decide between yourselves who is appearing.
There is no such respondent.
There is no respondent number 6. You are in the probably you have made a wrong number.
Appearing for the respondent number.
What is the appeal number in your case?
Appeal number, my lord, FAT 64.
Yes, same matter. You are wrong.
I will be appealing in item number 11.
So you must treat your learned friend to tea or coffee during the recess. You are appealing for which respondent?
Respondent number 1.
Only 1. 2 and 3 you have served.
Yes,
2
my
and
lord.
3, my lord, they did not contest before the trial.
2 and 3 did not contest.
They did not contest.
It is
Expert
a
order
super
against
partition, my lord, preliminary decree has been passed. Against that order, they have prepared an appeal before the district judge, and district judge kept it pending for 1.5 years. And the reason for rejection of that appeal, my you lost me, please to see.
Rejection of the dismissal of the appeal. They got the
certified copy has been.
no. They got the preliminary degree. You filed an appeal.
Preliminary decree has been given. 3/4 share has been given allotted to them.
So why was it dismissed? Tell us.
So,
Don't
my
keep
lord,
us in suspense.
One of the district judges hold that in view of the provision of the Bengal Agra Assam Courts Act, this court has no jurisdiction.
No, my lord,
Plenary jurisdiction.
আমি আপনি লিডিং করে দিচ্ছি। My lord,
আমাকে বলতে দিন আমার
না ঠিক আছে আপনার কথা
Probably he will
বলে দিচ্ছি,
concede.
আপনার
That's
কথাই
right.
বলে দিচ্ছি। My lord, the appellant, plaintiff's appellant filed the civil suit for partition.
No, Mr. Aditya is faster. Let him speak.
My lord, against the preliminary decree was passed, my lord, on part.
Up to this, we know. Why are you repeating? What is the valuation of the suit?
Valuation of the suit, my lord,
2 lakhs.
2 lakhs.
2 lakhs.
So, the appeal will be preferred before the Honorable High Court. Instead of that, he preferred the appeal before the learned district judge.
Yes. What do you
And
say to that?
Learned district judge returned the certified copy, my lord.
Yes. What is the difficulty in
But
that?
I'm
is
not
not
doing that,
maintainable.
my lord. They have
You should have preferred. This appeal is now filed against the trial court's degree. What is the reason for the delay? Pendency before the district judge.
Yes, my lord.
That is the reason.
Yes, my lord.
We're allowing it. Can 2 of 2025 is an application? Can
one.
1 of 2025 is an application for condonation of delay in preferring the appeal? Full stop. There is an ingredient of section 14 of the Limitation Act involved as well, comma, since the reason for the delay is that, comma, by a bona fide error, comma, the appeal was initially preferred before the learned district judge, comma, whereas under the Bengal, Agra and Assam Civil Courts Act, comma, the pecuniary jurisdiction vests with this court for entertaining such appeals. Full stop. Upon such dismissal, comma, the present appeal has been preferred. Full stop. Upon hearing learned counsel for the parties, comma, we find that sufficient explanation for the delay has been given. Accordingly, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 64 of 2025. Full stop. The said appeal shall be deemed to stand registered and admitted accordingly. No orders to cost. What is can 2?
Can 2 is against the original order, my lord.
What is the prayer made? What is appropriate or what is the meaning of this?
It is a interim order, interim.
In the prayer portion, you have asked for appropriate order. What is an appropriate order? You have to be specific in your prayer. This sort of application is not maintainable. Unless you specifically pray for something, this is an omnibus prayer without any specific prayer. What appropriate order? And in the body, you have asked for setting aside the order. This is not a proper application.
I am withdrawing this application.
I think that will be better, Mr. Aditya. You personally settle the application or draft it or whatever. Can 2 of 2025 is an application for within double inverted appropriate order. Full stop. It has been mentioned in the body of the application that the appellant prays for setting aside the impugned judgment and decree, which is not possible at the interim stage. Full stop. During hearing, comma, learned counsel for the appellant, comma, in his usual fairness, comma, submits that the application ought not to be proceeded with in its present form and seeks leave to withdraw the said application with liberty to file a fresh application with appropriate relief. Full stop. Accordingly, can 2 of 2025 is dismissed as withdrawn with liberty to the appellant to file appropriate application for a proper interim relief in connection with the appeal. No orders to cost.
Grateful.
Thanks. Come with a proper application, we'll consider.
I'm already.
আচ্ছা প্রথম লাইনে একটা দিয়ে দেবেন মেঘনাথ বাবু since প্রথম লাইনে একদম since the respondent numbers 2 and 3 did not contest in the court below, comma, prior service of a copy of the application is on the said respondents is dispensed with. 11. You are for the petitioner?
Yes, man.
You are for this. Oh, that matter. The real matter.
Yes, ma'am. The difficulty is that we have received the brief yesterday only.
So what?
Just yesterday.
Yesterday it was 24 hours back or 12 hours back. That is sufficient time. One night is enough.
I have just gone through. I have just not gone through the brief. Entire brief I have not.
Should have gone through. It's your fault.
After 11 p.m. That is the
After 11 p.m. is not a time at all for an advocate or a judge for that matter.
Let you start the matter.
He'll end the matter also. What is the matter against? Mr.
But here, my lord, there is a decree that has been passed in the suit for partition.
Please take the microphone a bit closer to you.
So sorry, my lord.
Yes.
So, my lord, there is a suit, my lord, that has been filed for partition, my lord. Okay.
Whose suit? Their suit or your suit?
My suit, my lord.
Dismissed.
My suit. My lord, it has been decreed, but my lord,
preliminary.
Yes, my lord, but there has been my lord, some anomaly in the decree itself because there have been some contradiction in the judgments itself, my lord. So, my lord,
the shares declared are not as per your prayer.
Yes. Yes. So, my lord, I only take your lordship, my lord, to 4 paragraphs of the judgment, my lord. Only that.
Do that.
Paragraph number 34. I'm sorry, my lord. If I just briefly say, my lord, about the content, my lord, in the plain and written statement, is that, my lord, the appellant before your lordship, my lord, they are, my lord, the legal heir of Jodunath, 1. And, my lord, the defendant, my lord, 1A to 1F are legal heirs of, my lord, Robindranath. And 2 to 7 are legal heirs of Gobindo. So there are 3 Gobindo. So, my lord, Jodunath, Robindranath, and Gobindo, three brothers. So, my lord, the scheduled properties are Schedule A and Schedule B. So, Schedule A contended, my lord, 4 plots of land. Schedule B, 2. So, my lord, what happens? That another fact is that Jodunath, Robindranath, and Gobindo gifted, my lord, some portion from this A and B schedule property in favor of, my lord, the son of Jodunath, plaintiff number 1 and 2. So this content is C schedule property, which is within A and B. So now, my lord, I prayed. My lord, now in this meantime, my lord, what happened? The defendant number 7 to 9 came into picture, who are, my lord, some stranger. So, my lord, who claimed that they got, my lord, demarcated. They purchased demarcated share from the property of legal heirs of Gobindo, which is not possible because there were no demarcation or partition before that. So, my lord, they are defendant number 7 to 9. So, my lord, I prayed for partition in the entire property of A and B with respect to everybody's share, and with respect to C, only our share. So that was my contention in the plaint. They denied the gift deed in the written statement. They said that no, the three brothers.
How can there be your share only in C? There was no demarcation.
Because, my lord, it is C schedule property is not a demarcated property. So, my lord, it is said that plot number, it is a particular plot number which is contending in.
So regarding that property also, everybody will have share.
My lord, what happens, my lord, here C schedule property is meant to be the property which are from A and B schedule property. Let us say, my lord, A schedule content X and
you
B.
cannot dictate the code as to which portion will be given to you. No, not this code, that code.
No, I follow, my lord.
So you cannot say C will be allotted to me.
I tell you, Lord, if C is not a particular portion.
Anyway, what is done by the court?
So, my lord, what happens here? The court says
the
that
judgment in the judgment after para 29, it's directly 33, page 6.
My lord, yes, I've seen that also.
So you are going to place para 32?
Yes, my lord, 34, 35, 36. Kindly sees this ones.
What is the discrepancy?
My lord, it is, my lord, held that it is a joint property. But in the operative portion, it is held that from a particular plot, 7 to 9 has to be given a particular share.
In respect, I mean, adhering to their purchase?
Yes.
That cannot be.
This
At
is
best,
what-
shares should have gone to them.
That is exactly what my prayer before your lordship. And also, my lord, in the operative portion, the calculation that has been given, let us say, my lord, it is written as 2 in favor of this, 3 in favor of this, and 6 in favor of this. So it is
The total does not tally.
yes, it exceeds the portion in the particular plot.
Must be someone, some mathematical genius like me. Makes arithmetical errors. No,
So-
you are appealing for 1 to 6 on caveat.
Yes, my lord. I think
So you have to
caveat was
serve
fine.
on the others.
But I have served upon all of them, my lord.
There was a direction by court.
No. There was no.
Without direction, you cannot.
Bhul hoyeche
For the
actually.
first time, it is coming.
We
Sorry,
cannot.
my lord,
we
it's
can-
my
No,
mistake
you
that happened.
could have served, but we cannot take cognizance of that unless they appeared. If they appeared,
Sorry,
we
my lord, I ought not have served this. my
will
lord,
direct you to
mistakenly.
serve again
I'll
on
do
the
that.
others. He is appearing for 1 to 6.
Then, my lord,
Usual order.
Yes, my lord.
Final degree proceedings will continue. No final degree will be drawn up.
As your lordship.
Certain.
And they are just trying to, my lord, make, my lord, the interest with respect to others, my lord, so that they cannot be done in this meantime.
They are trying to create third party interest.
Yes.
No, you have not asked for injunction. This is
My lord,
only a
in
stay
the
application.
in the application, my lord, that I have
What is that?
can number 1, my lord.
Is can one we are taking up? It's a stay application.
Yes, my
Prayer
lord.
is also for stay. Only stay. No injunction is sort of.
I don't have a CAN application.
Then what do you have?
Only the appeal, my lord. Memo of appeal with me.
You have not served the can?
But I have served both of these together.
I have the memo of appeal.
Find out. It must be there. Oh, it's not there.
It can.
It is there. my
What
lord.
has happened to you?
Sorry, my lord.
Any change in life recently?
No. Absolutely not.
I just pray, my lord. I'm
No, need not pray for that. In view of appearance of the respondent numbers 1 to 6, service of copies of the application on the said respondents is dispensed with. Full stop. Since a prima facie case has been made out on facts and on law, particularly with regard to the allocation of specific shares in respect of the strangers purchasers,
My lord.
being the respondent numbers 7 to 9.
My lord, the respondent number will be, my lord, there are defendant numbers 7 to 9.
Being the defendant number 7 to 9, as well as in view of certain mathematical errors in the allocation of shares, the appeal is required to be heard on merits. So we also find from the averments made in the application that unless the final decree, that in the event the final decree is drawn up on the basis of the preliminary decree which has been assailed before us, the appellants may suffer irreparable injury. Full stop. There is no abhorrement regarding injunction in the application.
But I haven't seen.
File a fresh application will be possible. Next para. Accordingly, there shall be stay of accordingly, the learned trial judge shall proceed with the final degree proceedings, but shall not draw up any final degree without the prior leave of this court till disposal of the application. Full stop. The appellant's petitioners shall serve copies of the application on respondent numbers 7 to 14,
Yes, sir.
indicating that the application shall be listed for hearing on July 14, 2025, when an affidavit of service to that effect shall be filed by the appellants. If you file an injunction application, we are not mentioning anything. File that, mention it, it will appear along with this, will pass on.
Grateful. Deeply obliged.
Thank you.
For the plaintiff respondent,
Respondent.
kindly see your lordship's last order.
In person? Yes, you are there. You haven't engaged anybody?
গিয়েছিলাম মাই লর্ড, আমি 14 তারিখে অর্ডার
একটু মাইকটা ইউজ করুন ম্যাম।
সরি গিয়েছিলাম 14 তারিখে অর্ডার বেরিয়েছে, 15 তারিখে গিয়েছিলাম, গিয়ে স্ট্যাম্প দিয়ে আমি অল কপিস দিয়ে এসেছিলাম। তারপরে ওনারা 19 তারিখে আমায় ফোন করেন, করে বলেন যে ডকুমেন্ট মানে আবার একবার ডকুমেন্ট দিতে হবে। তখন 20 তারিখে আবার যাই, গিয়ে
তো
ওনাদের
আপনার অ্যাডভোকেট দেওয়া হয়নি, এখন অ্যাপয়েন্ট করা হয়নি?
করা হয়েছিল, কিন্তু উনি 9 তারিখে আমাকে ফোন করে বললেন যে আমি আপনাদের কেস করতে পারবো না। তা আমি তখন জিজ্ঞাসা করলাম যে কেন করতে পারবেন না, তা উনি এইসব আমাকে পাঠিয়েছেন হোয়াটসঅ্যাপে লেখা, যে এরকম আপনাকে ক্রিমিনাল কেসে মারধর করছেন, এই করছেন, এইরকম
দেখি
করে
দেখি
লিখে পাঠিয়েছেন লাস্টের লেখাটা।
that person is saying that without documents he cannot do it.
আমি সব ডকুমেন্টস দিয়ে দিয়েছি, কারণ এই পেপারসটার মধ্যে স্যারকে দেখান।
এটা ফেরত দিয়ে দিন তো ওনাকে, এটা ফেরত দিয়ে দিন না। The petitioner appearing in person submits that although she approached the Calcutta High Court Legal Services Authority, and an advocate was engaged to conduct her case, the said learned advocate expressed her inability to conduct the case due to lack of papers. Full stop. It is submitted by the petitioner that she has handed over all documents which are with her to the Legal Services Authority. Full stop. The Calcutta High Court Legal Services Authority is directed to immediately look into the matter on the basis of a server copy of this order and, if necessary, engage a new advocate to contest the case to conduct the case on behalf of the appellant. Full stop. The appellant shall furnish a server copy of this order with the appropriate authorities at the earliest. Full stop. Let the matter stand adjourned till July 8, 20.
আমি আজকে অকুপেশন চার্জেসের ওপরে সম্পূর্ণ মানে রেডি হয়ে এসেছি এবং আমি সম্পূর্ণটা লিখে এনেছি, প্রেয়ার পোরশন বা যা কিছু আমি অল করতে পারবো, একদম হিয়ারিং করতে পারবো।
Before the trial
জাজমেন্ট
court, they have
নিয়ে
changed
এসেছি।
at least 6 advocates. It's not that because of
No,
their
no,
financial
আমি
irregularity,
আজকে
because of their conduct.
আমি আজকে
called
সম্পূর্ণ
with the
রেডি
advocates.
রয়েছি, 6টা জাজমেন্ট নিয়ে এসেছি।
না, যে কোনখানটা ছাড়লাম কি বললাম মেঘনাথ? Till July 8, 2025, when it will be listed under the same heading. Full stop. Next para. It should be mentioned, we shall be failing in our duty if we do not record the submission of the petitioner, seeking leave to appear in person, that she has come prepared in the matter. Full stop. However, in our order dated May 14, 2025, we had recorded that the appellant, appearing in person was unable to assist the court properly despite repeated opportunities being given. Full stop. We had also recorded that it is understandable since the petitioner and you are the daughter of the petitioner, and her daughter are not legal professionals, and we completely sympathize with them. Full stop. Next para. As such, we are unable to accede to the prayer of the petitioner by granting leave to her to appear in person, in view of the petitioner and or her daughter being unable to assist the court properly, causing unnecessary wastage of valuable time, valuable judicial time, which is detrimental to the interest of the other litigants waiting in the queue. Full stop. Accordingly, the petitioner is directed to re-approach the legal services authority with a server copy of our order for the said authorities to take appropriate steps.
My lord,
We refuse you that leave. Sorry. আপনাকে লিভ দিতে
my lord,
পারছি না আমরা
5 মিনিট দিলে ম্যাম
না
my
দিতে
lord
পারছি
আমি
না
এটা ম্যাম my
আমরা
lord
রিফিউজ করে দিয়েছি অলরেডি আপনি লিগ্যাল সার্ভিসেস অথরিটির কাছেই যাবেন ওখান থেকে
আমাকে ডিমোটিভেট করেছেন my lord
নেক্সট
উল্টো
ম্যাটার
বলেছেন।
প্লিজ 13 who is appearing yes what is the matter Mr. Shet
13, my lord, I am appearing on behalf of the plaintiff appellant. My lord, item number 13 and 26, item number 26, both the appeal has been filed by challenging the same judgment, my lord, between the same parties, my lord.
26 এ ফাইলটা বার করুন তো you are appearing in both
No, I am for the respondent one.
you are appearing in both
Yes, both the matter.
26 এ ফাইলটা give us some time we'll get that file
Yes, ma'am.
What do you do?
My lord, I
wait সেকেন্ড জাজেস কপিটা কই একসঙ্গে তো থাকবে দুটো yes Mr. Shet what is the matter
item number 13, my lord. My lord, suit for specific performance.
this is
filed
FAT number 175
175, my
yes
lord.
suit for specific performance
Filed by my client, that is the appellant hearing.
they agreed to sell to you
Yes, my lord.
that is the agreement
Yes, one agreement was executed.
then what happened
My
dismissed.
lord, that suit was dismissed. My lord, another matter, my lord, item number 26, suit for eviction of a licensee has been filed by my client, learned friend's client.
Analogously heard.
That both the suits was heard analogously by common
Your
judge.
suit dismissed, their suit
Yes, my lord.
naturally because if you're specific.
Yes.
So all the respondents were plaintiffs in the court below in that eviction suit.
Yes.
So why are you appearing for one only? You did not contest together in the court.
My lord, my client give me only one Bakaladama, therefore I filed there. I will talk with my client whether the
Mr. Shet, you have served on all.
My lord,
no order was passed.
my
As
lord,
No order was passed.
no order actually.
no, caveat.
Okay, actually.
Did you direct previous service?
Yes, my lord, I have served. They have filed caveat. my
Take caveat file.
Who has filed caveat?
Sanjay Singh file caveat. Respondent one. Respondent one.
You're not even sure of the basic facts, Mr. Shet. Who lodged a caveat? Only one.
Yes, my lord, only one.
So the rest you have to serve then. What is the matter? What is the prima facie case?
Prima facie
Why should we grant you injunction at all?
My lord, kindly come to.
Why was it dismissed? Tell us.
I have not paid the money within time according to the agreement, my lord. If your lordship kindly come to page 13 of the judgment.
It's 13
Paragraph number
of the judgment. Achha.
Yes, sir.
Yes, paragraph number.
Inner page 13.
Yes, paragraph number
T.
C. Yes.
The defendant did not specifically deny the signature on the said agreement. As such, it can be presumed that the defendant admit the existence of the said agreement. This court cannot accept the plea that the agreement was manufactured.
They had filed a counterclaim on a separate suit. Separate.
Yes, my lord. My lord, I am also
They had filed a separate suit.
Filed a separate suit. My lord, I have filed the counterclaim in respect of that suit, my lord.
Asking for the same relief.
Yes, my lord. My counterclaim has not been decided.
Why should it be? Your suit is equivalent to that counterclaim. There also you ask for specific performance.
Yes.
Your counterclaim is misconceived.
Yes, my lord.
You have asked for the same relief as in this suit.
Yes.
Two suits cannot be maintainable on the same cause of action.
My lord, thereafter, my lord.
Your counterclaim was also for specific performance.
No, my lord. Yes, no.
What
I have
was the
filed se-
counterclaim for?
I have filed separate suit, my lord.
Counterclaim, what was the relief sought in the counterclaim?
Suit is not maintainable because of that.
Can that be a counterclaim? What are you saying, Mr. Sethi? You have forgotten the basics, rudimentaries of civil law.
Sorry, my lord.
What are you saying? Ridiculous things in court. You are too well groomed for that. You say you have filed a counterclaim in the suit or a written statement.
I have filed written statement along with counterclaim.
What was the
Claim-
relief in the counterclaim?
Claiming that I am not the.
What was the relief? Counterclaim means he's on the footing of a suit.
If your lordship
What is the
kindly
relief you claimed in the counterclaim?
Kindly come to page.
Why should I come to any page? Why shouldn't you be able to tell? Yes, what was his counterclaim? What was his counterclaim?
Counterclaim is nothing. He denied all the things, but not.
Basically a written statement. Yes, Mr. Shet, please continue with page 13.
Page 13, my lord, paragraph number D.
D, yes.
Nothing has been mentioned in the said agreement regarding tenancy of the plaintiff at the suit property. Both parties have signed on the agreement. The recital of the agreement reveals that the plaintiff had approached the defendant for.
Why are you reading these? These are not grounds of challenge in the appeal. What was the error?
My lord,
What was the error in the judgment? Why was it dismissed, your suit?
my suit has been dismissed because of that I have not paid the.
Where is that finding? Come to that finding directly. You are reading other paragraphs. Content of the agreement corroborated. They have admitted the agreement.
My lord, next page, page number 14.
Don't fish out. What is the exact paragraph?
Page number 14.
Page number
G.
14.
G.
Paragraph number G. That there is no evidence before this court to conclude.
What
that
is
the
your answer to
plaintiff-
this? What is your defense to this finding? You did not produce any evidence to show that you have paid anything.
My lord, I have produced the documents. I have exhibited the agreement, my lord. My
Not
lord, and
agreement regarding payment.
payment, my lord. I have deposed that in respect of.
Orally.
Or,
Anyone else corroborated your evidence?
no, my lord.
The court disbelieved. Where is the wrong in that? No
My
proof
lord,
of your payment.
Another thing in paragraph, if your lordship kindly come to paragraph number F.
Yes, F.
On perusal of the exhibit number 1, that is agreement for sale, it appears the advance amount of rupees 25,000 paid by the plaintiff.
So in the agreement itself, it was acknowledged.
Yes. Purchaser has been acknowledged by the defendant. It further appears to this court that exhibit number B.
Yes, a
C,
prima
D
facie case has
proof
been made out. Prima facie case has been made out.
an amount of rupees 3,25,000
We have to look into the evidence
further
to see
acknowledged.
whether he had proved his further payments, because the evidence, the agreement evidence is first payment. Let us see. Injunction regarding what? Transfer alienation
Yes, my lord.
and disturbed possession.
And they are trying to.
You are granting ad interim injunction, you will serve on the other respondents.
Yes, my lord. My lord, during pendency of this appeal, my lord, execution case has been filed.
Execution case has been filed.
Yes.
That is regarding the other appeal.
Other appeal, item number 26.
What is the application made there? You have made another application in that also.
My lord,
That
in respect
application
of
is
appeal number FAT 170.
stay of operations.
Stay
You
of
will also very well.
And in respect of
Very well.
appeal
The-
number 175, my
The
lord.
two appeals are taken up together for hearing, since they arise out of analogous suits. Full stop. FAT 175 of 2025 has been preferred against a judgment and decree whereby the appellant's suit for specific performance of an agreement for sale of the subject property was dismissed, primarily on the ground that the appellant failed to adduce evidence regarding payment of consideration. Full stop. Learned counsel for the appellant submits that the impugned judgment itself records that the agreement contains a paragraph where it has been stated that the first payment of consideration was made by the appellant. Full stop. Next para. FAT 176 of 2025, on the other hand, has been preferred against a parallel suit filed by the respondents for eviction of the appellant as a licensee. Full stop. The said suit was decreed, since the appellant, it was held, failed to prove that he was either a tenant or had any title in respect of the property. Full stop. Since the two suits are were heard analogously, and the outcomes of each of the appeals would be consequential insofar as the other is concerned, comma, we are of the opinion that the appeals ought to be heard together finally as well, full stop. Since the appellant has made out a strong prima facie case for hearing the appeals on merits, comma, we grant injunction restraining the respondents and or their men and agents from transferring and or alienating and or creating any third party interest in respect of the suit property and or disturbing the peaceful possession of the petitioner during the pendency of the application. Full stop. Next para. With regard to Can 1 of 2025 filed in FAT 176 of 2025, comma, we grant stay of operation of the impugned decree of eviction as well as connected execution case, comma, if levied, comma, also till the disposal of the said application. Full stop. The said two applications, comma, respectively Can 1 of 2025 in each of the appeals, comma, shall be heard together and be listed for such hearing on July 9, 2025, when the appellant shall file an affidavit of service with regard to service being effected on the respondent numbers 2 to 6. Full stop. Copies of the application shall be served on the said respondent numbers 2 to 6, indicating the returnable date and the gist of the order. Full stop. The service on the respondent number 1 in both the appeals is dispensed with in view of the appearance of the said respondent through his learned advocate. Good. Thank you. এগুলো একসঙ্গে আসবে অ্যানালগাস হবে। 23 মার্ক করে রাখবেন, পরে আবার দুবার করে না কল হয়। আচ্ছা, এরপরে পাসওভার ম্যাটারটা একবার ডেকে দেবেন, যদি কোনো না থাকে নট টু ডেকে। Yes. Yes, Mr. Jha, what is the matter?
On the earlier occasion, I was directed to.
Can you please take the microphone a bit lower down?
I was directed to serve Can 1 upon the respondents.
Can 1 is a section 5?
No, section 5 has been allowed. Substitution petition has been allowed. Can 1 is for stay of the operation of the judgment.
Substitution application is there?
Has been allowed already.
Oh, all those have been allowed. Now the stay.
Yes, sir.
What is the impugned decree? Can 1 টা কোথায়? সব রয়েছে শুধু can. Page. What is the outcome of the service, Mr. Jha? What is the endorsement?
The only question which went against me.
No, the proper service has not been effected. These have come back.
All services have been returned. All services have been returned since beginning.
What is the endorsement? You can't understand.
Addressee cannot be located.
Then, did they contest in the court below?
Yes, my lord.
What was they contested from this address only?
Yes, that is the address of the suit.
Yes.
I think that both are the daughters.
Both are?
Both are the daughters of the original plaintiff. Upon
Acha.
the demise of the original plaintiff, both the daughters were substituted in the trial court below.
At the same address, they are same.
Same address.
And they contested, these daughters contested?
They contested.
Then will constitute to be good. So what is the appeal against? What is the nature of the
performance?
Acha.
There was an agreement between the parties to sell a particular piece of
What is the scope of stay, Mr. Jha? Your suit has been dismissed. Stay, what does stay mean? We'll dispose of the stay, will not grant any stay, but will definitely pass the usual directions for paperbook and all. Can 1 of 2020 is an application for stay of operation of a decree whereby the plaintiff stroke appellant apostrophe suit for specific purpose was dismissed. Since the suit itself was dismissed in the assailed judgment, comma, we are of the opinion that there is no scope of grant of any stay. Full stop. However, comma, we dispose of Can 1 of 2020 by directing the appellant to put in due requisites for service of notice of the appeal on the respondents within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, full of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. প্রথম লাইন একটা দিয়ে দিও, affidavit of service along with envelopes filed to be kept on record. Thank you.
Much obliged.
Thank you. 7 you are appearing?
I'm for the
Yes.
appellant, my lord.
Restoration application, you are absent
Within time,
within
this
time.
application has been filed. Order dated, my lord.
Dismissed for default at the order for turn stage.
No, my lord. Paper book has already been submitted. One application it was pending. That is my lord, can number 4 for production of a minor child.
Can 5 of 2023 is an application for restoration of the appeal, comma, which was dismissed for default on November 12, 2024. What is the reason given?
My lord, paragraph 4, my lord, landed advocate on record, erstwhile advocate on record died. Paragraph 4, he has filed this
Who died?
application. Paragraph 4, Basudev Gayan, erstwhile landed advocate on record. I am appearing in change brief. Paragraph 4, they have stated the reason.
Eye problem.
My lord,
You had an eye problem.
I am appearing in change brief. Erstwhile advocate died. Basudev Gayan, eye problem.
Died.
My lord, already died.
You have stated
After
suffering with his eye problem.
Filing this pending disposal of this application, advocate on record died.
We find that sufficient reason for the absence of the appellant on the relevant date has been made out. Full stop. Accordingly, can 5 of 2023 is allowed, thereby recalling the order dated November 12, 2024, whereby FMA 146 of 2023 as well as can 4 of 2023 had been dismissed for default and restoring the said application and application to their original file and number. Was there any interim order at that stage?
No.
Full stop. Next para, since there was no interim order subsisting as on that date as apprised by learned counsel for the appellant, comma, there is no scope of revival of any interim order. Appeal is otherwise ready for hearing. Who is appealing for the other side? Service has been
I am
effected.
appearing in change brief. One can application is also pending for production of a minor child. Otherwise, matter is ready.
Can application, that is, what is the can number?
Can number 4.
4.
4.
4 is an application for adding subsequent events.
No, my lord. This one.
And the prayer is
My lord, can number.
to place subsequent events analogously with impugned judgment, whatever that means.
Kindly appreciate, my lord. Earlier can number 4752 of 18. Now there has to be renumbered, my lord. That
No,
will
no,
be
can
renumbered.
4 is a new application.
Yes, my lord.
You please check up the records. What
Sir,
are
I
the
have already
pending
checked up.
applications?
This application is pending, my lord. For
Can
production.
4 also is there. What are can 1, 2, and 3? We don't know. 5 you have allowed.
That has already been disposed of. Only 4 is pending.
4 is not for any production of child or anything like that. এটা দিন তো নাকি উফ, নিজের মামলা নিজে জানে না। Please check, go through this. This is 4. ফালতু টাইম ওয়েস্ট এগুলো। এক গাদা অ্যাপ্লিকেশন পেন্ডিং রয়েছে এইসব করে টাইম।
Sorry.
You're wasting time of court unnecessarily.
Extremely
So
sorry.
many applications, so many appeals are pending. You are every day mentioning matters
Only one
and you're
application.
wasting time like this. You don't know what is your matter.
Can number 4. 4 is pending, my lord.
So what is 4? We don't understand 4.
4 regarding, my lord, I have been denied to meet with the minor child. That has been directed.
Is that what you read from this? This is 4.
No. This,
Can't you read English?
my lord, in my application.
Your application, throw it out in the dustbin. Look at our application. This is can 4. Can't you understand basic English? আরেকবার দিন ওনাকে। দিন এটা। Can't you see the number can 4? Have you gone out of your mind? First see the number, read out the number so that everybody in the courtroom can hear.
Can number 4 of 2020.
What is the prayer?
My lord.
Production of child. Gone out of your mind. We are handing you over the court's copy of can 4 and are reading something else.
That is otherwise. Sorry, my lord.
What is this? Read out the prayer so that everybody, even the clerks, can hear. Read out the prayer.
Your petitioner therefore prays that your lordship may graciously please to grant liberty to the petitioner to place the subsequent events analogously with the impugned judgment on the cause stated herein above or to pass such other.
And what were you saying? We have handed you over the court's copy. You are looking into your copy, whatever that means.
Sorry, my lord. Extremely, I beg apology, my lord. I beg apology, my lord.
So how you don't even know that such an application is pending, this application?
Then, my lord, I have to further inspect the entire case record. Kindly allow me.
যেটা বললাম, যে অর্ডারটা বললাম করে দাও, আর কিছু না, এবার লিস্টের বাইরে পাঠিয়ে দাও। হয়ে গেছে, ক্যান ওয়ান্টটা ডিসপোজ অফ হয়ে গেছে। আচ্ছা, লিস্ট না, এটা দিয়ে দাও অর্ডার।
My lord, liberty may be given
Can
to
4 of such and such be listed in the monthly list of August 2025?
and deeply obliged, my lord.
Don't be so deeply obliged. We have directed it to appear in the monthly list of August. You will get sufficient time to apprise yourself of whatever application is pending, and have 6 conferences in the meantime also. Next. 15 to 7.
15, 16, and 17, my lord, this matter.
Yes.
Where Mr. Shaktikant Mukherjee was appearing virtually, my lord.
Yes,
I'm
yes.
also appearing now.
Yes, Mr. Mukherjee, we can see you.
My lord, twice in the past, I have taken adjournment.
Yes,
along
you are
with
the
the-
respondent.
I am the appellant in the item number 17 in the respondent. This is an appeal from a partition suit, my lord. So I am appearing for one set of parties, my lord. Appellant in item number
You are
17.
supporting Mr. Mukherjee's client.
My lord, I am praying for
Opposite.
adjournment. There is no question of argument, my lord. All are together praying for adjournment.
Adjournment?
Settlement
You will
talk
see the
is
last
going
order,
on.
my lord. Talks of settlement were going on.
Still going on?
Because of the summer vacation, my lord.
Summer vacation, how does it affect this?
We said we are required to sit again with him, my lord.
Very well. Learned counsel for the appearing parties submit that the talks of settlement are still going on, full stop. Accordingly, let the matters go out of the list for the present, with liberty to the parties to mention for inclusion in the list as and when such talks of settlement either fructify or fail.
Lord, you will kindly give a date, my lord. Will kindly give a date, not
No.
an open-ended.
No, Mr. Mitra. We don't know. It's pending for so long. So we first settle the matter. If you can't settle, we have said either it settled or failed. Yes. For the present, it goes out of the list. Thank you, Mr. Mukherjee. Yes.
Thank
Next.
you, my lord.
18. Yes, Mr. Banerjee.
My appeal, direction was given to file affidavit in opposition to the stay, and my reply
Achha, no vakalatnama has been received by the department.
from our end, my lord.
Yes. Appeal could not be accepted unless there was a vakalatnama.
No, your lordships have been pleased to grant
Because
a-
you just check up this 13th of June report.
I will look it up, my lord.
The notices of appeal has been duly served, issued on the respondent numbers 2 and 2,
Yes.
but till date no service return, no question of service return. Further submitted that no vakalatnama has yet been received by this department till date. If you have filed, please ask your clerk to just furnish the
particulars. I'll look it up.
particulars, the date and the.
I'll check it up, my lord. I'll look that up. But now they have filed the affidavit in opposition. They have filed it within time. They were supposed to. They filed it on.
You are the
22nd.
appellant.
I am the appellant.
Oh, then they have not filed.
They have not filed their vakalat. That's what I was thinking.
What can be done? We'll proceed expertly then.
They filed, my lord, I am out of time with my reply.
The appellant said that is not an issue.
No, I'll just pray for 5 days time. My lord.
Oh, still you have not prepared.
Still not prepared. It's come on the 22nd.
Opposition has not been filed as yet.
They have not filed.
They have given you a copy,
they've
not
given me
filed.
an advance copy. So simplicity, your lordship keeps it after a week. Not in the meantime, I'll just.
Precisely.
And then I-
None appears for the respondents. Full stop. It transpires from the office report dated June 13, 2025 that despite notice of appeal having been issued on the respondent numbers 1 and 2, comma, there has been no service return till date, comma, nor has any vakalatnama been filed on behalf of the said respondents. Full stop. Next para. They appeared on the previous occasion, Master.
No, my lord.
Oh, they did not appear.
No, they did not appear.
Who has given you a copy of the affidavit in opposition? Some advocate, Master.
Yes, yes. My lord, Kaustav Chandra Das.
However, learned counsel appearing for the appellant submits that a copy of an affidavit in opposition has been handed over to the appellant's advocate by one Mr. Kaustav Chandra Das, learned advocate, having instruction to appear for the respondents. Full stop. Mr. Das is requested to file his vakalatnama in the department at the earliest on behalf of the respondents. Full stop. The matter stands adjourned till 1 week
2 weeks.
2 weeks. Till June 30, 2025, full stop. The time for filing affidavit in opposition is extended till June 20, 2025. Full stop. Reply, if any, shall be filed by the next returnable date.
Very great. No, my affidavit of service be kept on record. I moved it.
Acha,
expired.
affidavit of service filed today be kept on record.
দুটো কেন?
If they don't appear, we'll proceed on the premise of this expertise. Affidavit of service says they have been served otherwise.
Yeah, আমি check করে নি, করেছো তো? Yes, yes. That's why they filed the affidavit.
No, need not be, may not have been served, but anyway.
I understand.
Yes.
Yes, but
Yes.
19 I appear for the appellant. But this is a suit arising out my appeal arising.
You are enjoying a status quo order.
My lord.
What about service?
Service, my lord, the principal defendant has been served, my lord. The pro forma could not be served.
You are seeking injunction only against the principal defendant.
Principal, because pro forma, my lord, is my lord the person who my lord intended to purchase the property or who was making attempted to
What is
make
the fate of the service on the pro forma respondent?
My lord, it has come back to me, my lord. Packet has
Intimation served, that is good service.
packet has
Affidavit of service filed today, we will make the injunction absolute. The affidavit of service filed today in court be kept on record. First of all, although good service has been effected on the respondent number 1, comma, the respondent number, insofar as the respondent number 2 is concerned, sorry, insofar as the pro forma respondent number 2 is concerned, comma, although the postal authorities served intimation, comma, the said pro forma respondent did not contact the postal authorities, comma, which is evident from the track report furnished along with the affidavit of service. Full stop. Accordingly, we deem that good service has been effected on both the respondents. Full stop. Can 1 of 2025 is an application arising out of the out of an order refusing grant of ad interim injunction to the plaintiff appellant in a suit for partition. Full stop. As recorded in the order dated May 22, 2025 at the ad interim stage, comma, the impugned order suffers from prima facie suffers from illegality, comma, since it was rendered merely by quoting a judgment and observing that there is a delay of about 1 month from the first notice of infraction of the plaintiff's right in approaching the case, comma, by overlooking the settled principle of law that in suits in the nature of a partition suit, comma, the endeavor of the court would be to maintain the property in statu quo during pendency of the suit. Full stop. Since no change of circumstances have been brought to our notice since the grant of ad interim order of injunction, comma, nor are the respondents represented through counsel, comma, we intend to make the said ad interim order absolute. Full stop. Accordingly, can 1 of 2025 is allowed, thereby restraining the defendant stroke respondent number 1 and pro forma defendant stroke respondent number 2 and stroke or their men and agents from changing the nature and character of the suit property and or creating any third party interest in respect of the same in any manner till disposal of the appeal. Full stop. The appellant shall put in postal costs and due requisites for service of notice of the appeal on the respondents within a week from date. The trial court record shall be brought by special messenger. This is a partition suit.
partition suit.
Trial court records you are dispensing with, you have all the copies. Trial court records are darkar nahi. In view of the short conspectus of the appeal, comma, calling for the trial court records is hereby dispensed with. Full stop. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from date by incorporating all the relevant documents. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
On behalf of the petitioner.
My lord, Mr. Apurva Kumar Datta could not come today.
Please use the microphone, ma'am. Miss sir.
My lord, Mr. Apurva Kumar Datta could not come today because of medical emergency at home. So if you can please accommodate.
You are enjoying an interim order.
Yes, my lord, your lordship was pleased to hold that there's a primary case.
So you have granted injunction disposal of the application or what?
Yes, my lord, your lordship directed the matter to appear of
Disposal of the application. So we'll grant the adjournment. Till when?
My lord, only for today.
Only for today.
Only for today.
On the prayer of the respondents, the matter is adjourned for the day.
May I file my affidavit, sir?
Affidavit of service filed today be kept on record. Please give your name only for the respondent, not his name.
Grateful.
And Mr. Ghosh, all of your names. Yes.
Item number 21.
21, my lord, I am for the appellant, my lord.
Appellant, right.
My lord,
For the
two
first time?
For the first time, my lord, two applications, one under section 5, another, my lord, for injunction. My lord, let me serve and come back, my lord, everything, my lord, including the, my lord, the memo.
The appellants shall serve copies of Can 1 of 2025 as well as Can 2 of 2025 on the respondents, indicating that the applications shall be listed on July 9, 2025 under the same heading, when an affidavit of service shall be filed to that effect by the appellants.
Grateful.
My lord, 22, I appear for the respondent.
Yes.
This matter, Lordship, I am appearing for the Lordship, appellant Lordship led by Mr. Parthopratim Rai. What happened, Lordship, in a specific performance of suit?
You are appearing for both the respondents.
I am appearing for both the respondents.
Why that expression? You want to pray for
My
something?
lord, expression is there because on 22nd of May, your lordship had extended the interim order till 30th of June.
Oh.
My lord, only one thing, my lord, I was not there on the last occasion. My lord, while going through the orders passed by the learned trial court, after the order which was passed by my lord Justice Harish Tandon, wherein they have first came before this honorable court challenging the order of refusal of an ad interim order, my lord, your lordship kindly comes to the order of Justice Harish Tandon once. My lord, I know I do not have that much of a strong case, but still I'll try my best to persuade your lordship to this extent
Justice
only.
Tandon's order at page 19.
Yes. My lord, kindly sees the order which says, well, there is a fivefold direction given and the order was passed in presence of both the parties. The first direction was that we are restrained from transferring the property for a period of 4 months. Second is that, my lord, within 2 weeks, I was required to file my written objection. Third is that, my lord, that within a month from the date of filing of the written objection, my lord, the learned trial judge needs to dispose of the matter. Their ad interim injunction prayer.
There may
my lord, not to refuse adjournment, no, to give a not to refuse adjournment and to prepone the date. That was fivefold directions. What they did, my lord, within 2 weeks' time, my lord, I duly filed my written objection on the very date we filed.
But why are these relevant now? Now the injunction
Relevant,
application
my lord,
itself has been
because of
decided.
the conduct.
Yeah.
Because of the conduct, my lord, kindly sees. My lord, they have filed 2 applications thereafter under Order 1 Rule 10 as well as Order 6 Rule 17. And my lord, the interim order which my lord Justice Tandon had given, that was for 4 months. That expired on 15th of May.
At the final hearing of the injunction application, those become
My lord, 13th of May, for the first time they come up with an extension prayer without, my lord, getting, my lord, any effort to make the matter heard. That is my prayer, my lord. Even if, my lord, your lordship has directed it and extended it till 30th of June. Only I am praying one thing, my lord. If, my lord, your lordship directs the learned trial judge to dispose of the matter within that date. My lord, today now we are on 17th, your lordship.
So they have challenged in this appeal. They have challenged what?
They have
temporary injunction.
No, they have filed an extension application.
That was
2 days before. The learned trial judge said whether I have the power to extend.
All right.
Wherein the original order of the Honorable High Court do not.
You are right, because no use keeping the appeal pending here.
No use.
Unnecessary advantage.
Yes. No use keeping the appeal pending here. Your lordship kindly.
So we'll record your submission on their conduct that they were instrumental in delaying the hearing.
Yes, my lord. They repeatedly filed separate applications, and my lord persuaded the learned trial judge to hear out those applications first, even if it is recorded in their prayer that you kindly dispose of my Order 1 Rule 10 application, and then only you grant a order of status quo injunction on my interim injunction prayer.
So what was an Order 1 Rule 10 is still pending? Order 1 Rule 10 is still pending.
Yes, those are all pending. Order 1 Rule 10, Order 6 Rule 17.
Those are your applications.
No, those are their application. Their application.
But unless injunction is taken up first, I mean.
My lord, yes, I am also saying that, my lord, the injunction application should be disposed of.
They insisted that those applications.
Yes, should be taken up first.
But those were not taken up first.
Those were taken up first. That is why it
not decided.
Not this interim injunction application. So it was their conduct, my lord, deliberate conduct to delay and not to get the matter heard.
Yes, what do you say?
Now, lordship, kindly consider, lordship, paragraph 4, lordship, of the lordship Justice Tandon's order, lordship.
Yes.
During course of the hearing, lordship, the respondent informed the court that part of the property has been sold by them.
Oh.
During pendency of the suit. So, lordship, there was a direction for
to file a addition of party application before the learned trial court, but no lordship copy of the deed was handed over to us, lordship, on behalf of the lordship respondent.
Now that order 1 rule 10 is there.
Order 1 rule 10 is lordship pending, and last 3 occasions they are not appearing before the learned trial court. So cause has been lordship issued. The application is running ex parte, lordship.
Then,
my lord, I am beseeching only one thing, my lord, because the order
did not appear on the last.
No, because the learned trial judge kindly sees, my lord, have directed that order 1, those dates were fixed for hearing of their application under order 1.
So it did not appear.
My lord, kindly sees, my lord, this. Ekটু দেবেন judge sir. দুটো copy.
This is one order. What about the other orders?
The other orders are all there, my lord.
You have selected the orders where you appeared.
No. I am replacing those orders.
Is it correct or not to say that you did not appear on the last 3 occasions?
My lord, on the last occasion I did not appear. It is recorded in the order as well.
It balances out.
My lord, only one thing, my lord. Your lordship had extended it till 30th of June. I am not pursuing anything else.
We are extending it till the disposal of the injunction application.
My lord, kindly do not do that, my lord. They will not let the injunction application heard
Again, this same procedure will be repeated.
My lord, kindly, your lordship, my lord, directs the learned trial judge
Mr. Shanal, what is the
hear out
difficulty?
the
Mr. Rai, what is the difficulty if the injunction application is disposed of first, then your order 1 rule 10 and the other?
Order 1.
Again, another order injunction application.
They have a point there,
Because
Mr. Mondal, because unless that is allowed, this injunction will not extend to the added parties. Another injunction application will be filed, and the suit will be
the entire proceedings.
Have you filed your objection to that order 1 rule 10 and
Expert, it is posted for expert hearing.
My lord, kindly seize this.
What is this?
My lord, this is their order 1 rule 10 application wherein they themselves have asked for a status quo injunction. In the application for order 1 rule 10.
That is entirely different.
And my lord,
we are not hearing that.
And they also prayed that order 1 rule 10 should be heard out first and then
that is the proper method. Mr. Rai is right on that, because what is your answer to this? Because
only
suppose somebody is added, if that is refusal,
you're absolutely, your lordship is
again the another
the suit will be delayed. Though my lord, we have not come here on merit,
and you have not filed your objection to the order 1 rule 10 and the section order 6 rule 17.
No, we have not filed.
File your objection.
I'll file your lordship.
File within a week from date.
Yes, we will do that.
To both the applications.
Yes,
we'll direct those to be decided within a fortnight, within 3 weeks thereafter. Trial courts are human beings.
I
so within 3 weeks there, you will file your written objection to both those injunction. You have filed a written objection.
Yes.
To both those applications within a week.
Right.
Within 3 weeks from that, those applications will be decided.
Right.
Within a week after that, the injunction will be decided.
Obliged. Yes. My lord, we also do not have any objection to order 1 rule 10. Let the parties be added.
Then we can record that and
yes, we can do that.
Very well.
Instruction reaches though. Yes. Upon instruction, my lord, I am submitting. It's admitted that, my lord, if you go to the merit, you will find out, my lord, what a case has been made out. I must tell, my lord.
No, regarding the order 6 rule 17,
5 crores of land.
Order 6 rule 17, Mr. Mondal, is also consequential. Are you considering to that also?
Order 6 rule, no. My lord, only order 1
rule. Order 1 rule.
Yes.
Very well. So 617, whatever you said will apply?
Yes.
On consent of parties, both the appeal and the application are taken up for hearing together. First of next para, learned counsel appearing for the respondent submits that due to the dilatory tactics of the appellants, the injunction application pending in the trial court is being protracted. First of learned counsel submits that in order to dilate the proceedings, the appellants have taken out an application under order 1 rule 10 of the Code of Civil Procedure for addition of parties, and also an application for amendment of the plaint under order 6 rule 17 of the Code of Civil Procedure. First up, due to the pendency of those, the injunction application cannot be disposed of, despite the directions passed by a coordinate bench on January 16, 2025 in FMA 852 of 2024 at the ad interim stage. First of next para, learned counsel appearing for the appellant submits that unless the applications for addition of party and amendment of plaint are taken up for hearing first, there will be an unnecessary multiplicity of proceedings, since, in the event those applications are allowed and the proposed added parties are implemented, injunction will have to be sought afresh against them. First up, next para, it is further submitted that on several occasions, the respondents themselves have also asked for adjournments. Full stop. We also find upon hearing learned counsel that the respondents have not yet filed written objection either to the addition of party application or to the amendment application. So next para. At this stage, comma, learned counsel appearing for the respondents, comma, on instruction, comma, submits that the respondents do not have any objection to the order application under Order 1, Rule 10 of the Code of Civil Procedure to be allowed in the trial court. Full stop. Next para. As such, comma, they do not intend to use any objection thereto. Full stop. However, comma, the respondents assured this court that they shall file written objection to the amendment application in the trial court within a week from date. Full stop. Next para. Keeping in view such fair submission on behalf of the respondents, comma, and considering the scope of the pending applications in the trial court, comma, we are of the view that unless the amendment application is taken up for disposal earlier than the injunction application, comma, there may be unnecessary multiplicity of proceedings, comma, since amendments consequential to the addition of party might be introduced by the court in the event the amendment application is allowed, comma, in which event the injunction will have to be extended to the added party as well. Full stop. Next para. Otherwise, comma, we find that a strong prima facie case has been made out for grant of injunction, comma, particularly since ad interim injunction was granted by different courts, different benches of this court at different points of time. Full stop. Accordingly, FMAT 194 of 2025 along with Can 1 of 2025 are allowed, comma, thereby setting aside the impugned order and granting injunction restraining the respondents, defendants stroke respondents and or their men and agents from transferring, alienating and or encumbering the portion of from further transferring, comma, alienating and stroke or encumbering the suit property in favor of third parties till disposal of the temporary injunction and application pending in the court below. Full stop. Next para. The respondents shall file their written objection to the amendment application filed by the appellants in the trial court within a week from date. Full stop. Subject to the filing of such written objection, comma, the learned trial judge shall dispose of the amendment application within a fortnight thereafter and shall proceed to dispose of the injunction application within a week subsequent to the disposal of the amendment application. Full stop. Next para. Insofar as the application under Order 1, Rule 10 of the Code of Civil Procedure filed by the plaintiff stroke appellants in the court below is concerned, comma, in view of the concession given by the defendants respondents in this court, comma, the said application stands allowed, comma, thereby directing the parties sought to be added to be impleaded as party defendants in the suit. Full stop. Necessary consequential corrections. Now, the appellant shall take steps for.
I have to file an amended plaint within a week. I'll file this.
The appellant shall file an amended plaint, comma, incorporating the name of the added parties within a week from date. Full stop. Next para. It is made clear that the above observations shall not affect the merits of the amendment application and or the injunction application pending in the trial court, and the learned trial judge shall be at liberty to independently decide both the said applications on their own merits upon giving opportunity of hearing to the parties, comma, however, comma, adhering to the timelines as stipulated herein. Full stop. No orders to cause urgent certified copies.
Deeply obliged.
Appeal it a judgment.
I went to court room on 16. Just running there.
16.
16 then.
16 who is sitting?
Your lordship.
Oh, you were going to. We were also almost going to 16.
After that, I realized that.
Yes.
Grateful, dear lordship.
Court 16 was a much larger court.
Smaller judge, smaller court.
No,
Yes.
never.
Next one.
Diplomacy.
23 is appeal.
My lord, I am
Yes.
appearing, my lord.
Please take the microphone a bit.
My lord, yes, my lord. My lord, your lordship asked me to serve to the other side, my lord, but it has returned, my lord,
With what endorsement?
with insufficient address.
Then you have to ascertain the address and serve again. What is the application for?
So like this application, my lord, there is one condemnation of delay and one,
Condonation of delay, you have to serve on.
there is a lot of days, my lord. 960 days, my lord.
Serve again.
Yes, my lord.
The affidavit of service filed today be kept on record. First of it transpires from the envelope which has returned, comma, that the address of the respondent as given therein was insufficient. Full stop. The appellant shall ascertain the full current address of the respondent and serve a copy of the stay application afresh on the respondent at the said current address. Full stop. The leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the cause title of the stay application as well as the memorandum of appeal incorporating the full current address of the respondent.
But there is no mistake, my lord. My lord, there is no mistake. The respondent has filed the petition for divorce in the same address. And in on objection also, he has filed this with same address in affidavit portion. We have find that the same address is there. Your post office is somehow doing some mistake, my lord. The same, my lord, your in stay application, your lordship will find that the respondent has filed the petition.
এখানে বললাম যে full stop করে দাও. The learned advocate for the appellant shall apprise the court as to the outcome of such inquiry on the returnable date. Full stop, let the matter be listed under the same heading on June 24, 2025. Ma'am, we are keeping it on 24th June, 1 week after. Hence, you try to ascertain if there is a change of address in the meantime. If there is a change,
Serve again, my lord.
we have directed you,
Yes, my
but
lord.
try to
Sir, but the same result will be the same.
You don't understand us. Let us complete. You will ascertain whether you can find out a new address. If you can't find out, we have kept it on 24th. Come back on that date, remind us of our direction, and say that you have ascertained that they are in the same address, and then point out to us that it was they contested in the court below. All these things will then pass appropriate directions, deeming this to be proper service. But please try to ascertain whether actually they have changed address or the address should be fuller. Ascertain that in the meantime. Why not undertake that exercise? The direction remains. Come back on 24th and apprise us if
That
you.
direction I will not follow just now.
Then don't follow. Regarding the sending, don't follow. But if you find out that they have a different address, then follow.
I will come back on 24th. Thereafter, your lordship will pass the necessary order.
But don't sit tight. Ask your client to
Yes, my lord.
ascertain all the same whether there is a different address. इलेक्ट्रॉनिक मोड काफी है ये सब सही इलेक्ट्रॉनिक मोड फॉर ग्रामीण Huh? Yes.
Please, Your Lordship.
Yeah.
My appeal.
And for the respondent.
Yes,
It is
yes.
Section 5, my lord, also.
What is the delay?
The delay, my lord, as per the application is 7 days.
But
by my calculation, it should be, I think, 4 or 5 days. If Your Lordship excludes the time, my lord, taken to, my lord, obtain the certificate.
what is the reason?
The reason is, well, there was some confusion as to the period of limitation that would apply.
Yes, what do you
This is
say?
From City Civil.
For this, I can.
Upon hearing learned counsel for the parties, comma, we find sufficient cause for the delay having been made out. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in filing FMET 490 of 2024. Full stop. We will take up the appeal for order for 1011 right now. Are you ready?
As Your Lordship, please.
Then we'll take up, right? Why waste time?
Right.
We take up the appeal for hearing under order for 1011 of the Code of Civil Procedure. Yes, what is the appeal?
My lord, the suit is one for specific performance of a
So
removal.
why miscellaneous appeal? Remand order?
No, my lord, the suit has been decreed against me. I
Why
am the
miscellaneous?
plaintiff. Not miscellaneous, it was corrected.
Oh,
It was initially numbered FMET, subsequently, my lord.
then we'll take up the
Yes, my lord.
other can.
Yes, well,
The
the application is my lord,
admission.
for injunction. My lord,
Sorry, please continue. You are continuing for the
Yes.
purpose of the stay we are hearing.
Yes, my lord, suit is for my lord, specific performance of a renewal clause in a lease agreement. It's a registered lease deed, my lord, for 5 years.
You filed the suit.
I filed the suit. My lord, Life Insurance Corporation is the owner of the property. Now, my lord, original term of the lease was, my lord, for 5 years, 1994 to 1999. The clause is, my lord, within 1 month prior to the date of expiry, I have to apply for renewal. Parties, my lord, will negotiate fresh terms, but, my lord, the rate of increment of rent should not be less than 35%.
But an option is left to them.
Absolutely.
How can you get
Well,
it specifically
Now, my lord,
enforced?
the option was exercised. They accepted, my lord, they sent me an offer note stipulating, my lord, the term, the rate, everything. They sent me a pro forma of the lease deed to be executed for the next term. I signed, executed it, sent it back to them. At that stage, my lord, they say that we need to conduct a measurement of the property and the rate of rent, my lord, will stand increase dependent on the measurement. Now at ₹3 per square feet.
So there was no consensus at IDEM at any point of time. Where was the concluded contract?
Well, the concluded contract, well, I have signed well, the pro forma and sent it back to them. It is after that well, that they turn around and say that no.
So
these
gave
are-
that offer, you accepted, and then
Yes.
then that is your case.
And now, my lord, the trial court, my lord, has framed two issues, my lord, largely. One is the issue of limitation, on which it is also held against me, saying, my lord, the date of expiry of the original lease is the starting point of my cause of action. Whereas, my lord, for at least 6 to 8 months thereafter,
Negotiation.
negotiations happened, my lord, signing of the.
You've got a better
amendment-
case on Section 5. Yes.
Yes, my lord, that was the limitation aspect.
There is some arguable issue. We'll grant stay.
Lordship, there is no.
We'll hear you. Yes.
Lordship, the stay cannot be granted in this matter, Your Lordship.
Why cannot be granted?
Because, Your Lordship, they are totally unauthorized occupant, Your Lordship. This matter has to be decided.
No, no.
because
Stay is in respect of the specific performance. You are sorry. We are wrong. Yes, your suit has been dismissed.
It has been dismissed. They are the
Dismissal, there cannot be any stay.
Well, I was praying for an injunction because I was enjoying it for this entire
You've not
duration.
prayed for injunction.
Yes, my lord, I have. My lord, prayer B, if your lordship kindly consider.
Acha, in this very same application.
Yes, my lord. Prayer A is for stay. My lord, prayer B, I have prayed for injunction. They had, my lord, filed an
Interfering peaceful possession.
well, that was, my lord, the terms of
Right.
the injunction which was originally granted by the
Right now, you are an illegal occupant. But yes, that will depend on the outcome of the appeal.
Well, I am continuing to occupy upon payment
That is
of that modified rent. Well, I agree. Well, today it has increased several fold. I have also asked my
I will direct you to put in your affidavit in opposition. You disclose the parameters for will grant stay, but occupation charges they have to pay.
That has to be a limited period, Your Lordship, because they are the totally unauthorized occupant. And if at all, if your Lordship permits, then the occupation charges may be enhanced at the time. of
That is
granting.
what we are saying. We will grant a stay for a limited period. We will direct you to put in your affidavit in opposition. There you disclose the parameters and yardsticks in the area for fixation of occupation charges.
And at this juncture, your lordship, at the time of granting stay, let the 4,500 be enhanced
That I'm
to some
paying, that
extent.
I'm anyway paying.
They are paying 4,500.
They are paying, but we are not accepting. It has been kept in the suspense account. At this juncture, your lordship, I've got the instruction. They're not paying that also. Because in the memo of appeal, it is said that in the impugned order, it has been.
Why restrict yourself to 4,500? We will. How soon can you file your opposition?
2 weeks.
2 weeks. We'll give you 2 weeks, 1 week. We'll take up the matter after that. For the time being, let there be unconditional stay. If you restrict yourself to 4,500, it may be difficult. Since a prima facie case for hearing of the appeal on merits have been made out, comma, on the questions of limitation as to whether there was a concluded contract which was enforceable, comma, between the parties, comma, as well as the other grounds taken in the memorandum of appeal, comma, the appeal is required to be heard on merits, as such, comma, in view of the threat of eviction at present, comma, we find that the balance of convenience and inconvenience is in favor of grant of interim order of injunction as prayed for in relief small b sought in the interlocutory application. Next para, learned counsel for the respondent LIC submits that the appellants are at present illegal occupants of the suit premises. Although initially meager amount of rupees 4,500 per month was being paid, comma, the appellants have stopped making such payments now. Moreover, comma, it is submitted that there are no merits in the appeal. However, comma, since an arguable case has been made out, comma, we are of the opinion that the interim or injunction as sought by the appellant should be imposed, subject, comma, however, comma, to appropriate occupation charges being paid by the appellants to the respondent. The respondent shall file its affidavit in opposition, comma, inter alia disclosing the relevant parameters stroke documents for the purpose of ascertaining the correct market occupation charges payable in the area in question. Reply, if any, shall be filed within a week thereafter. The application shall be listed on July 14, 2025 for hearing. There shall be the respondent and its men and agents shall remain restrained by an order of injunction from interfering with the peaceful enjoyment and possession of the petitioner in respect of the suit property till August 14, 2025 or until further order, whichever is earlier. We are making it limited so that.
I'm grateful. May I file the affidavit of service?
Yes. Prothame affidavit of service shall to be kept on.
Yes.
Thank you.
I am for the opposite party.
Opposite party, yes. Yes, Mr. Das, what is your matter? You are appearing for both the respondents, Mr. Bhattacharya? Yes.
Application, my lord, under section 5 of the Limitation Act.
What is the delay?
Delay is 1677.
1677. Explanation?
Explanation given, my lord, that initially the erstwhile advocate, Mr.
Take the microphone a bit closer, Mr.
Mr. Gopal Chandra Ghosh was appearing, my lord.
Take it upwards, the microphone.
Mr. Gopal Chandra Ghosh, my lord, is appearing on our earlier occasion. My lord, he filed by mistake, my lord, a revisional application. But the order impugned should be fast appeal. And the matter in the year 2000.
What is the order impugned?
Order impugned, my lord, an application, allowing an application under Order 7, Rule 11. In an application.
When was the revisional application dismissed?
My lord, I have, this is the supplementary affidavit.
Was it dismissed by the court holding not maintainable?
My lord.
Initially, the motion was admitted.
Motion was not admitted. Matter was pending.
It was pending at the motion stage. When was it dismissed?
My lord, this is the order, my lord. On last occasion, your lordship directed me to file this supplementary affidavit. I am given.
Obviously, I have not served a copy on him.
I have not received mine.
If you have served a copy, that will be an exception, we say. You're serving now.
No.
How is he supposed to come prepared?
Well, he was there. He was there.
Do you remember every matter where you appeared? You have phenomenal memory, Mr. Das.
No, I have to read, I have to see. The explanation has been given in paragraph number 8, my lord. Family problem.
For which, my lord, it is the only delay.
No, no.
Yes, family. Can you see?
What can
Family
you see,
problem of the
my
ad-
supplementary
Yes,
is
sir,
fast.
as well as the problem in the family.
Where is
Family
it?
problem, my lord. What type of family problem?
Which page? No, also fever and stomach upset.
No, no. Kindly see the supplementary affidavit, my lord.
Page 4, para 4, fever and stomach upset of the advocate for 1677 days.
Yes.
Matter was dismissed as not maintainable by Honorable Mr. Justice Ajay Kumar Mukherjee.
You go through the supplementary affidavit. Come back tomorrow. Come back tomorrow. Sir. Supplementary, this is the size of the supplementary. He has only annexed the order. You can do it right now. No statement made, no paragraph. Yes, Mr. Das, what is your explanation in this state? Show us from the section 5 your explanation.
But kindly see para 4, 5, and 6.
4, read out 4.
That states that on 10/8/23, when the matter was taken up for hearing, the present.
No, para 4 of the section 5.
Yes.
You're reading some other paragraph.
No. Para 7, your lordship will see. That is that the case was restored by an order.
Why did you put in there the stomach upset and fever?
Because on 10th August 23, my lord, I was engaged, but I could not appear. Thereafter, I filed an application for restoration that has been allowed. Now, when the matter was taken up for final hearing, Honorable Mr. Justice Ajay Kumar Mukherjee held that it is not maintainable. You take back the certificate copy and prefer an appeal. That is the last order of the order passed by his lordship. Last order.
Yes, Mr. Bhattacharya, by occupation cultivation.
Very poor person.
No cost. No cost.
My lord,
No cost. He has become poorer after coming to you, or he was poor beforehand?
Really poor person. But his mother.
Yes, Mr. Bhattacharya.
His father left him at the age of.
Yeah, no, locus standard to file that.
Poverty is his locus
If
standard.
your lordship
Not
goes
the
to
son.
history. No, the lordship goes to the history.
What is the suit for? What was the suit for?
Suit for revocation of probate.
Why rejected? Plaintiff rejected?
Plaintiff rejected on the ground that is barred by limitation. But there are subsequent judgment I will show before my lord that
it's an arguable question, Mr.
that
Bhattacharya. If it's only on the ground of limitation,
even our High Court, Honorable High Court has said
it's
that
arguable. It's arguable to say the least, and at the order 7 rule 11 stage, more arguable.
Yes.
The supplementary affidavit filed today in court be kept on record. Full stop. Next para. It transpires that initially, upon bona fide error, upon bona fide error in legal advice, a civil divisional application under Article 2, a civil divisional corona, an application under Article 227 of the Constitution was preferred against the impugned judgment and decree, whereby the plaint of the revocation case of the present appellant was rejected. Sorry. Full stop. Next para. After the dismissal of the said revisional application, the appellant contacted a different learned advocate and the present appeal was filed. Full stop. Upon hearing learned counsel for the parties and keeping in view the fact that the petitioner is a cultivator by occupation, and it is credible that the petitioner might not be aware of the legal nuances and or financially well off, we are of the opinion that a lenient view ought to be taken. Full stop. Next para. Moreover, an ingredient of section 14 of the Limitation Act can be read into the facts of the case. Full stop. As such, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring the appeal. Full stop. Yes, any stay application or
application for stay appeal may be placed for hearing.
Not filed, my lord. Still not filed.
So we'll direct you to put in you are for both the respondents. In view of the appearance of both the respondents to their learned advocate, service of notice of the appeal on the respondents is dispensed with. The trial court records were dispensed with only plaintiff.
An order.
And those things you will annex in your paper. Since the appeal arises out of the rejection of a plaintiff, we dispense with calling for the trial court records. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks from date, and serve a copy thereof to the learned advocate for the respondents. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing, full stop. In view of the above directions, comma, the appeal be treated to be ready as regards service and arrival of the trial court records.
Service.
Next. Copies have been served, Mr. Mitra?
My lord, I understand. I really could not check it, my lord. I understand, my lord.
Mr. Singh must have checked.
Yes.
1 to 5 and 11, 12, sir.
1 to 5 and 11, 12 and 13 have been served, but my lord,
Your injunction has been sought against only 1 to 11.
yes, 1 to 11.
This is against what, Mr. Mitra? Can you please remind us?
I'll tell you, lordship, my lord. A suit for declaration and injunction was filed saying that, my lord, the plaintiff is, my lord, owner of a portion of a property, and my lord, the defendants or those defendants were trying to interfere with my possession. Now, in that suit, my lord, the suit was filed in 2017, if I remember it correctly.
Yes.
15.
15, yes.
15. Now, my lord, in that an order of injunction was passed on 9th of July 2015. Now, the contesting defendants, they appeared, did not contest that application. The interim order was confirmed on 14th of February 2020. Thereafter, the suit came up for, my lord, ex parte hearing and the suit was dismissed. And I can show you, lordships, the decree or, my lord, the
Dismissed. Why? Because you failed to prove your case. What was the reasoning? The primary reasoning. You failed to produce any title deed or something like that.
On careful perusal of the unchallenged testimony and uncontroverted testimony, I observed that there is no specific demarcation of partition of the property under possession of the plaintiff. The partition deed, which is the key route of the plaintiff to seek decree of declaration of title and does not include the entire property, etc. Now, my lord,
we are making the injunction application absolute and we'll direct you to put in special.
Absolute, yes.
Yes, we are disposing of the injunction. Affidavit of service you have to file.
Yes. Arekta copy though.
Division bench appeal. Intimation served.
The defendant numbers 1 to 11 they contested together.
No.
1 to 7.
Oh.
1 to 7 contested, my lord, together.
And then others did not.
The others did not.
1 to 4 filed one written statement, 6 and 7 filed another written statement. Yeah.
Yes. 1 to 7 contested.
1 to 7 contested. The others did not contest.
No. 5 correct.
Actually correct.
Did not contest the suit. Have you taken instruction? The others did not contest the suit.
No. They did.
Affidavit of service filed to be kept on record. Full stop. We find that substantial service has been effected on the respondent numbers 1 to 7 who contested the suit together in the court.
1 to 5, my lord.
And 12, sir.
6, 7, my lord.
Item on hold.
Item on hold.
Addressee cannot be such person.
Addressee could not be located.
No, the 1 to 7 contested together in the court by a single written statement.
1 to 4 filed one written statement.
1 to 4, my lord, they had filed one, my lord, written
1 to 4 you have already served.
Yes.
6 and 7.
6 and 7 had.
Have you served either of them in this application?
Yes, 1 to 4 have been served.
No, 6 and 7?
6 and 7 also it's come back.
No, 6 and 7 have come back, my lord.
Neither has been served. So then you have to serve again on them at least. We'll dismiss your service on the others.
Well.
কি বললাম? No. 1 to 4, 1 to 5 who contested the suit together. Full stop. Respondent number 6 and 7 also contested the suit, but proper service has not been effected on them. Full stop. Next para. Insofar as the other respondents are concerned, comma, since they did not contest the suit in the trial court, comma, we dispense with further service on the said respondents. Full stop. However, comma, the appellant shall effect fresh service of the application on respondent number 6 and 7, indicating that the application shall be listed for hearing next in the monthly list of July 2025 and file a fresh affidavit of service on the returnable date. Injunction is already there till disposal of the application. So,
Yes.
yes.
এটাকে আজকেই পাঠিয়ে দাও বেশ পাঠাও
Acha, can you serve on their advocate also?
6 and 7 to
6 and 7, 6 and 7. আচ্ছা তাহলে যেখানটা বললাম shall serve afresh on the respondent number 6 and 7, comma, directly and stroke or through their learned advocate who appeared in the court below. Only 6 and 7.
My lord, I am appearing on behalf of the appellant.
Yes.
The
About service.
last order was being served to
Proper
the
service has been effected on
yes,
both.
my lord,
On all.
or to both the addresses of the respondent. The respondent is a resident of Sharjah. To Sharjah address also and to Koshba address also. It has been
Sharjah.
Sharjah.
He has received at Prinsep. Prinsep Khatas. Oh, acha, acha. Delivered, yes.
Yes.
What is the appeal arising out of?
The appeal is the suit was for specific performance, and this appeal is against an order wherein basically the order was passed overlooking substantial evidence presented by the
What was
appellant.
done by the order? Injunction, you are the plaintiff there.
Yes, we are the appellant.
In this suit, you are the plaintiff.
The plaintiff.
Why was the injunction refused?
The plaintiff, the plaintiff was basically a tenant in respect of a property which was owned by the respondent. So there was an agreement for sale.
No, why was you have challenged an ad interim order in the appeal, or main injunction application was dismissed?
It
Both
was,
of you cannot argue together. One of you please argue.
it was
Either
the,
you come up or let her argue.
the suit for specific performance was disposed of by the lower court.
Oh, acha, acha.
For hearing the appeal on merits, the LCR would be required. So we are praying for direction for LCR.
Despite service, none appears for the respondent. Full stop. The affidavit of service filed to be kept on record. Full stop. We find from the materials annexed to the application that a sufficiently strong prima facie case has been made out, inasmuch as there was somewhat approval of the plaint case of oral agreement in the averments made in the written statement, and since the appellant was enjoying an interim order of injunction during pendency of the suit. Full stop. Since the respondent chooses not to be represented despite service, comma, we take up the injunction application for disposal ex parte. Can 1 of 2025 is allowed in view of the above observations, comma, thereby restraining the respondent stroke opposite party and her men and agents by an order of injunction from dealing with alienating, transferring and or creating any third party interest in respect of the suit property and stroke or from disturbing the peaceful possession of the appellant stroke petitioner in respect thereof till disposal of the appeal. Full stop. Next para. The appellant shall put in postal costs and due requisites for service of notice of the appeal on the respondent within a week from date. Full stop. The trial court record shall be called for by special messenger at the cost of the appellant.
Within
Also,
2 weeks, my lord.
also to be deposited within a fortnight. Ageta fortnight kore daw. Within a fortnight. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Much obliged, your lordship.
Appeal the respondent. The respondent is. No, no. You to address a party. Next. একই রেসপন্ডেন্ট দুটো অ্যাড্রেস আছে।
Your Lordship, I'm appearing on behalf of the appellant. Your Lordship, this is a partition suit On the last occasion,
you have not put in requisites for service because Mr. Devdipti Banerjee appearing for 2, 3, and 4 on caveat. 2, 3, and 4, all right. But respondents 5, 6, and 7, you have to put in requisites.
we have been given directions. We have filed it also. We are filing the affidavit of service today.
Let us dispose of this is an injunction application.
Yes, your lordship, I would just like to mention, I'm being led by, actually this matter belongs to Mr. Rajdeep Bhattacharya.
Mr. Rajdeep Bhattacharya is in court.
He's not in court. Due to some personal difficulties, he was not there. So I was just told to file the affidavit of service. And
Since Mr. Rajdeep Bhattacharya said we have to abide by that.
My lordship, kindly sees the lordship's last order. The order directs me to prepare the paper book, the respondents, and lordship had dispensed with the calling for of the lower court records. And the paper books are ready. Allow me to file it in the court. I'm giving a copy to my learned friend also.
No, file it in the department, Mr. Mukherjee. Otherwise, it will be difficult. It will be filed in the department, and we don't have space. After shifting of court, we don't have physical space. We don't have.
Okay.
File it in the department, and they'll give a number and all those things. Let the formalities.
All
be
right,
done.
madam. I'll file it in the department.
And then affidavit of service filed today be kept on record. You have served on the other respondents 5, 6, and 7. They have received.
Yes.
Then we'll dispose of the stay application.
Lordship.
This is against what?
The Can 2 was against application in connection with the present appeal. Application was for stay of the preliminary decree and stay of proceedings.
We have passed the usual direction. Very well. Affidavit of service filed today be kept on record. Full despite service, none appears for the respondent numbers 1, 5, 6, and 7. Although the respondent numbers 2, 3.
1 is dead already.
Acha. Although respondent numbers 2, 3, and 4 are appearing through the learned advocate. Since the respondent number 1 has met his demise, there is no question of further service on the said respondent. We are
appearing for respondent number 2 and 3.
Not 4.
Not 4. They were directed to serve upon 4, 5 to 7.
No, you had lodged a caveat on behalf of 2, 3, and 4.
2 and 3.
That is the office report.
But
Must have served.
it is 2 and 3.
The office report is wrong then. Have you got a copy of the caveat?
No, caveat.
No, 2, 3, and 4.
We'll check up.
Yeah, on the last occasion that appeared on
push up. Since the absentee respondent choose to remain unrepresented despite service, we take up the application for hearing in their absence. Full stop. The present appeal has been preferred against a preliminary decree of partition. Full stop. Accordingly, we allow Can 2 of 2020. We dispose of Can 2 of 2025 without any orders to cost, thereby directing the learned trial judge to continue with the final degree proceedings. However, no final degree shall be drawn up without the prior leave of court till disposal of the appeal. So next para, learned counsel for the appearing respondents 2 and 3 submits that the paper books have already been prepared pursuant to the direction of this court. Full stop. Next para.
The paper book copies are being handed over.
Copies thereof are handed over here and now to the learned advocate for the appellants. Full stop. Next para. The respondent numbers 2 and 3 are granted liberty to file the paper books in the department. Full stop. The appellants shall put in due requisites and postal costs within a week from date for service of notice of the appeal on the respondent numbers 5, 6, and 7. Liberty to the parties to mention the appeal for inclusion as and when the same is ready for hearing. 5, 6, and 7 put in the requisites within a week.
It's otherwise ready for hearing.
Otherwise ready, but they have to be served 5, 6, and 7.
Grateful.
You are appealing?
I am for the appellant. Pursuant to the direction passed by your lordship, my lord, we serve.
Mr. Halla, please take the microphone towards you. Tolabana 5 rupee was not deposited.
That has not been done. We are doing this by within a
We'll deduct 5 rupees from your fees.
My lord.
And put it in there. Put in that by tomorrow.
My lord.
Acha, you have served the proper service?
My lord, so far as there are sole plaintiff. My lord, this is a partition should, my lord, different number 1 and 2, my lord, prepared this appeal. My lord, against the final decree. My lord, sole plaintiff respondent has been served.
This is an application for what?
Application for
Section 5.
Section 5, my lord. From the stamp reporter report, there is no, my lord, delay. but it appears from the final decree, so far as the passing of final decree and drawing of the final decree, there is a delay of 73 days in preparing this the instant.
What is the explanation?
Explanation is that
Ailments.
appellant underwent surgery. That is
You have properly served on one.
one.
The others we did not direct service.
Yes, I was directed to make
Not
service.
properly
I
served.
But that from the post tag reports, it appears it has been sent to the sender. But till today, we have not received any
We find from the
article.
affidavit of service filed today and kept on record that the plaintiff stroke respondent number 1, comma, the principal contesting party, comma, has been served. Full stop. Accordingly, we take up the application for condonation of delay for hearing. Full stop. Upon a perusal of the averments made therein, comma, we are of the opinion that sufficient cause for the delay has been explained. Hence, can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 105 of 2025. Any other application?
No, there is no other application. But in the earlier order, your lordship was pleased to direct us to serve copy of can number 2, but it should be can number 1. In the earlier order passed by your lordships. Though in the order sheet, it has been in the head can number 1, but in the body of the order, can number 2 I was directed to serve. There is no can 2.
It may be recorded that in the order dated May 6, 2025, it had erroneously been transcribed that the appellants were to serve copies of can 2 of 2025, comma, which should be read as can 1 of 2025. Which of next para. So directed to put in the requisites and all for service on all, because partition. The appellant shall put in postal costs and requisites for service of notice of the appeal on all the respondents within a week from date. This is against the preliminary decree.
Final decree.
Final decree. The trial court record shall be brought by special messenger at the cost of the appellants, comma, to be deposited also within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who is of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. 1 week. Yes.
My lord, I am appearing on behalf of
Item 31. Yes.
My lord, I am for the appellant petitioners. My lord, I have served.
Yes, sir. Proper service effected.
Yes, they are busy. But the difficulty is this, my lord, so far the honorable second judge's copy, it is not properly prepared. Just xerox.
What?
copy.
The affidavit of service?
Yes.
Give the only copy to the honorable second judge.
I may be excused, my lord.
Hey, affidavit of service. Yes.
My lord, there are 2 applications.
You are appearing?
appearing on behalf of the respondent number 1 and 2.
1 and 2 are the only respondents.
My lord.
This is against what?
What degree of the suit for declaration and injunction? We have prayed for declaration that we are the owners and we have right to the peaceful use and enjoyment. And
Take the microphone a bit closer to you.
And permanent injunction restraining the defendants respondents from disturbing my possession and also for demolition of the illegal construction. The learned trial judge, my lord, decreed the suit in part, holding that I am the owner of the property, but at the same time restrained me from making any construction. There is no counterclaim, nothing. Ex parte. Suit has been disposed of ex parte.
No, sorry. Suit was decreed.
Decreed in part that I am the
Owner of a portion.
Nothing more.
But what was not done? No, permanent injunction was not
Nothing.
done.
Rather, I have been restrained from making any construction.
Yes, we'll make the injunction order absolute and direct them to prepare paper books.
Yes,
Seeking some time for filing affidavit of opposition.
No. Why waste time?
They cannot.
Since they're asking, let us, because you are enjoying
Absolutely.
injunction.
At the same
The
time,
more the delay, they are benefited.
Order from Calcutta Corporation to demolish the.
Oh, thank God. We thought there was an order by the Calcutta Corporation to file affidavit in.
Yes, that is against the respondents.
Some day will come when they will direct us.
Yes, and at the same time, my lord, kindly give the direction.
Demolition, Calcutta Corporation is not a party here.
My lord.
No. In the suit
They are
also.
parties.
No.
No, they are not parties.
Calcutta Corporation is not bound.
Yes.
Let them proceed.
Yes.
You are bound. You will not you are injuncted from disturbing their possession.
And that order has been set aside. whatever it may be. I'm not
We're not
making
going
any
to that.
submission on this, and kindly give me direction to prepare
Affidavit
the
of
paper.
service filed today be kept on record. Full stop. Upon hearing learned counsel for the parties, we find sufficiently strong prima facie case having been made out, insofar as the learned trial judge was learned trial judge committed an error of law and fact in refusing permanent injunction despite granting a partial decree of declaration of the title of the plaintiff in respect of the suit property. Full stop. Accordingly, this is can 1.
Yes.
What was can 2?
Can 2 stay of the operation of the order?
That we have disposed of or not?
No, pending, but no interim order has been granted.
Very well. Accordingly, can 1 of 2024 is disposed of by granting injunction restraining the respondents and or their men and agents from disturbing the peaceful possession and enjoyment of the suit property by the plaintiff appellant till disposal of the appeal. Full stop. Insofar as can 2 of 2024 is concerned, the same is not pressed by the appellant and is disposed of as not pressed. Full stop. The appellant shall. You are appearing for both the respondents, you said.
Both the respondents,
In
my lord.
view of the appearance of the respondents to their learned advocate, service of notice of appeal on the respondents is dispensed with. The appellant shall. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Thank you. Next.
I'm appearing for the appellant, my lord. On the last date, my lord had directed me to put the name of the respondents and to serve them a copy. So I have done the needful, my lord. And
You are appearing for the respondent
no, my lord.
with her.
Yes.
What is that? Your ticket to this court. What is that paper you are showing? You are giving it to him. We asked you are appearing for the respondent. You are showing a paper. We thought that's your ticket to the court. Yes, sorry, ma'am, you have served. Good service.
Yes, my lord, it's come back refused. We got
Refused is good. Unclaimed. Unclaimed is also
there
good.
are we got 2 new addresses, my lord, after that.
Acha.
So we have served upon the new address also and in the old address also.
So there has been good service.
It has been good service, my lord. The only question of law which was there, because we had filed an application for grant of letters of administration.
What are the 2 applications? One is section 5.
One is section 5.
What is the delay? First, you have to
Of
cross.
53 days, my lord.
Reason?
The order was granted on 20th of December 2024.
What is the cause of the delay?
The cause of the delay was that, my lord, we could not trace the file after the order was granted, and we took some time for tracing the file. Thereafter, we, in 4 days of tracing the file, we applied.
What is the appeal against?
Appeal is for, my lord, we had applied for grant of letters of administration, and the lower.
On the basis of a will?
No, my lord.
Without
there was
will?
no will.
Achha.
And the maintainability point was heard, considered by the court below, and they had observed that a will is not required for grant of letters of administration. Thereafter, on the date of final hearing, after the citations was done, the chief was completed. The learned trial court observed that because there is no will, hence the letters of administration cannot be granted.
That is the reason.
Yes, that is the reason, my lord. Yes, that is the reason, my lord. My lord will kindly see in my section 5 application itself, I have annexed the order. My lord will kindly come to the last page of my section 5 application. That is page number 32.
What is the date of the impugned order?
That is 20th of December 2024. 2012-24. The last page, my lord. Page number 32. And my lord, I have also, it also states that there is suppression of facts, my lord.
What fact? That there is a will.
I don't know.
You suppress the will.
I don't know. But
where there is no will, there is no way. Anyway, affidavit of service filed today be kept on record. Full stop. Despite service, none appears for the respondents. Full stop. Accordingly, we take up the applications for hearing ex parte. Full stop. In view of sufficient explanation for the delay in preferring the appeal having been made out, Can 2 of 2025 is allowed, thereby condoning the delay in preferring the appeal. Full stop, next para. Can 1 of, you had also served a copy of Can 1. We had directed both to be served.
Copies, all
Very well.
copies.
Can 1 of 2024, 5 is an application for,
My lord, these are the envelopes because they are very huge, so I did not attach it with the,
no, stay would not serve your purpose. What would you stay? It's a dismissal.
it's a dismissal, my lord.
Is an application for stay of the impugned judgment and deemed decree, full stop. However, comma, since by the deemed decree, the proceeding for letters of administration initiated by the appellants was dismissed, comma, there is no scope of grant of stay. Full stop. Accordingly, we dispose of Can 1 of 2025 by directing the appellants to put in postal costs and due requisites for service of notice of the appeal on the respondents within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellant shall prepare and file informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is ready for hearing. Put in the postal cost and the special messenger cost within a week from date and mention the appeal when you prepare paper books. Yes. Next.
Item number
Much obliged, my lord.
Parthopratim Roy is only praying, my lord.
Parthopratim Roy for the respondent?
No, my lord, for the appellants.
Appellants. Yes.
Is only praying made me not today, only for adjournment for the day, my lord.
Did you inform Mr. Mitra and Mr. Mukherjee previously that you will pray for time? If you did not inform, we will refuse. Mr. Parthopratim Roy has been roaming around the court throughout the day.
Yes.
He has been spotted in several places at the same time.
Only for the
You are enjoying an interim order?
No. The plaint has been rejected. Plaint rejected.
Plaint rightly rejected.
So you asked for a stay of operation of that order. Why should you adjourn for on the ground of Mr. Rai?
Kindly,
stay means what? The suit is revived.
The suit is revived. We want to contest the suit before the court below.
Then you have to win the appeal first.
Yes, my lord. For that,
we'll dispose of the stay application. We'll direct Mr. Rai is in the court precincts.
No, yes,
we'll record his name. We'll dispose of this application. Direct you to there. You are appearing for the plaintiffs at
1 and 2.
Not plaintiffs. Different. Oh, only for 1 and 2.
1 and 2. Oh, okay, 5, 4. I'm 5 and 6.
You have set up Mr. Mitra and Mr. Mukherjee, or they have set you up?
It is our application which was allowed by the law.
You are which respondent, Mr. Mukherjee?
1 and 2.
Oh, you are appearing together. Yes. You don't have any case then. নিশ্চয়ই গন্ডগোল আছে এই দুজনকে দিয়েছে 1 and 2, but the other defendants will also be affected if the plaint either rejected or not rejected.
If the plaint is rejected, blood, then the other defendants are not.
No, but the other way around, if it is set aside, then the suit revives and but they did not appear. They did not apply for rejection. 1 and 2, you are appearing.
1 and 2, we are appearing.
You are for 5 and 6, you are also appearing. You are supporting them, obviously, 1 and 2.
My instruction to support the applicant.
Support the appellant?
Because they are not the Shebayats. The declaration of a Shebayati right is not the subject matter of the partition suit. Partition suit for a declaration 120th Shebayati right is not prayed for. Whether that is maintainable or not.
Mr. Rai will never come. What is the affidavit of service?
No.
On caveat, you have served them.
Yes, ma'am.
1 apply করেছিল.
Did you direct you to serve? Yes, we directed you to serve. Was there a direction for service? We don't find it.
I suppose there was a caveat. They were upon
1 to 4.
Respondent.
You are appearing for 1 to 4. That was recorded on the last occasion.
But the application was made by defendant number 1.
Maybe, no difficulty on that.
We are in search of the
No, if you are for 1 to 4 and he is for 5 and 6.
The 1 and 2.
The present application has been filed for stay of operation of the impugned decree, whereby the plaint of the suit filed by the present appellant was rejected. Full stop. Next para. Learned senior counsel appearing for the respondent numbers 1 to 4 point out that the plaint was rejected at the behest of the respondent numbers 1 and 2 and on their application.
We are appearing for 1 and 2.
আচ্ছা তাহলে রেসপন্ডেন্ট 1 টু
Application was by 1 only.
1 only.
আচ্ছা তাহলে যেখানে 1 to 4 বললাম ওটা 1 and 2 করে দাও আর যেখানে 1 and 2 বললাম ওটা 1 করে দাও রেসপন্ডেন্ট নাম্বার 1 on his application for rejection of plaint. Full stop. Next para. Respondent numbers 5 and 6 are also represented through a separate set of counsel. Full stop. Next para. In view of the plaint having been rejected only on the prayer of respondent number 1, comma, we do not find any necessity to direct fresh service on the other non-appearing respondents. Full stop. Next para. Accordingly, we take up Can 1 of 2025 for hearing. Full stop. Since the impugned deemed decree is one of rejection of plaint, comma, there is no scope of grant of stay of operation of the same. Full stop. Next para. Accordingly, Can 1 of 2025 is disposed of by directing the appellant to prepare the requisite number of informal paper books without comparing with the records within 6 weeks from date and to serve a copy of the same on the learned advocates for the appearing respondents. Full stop. We dispense with service of notice of the appeal on the non-appearing respondents for the reasons as indicated above. Full stop. In view of the short conspectus of the appeal, comma, the trial court records need not be called for and are dispensed with as well. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. You prepare informal paper books within 6 weeks, give them copies, come back then.
Great.
Thanks.
আপনার ওই অ্যাপিলটা আর স্যার না চলছে 12টা পার্টিশন দিয়ে
বাহ এটিকেও হাফ অফ করে দিয়ে দিলে কত বুঝলে একজন সেবায়িত বলে গেল যে অন্যদের দিয়ে সে তো wow, very good. Yes, Mr. Shamantu, what is the matter? Good service. What about the service?
all have been served.
What is the matter about?
The suit
Ad interim injunction refused in what partition suit?
partition. The lawsuit
Despite service, none appears for the respondents. Full stop. The affidavit of service filed to be kept on record. Full stop. The matter arises out of the refusal to grant ad interim injunction in respect of a partition suit filed by the plaintiff stroke appellant. Full stop. We find that the learned trial judge refused the ad interim injunction primarily on the basis that no document of title of the predecessor of the plaintiff was produced, despite certain other documents, including the Aadhaar card, power of attorney, etc., having been produced to prima facie show the possession of the appellant, as well as a Faiznama, F-A-I-Z-N-A-M-A, dated January 12, 2025, being produced by the plaintiff stroke appellant, showing the lineage of the predecessor in interest of the plaintiff, who was the owner of the property. Full stop. Accordingly, we find sufficient prima facie case having been made out by the appellant for grant of injunction. Full stop. Moreover, comma, since the appeal has already been admitted, comma, the balance of convenience and inconvenience is in favor of grant of injunction. Full stop. Accordingly, Can 1 of 2025 is allowed, comma, thereby restraining the respondents and or their men and agents by an order of injunction from changing the nature and character of the suit property in any manner and or from creating any third party interest in respect of the suit property till disposal of the appeal. Full stop. The appellant shall put in due requisites and postal costs within a week from date for service of notice of the appeal on the respondents. The trial court record shall be trial court records need to be
This is a refusal of ad interim injunction. Appeal can be disposed of and can be sent back for.
appeal cannot be disposed of unless you serve notice of appeal on them. That is the difficulty. If they appeared, we could have disposed of. That is the purpose. That was the purpose for service. If they don't appear, then anyway, you prepare informal paperbooks then. In view of the short ambit of the appeal, the trial court records need not be called for and are dispensed with. Full stop, the appellant shall prepare and file the requisite number of informal paperbooks without comparing with the records, incorporating all relevant documents, within 6 weeks from date. Full stop, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. যদি affidavit of service বলে থাকি তাহলে আলাদা কথা, না বলে থাকলে ছেড়ে দাও। But okay, good. Thank you.
Item number 35.
For the respondent number 16.
16.
16.
Served on the others.
I am respondent number 10, 11 and 12.
There are other respondents also. I'm told everyone has
What
been
about
served.
service on the others, Mr. Banerjee?
I'm told everyone has been served.
You have served on all.
Served, I'm told.
What is the matter about?
May I personally check once? I have not personally checked.
Personally check. কতক্ষণ দেখিনি একটু কি আগে।
No, someone is left unserved. It says item delivered to the sender.
Sender means?
Sender. Means
Sender. That's you.
Yes.
Your learned junior should be more cautious in the next occasion.
There are 3-4 endorsements like that.
Who have not received? Which parties?
That I have to check that telling with the postal receipts. It was sent to everyone. That I have checked through speed post.
No, this is against refusal of ad interim injunction.
Yes, and my lords were kind enough to grant me an interim protection on May 6, 2025 with a direction to serve everyone. Now, we know the addresses as are indicated in several multiple litigations are pending before different fora.
No, they did not contest at this address, so we cannot be sure that you have sent at the right addresses.
Respondent number 1 to 9, they don't have any interest over the issue.
Why do you say that, Mr.
They have sold out the property. We have purchased.
As for the plaint case also?
Yes.
That is a plaint case also?
No.
Yes,
Not
the plaint case.
No. Plaint case, they have stated the
I have said that they have sold, but they are also litigating in various matters. So
You are
they need to be served.
seeking injunction against them also?
Yes. May I try my hand once more?
1 to 9 are appearing together in the suit. They appeared?
Yes.
No, at interim stage?
No, they did not. In my suit, they did not. This is from refusal to pass expertise ad interim order. So,
but then this injunction will be perpetuated if you can't serve them. What is the endorsements? I mean, postal tax reports. What is
it?
Out for
Delivered to
delivery?
the sender.
No, that is the last endorsement. Out for delivery? No.
Most of them residing at Faridabad.
Item delivered to addressee as well as, please see page 18. একটু একবার দিন তো অনিন্দিত, see page 18. Addressee as well as sender. First addressee, then sender.
Strange,
Strange.
Single postal article.
Stranger things. Any other similar endorsement? Very curious.
I'll just check. No, here is one which says only delivered to the sender. Most of them are delivered to the addressees, barring
Because they'll be unnecessarily hauled up. If you agree, we can. No, but the appeal has not been served.
The difficulty is, I cannot strike their names out.
Yes, what do? We can dispose of the injunction application saying substantial service has been effected, but the other respondents, they have to put in postal requisites.
Injunction, we are suffering, my lord.
That is why we are asking you.
If you
Nothing to be done. We can dispose of the injunction, this injunction application once it will go ahead one step. But they have to put in postal requisites for the other.
I have to say something, my lord, because, my lord, there is some.
You want to use opposition to the injunction application?
No, my lord, I have made a compilation, my lord, that will be enough, my lord,
Compilation,
of facts.
that is the size of the compilation?
Yes, yes, yes.
Because, my lord, apart from my suit, there are not less than 7, my lord, suits are pending before different. My lord.
Yes, what do you say in that compilation? Give a copy to them also.
এদের আর কোনো অ্যাড্রেস জানা আছে? একটু জানার চেষ্টা কর। হ্যাঁ, থ্যাংক
ইউ। My lord, if your lordship kindly come to
Compilation, but you have not yet filed your written objection in the court below.
My lord,
How can you look into documents?
because, my lord, ad interim injunction, my lord.
Ad interim then will make absolute and direct you to file your written objection to the injunction
This is,
application.
my lord, for understanding, my lord, what happened in
We
the
don't
suit,
want
my
to
lord.
understand so much. We are proud of our lack of understanding.
My lord, what
You have not filed written objection in the court below. We cannot
we have
permit
not
you.
been served, my lord. Plaintiff has not been served.
Yes, because at the ad interim stage you had no occasion to file written objection. This remedy will be illusory. These documents will not be for the trial judge. We cannot decide the appeal against the ad interim order on the basis of documents which are not before the learned trial judge.
এক্সপেডিট করিয়ে নেবেন ট্রায়াল কোর্টে। দেখুন
1 to 9 you have stated in your plaint that they have transferred.
Yes, I have said so.
My lord, once may I submit the facts, my
No,
lord?
no,
In
no,
short,
Mr.
my lord, in short,
We
my lord,
cannot take these.
it will not create any trouble, my
We'll
lord.
direct the respondents to very well. You make your submission.
My lord, what happened, my lord? There is, my lord, 140 cutters of land.
Right.
My lord, if your lordship kindly come to my first page, my lord, 3 sons are the owner and 1 daughter is the owner. My lord, everyone gets, my lord, 25%. My lord, they have sold out the land to the respondent number 10, 11 and 12. They have purchased the land by 3 deeds. My lord, thereafter, my lord, one respondent number 14 obtain a probate. After obtaining such probate, the appellant has executed a development agreement with that, my lord, Tomal Sarkar, respondent number 14.
Mr. Bhatto, the injunction, ad interim injunction was not refused on merits. It was refused on primarily 2 grounds. One is that there is an arbitration clause, which is a bad ground. Another, there is a jurisdiction clause. We have said that there is a strong prima facie case against both the grounds. Unless the trial court itself considers the merit, we cannot do that. It's beyond our scope.
Then, my lord, it can be sent it back to the trial court for
Learned
final.
counsel appearing for the respondent numbers 10 to 12
Then, my
submits
lord, appeal be sent it back to the, my lord,
seeks to submit on merits of the facts of the case. Full stop. However, since the appeal itself arises out of an ad interim order of injunction which was refused primarily on the ground of a jurisdiction clause and the existence of an arbitration clause, we cannot permit the scope of the appeal to be widened to incorporate factual considerations which were not before the learned trial judge. First up, the affidavit of service filed today is kept on record. First up, we find that despite substantial service having been effected, the other respondents than respondent numbers 10 to 12 and 16 are unrepresented. First up, next para, learned counsel appearing for the respondent numbers 10 to 12 contends that in view of the transfer of the property by the respondent numbers 1 to 9, they shall not be prejudiced in the event the appeal is disposed of in their absence. Full stop. Next para, we find from the averments made in the plaint, which are the German consideration of the ad interim stage, that there is substance in the contention of learned counsel for the respondents 10 to 12. Full stop. Next para, in any event, since the respondents choose not to appear, we are of the opinion that substantial justice would be subserved if the appeal along with the application is itself disposed of, granting opportunity to the respondents, to the defendants to respondents to file their written objections, bringing in all the necessary facts, in the in connection with the temporary injunction application pending in the court below. Full stop. Accordingly, comma, we dispose of FMA 556 of 2025 by treating the same to be on the days list along with can 1 of 2025, comma, thereby setting aside the impugned order and granting ad interim order of injunction restraining the respondents and their men and agents from transferring, alienating, and or encumbering the suit property in favor of third parties in any manner till disposal of the temporary injunction application. Full stop. The defendants in the suit shall file their respective written objections within 3 weeks from date. Full stop. Next para. The learned trial judge shall dispose of the injunction application at the earliest thereafter, comma, preferably within 4 weeks from the date of filing of written objection. Now, preferably within August 14, 2025. Full stop. It is made clear that the learned trial judge shall dispose of the injunction application on its own merits independently without being swayed by any of the observations made above.
May we also have an opportunity to put in a
Reply in trial court, it's not granted. Take this back, Mr. Bhatto. It will be necessary in the court will.
Since we are new documents now, it appears we are going to come. So maybe.
Very well. তাহলে যেখানে বললাম যে 3 weeks এর মধ্যে করবে, reply thereto if any shall be filed within a week thereafter.
Grateful to your lordship.
তাহলে ওটা যেটা dispose of within August 14, within August 31, 2025.
Grateful to your lordship.
There was a direction to serve, my lord. I have served, my learned friends are appearing. Now, my lord, 2 plots of land, my lord.
You are appearing for all the respondents?
But only one.
One.
My lord, 2 to 7, my lord, your lordships had dispensed with.
Achha, very well.
Now, my lord, there are 2 plots of lands, my lord, 726 and 727 by 807.
Yes.
Now, my lord, 726 is exclusively my plot of land. 727 by 807, my lord, belongs to my learned friend. Now, my lord, what he did was, my lord, he filed a suit for declaration and injunction. Now, my lord, he obtained an order of injunction. Now, my lord, we challenged that order in misappeal. The learned appellate court stayed that order. Now, my lord, suppressing that suit, my lord, over the same plot of land, he filed a partition suit and obtained an order of status quo. Now, my lord, I am aggrieved, my lord, by the order granting, my lord, injunction in their favor. Now, my lord, if your lordship kindly comes to the order, my lord, passed in, my lord, the suit, my lord, page, my first suit, page 82. Now, my lord, this was the order of, my lord, injunction in the form of status quo.
Yes.
My lord, when we assailed that order before the learned appellate court, the learned appellate court found that there is nothing on record to show that in respect of plot number 726, which is my plot of land, which I have purchased by way of 4 title deeds, my lord, he has any right, title and interest. So, my lord, the learned appellate court stayed that order. Record of rights, my lord, also did not reveal his name. Now, my lord, thereafter suppressing that, kindly comes to the order impugned, my lord, which is the certified copy. Now, my lord, he produces a certified copy of a deed of conveyance. My lord, there is no specification given by the learned trial court, my lord, in respect of which plot of land this deed of conveyance was filed. My lord, 727 by 807, I say it is his plot of land. I have no right, title and interest over it. Now, my lord, the learned trial court, my lord, grants an order of status quo. I am constructing my residential house over plot number 726. My lord, since it is a subject matter of the, my lord, schedule of the plan, entire construction work is stored.
Your sale deed you have annexed here.
But I have annexed my sale deeds. Kindly comes to, my lord, page 15 onwards. All my sale deeds, 4 title deeds I have purchased. And kindly sees the schedule of those sale deeds, all appertains to plot number 726. And the order of, my lord, status quo, LR information, registered certified copy of deed of conveyance, my lord, which plot? My lord, there is no mention in the order passed by the learned trial court.
Yes, what do you say?
My lord, so far 726 plot is concerned, we are co-sharer.
We are?
Co-sharer.
Please
also
come to the microphone. Come to the mic.
We
Your
are also
co-share.
co-share, my lord. In the court below, they have filed an application under order 39 for vacating the interim order that is pending. And in that application, they have stated
They have
that
challenged here an ad interim order of injunction. So we'll direct you to file your written objection. We'll direct them to file written objection to that, to your injunction application, and that along with the 39(4) will be heard together.
yes.
Then let us dispose of this appeal. But that injunction you have granted, you have been granted, that cannot continue.
Grateful.
No, in that 726, we are also the owner. That's why partition suit has been filed.
Your previous injunction order has been stayed. You have suppressed that. This is suppression of material fact. You know, plenty have not stated.
They have not mentioned in the
Partition suit. That was declaratory suit.
So what? The self-same plot,
Same plot.
partition suit, the preliminary degree will be for declaration of title.
My lord, but we have our deeds. We have produced this before the court below.
My lord, kindly comes to their plane. There is not a.
No, let them complete.
My lord, kindly have a look. 726.
This is not referred to in the impugned order.
Yes.
But this has not been referred to in either in the impugned order. You have not also in your plaintiff you have stated. You must have stated you have title, but first of all not referred to, and you have suppressed this previous injunction refusal.
Yes, we have withdrawn that suit.
But
That you should have disclosed these facts before the court below.
Absolutely.
We'll set aside the injunction, but we'll say that this will not affect the court below while disposing of the main injunction. We'll dispose it of on the ground of suppression.
Only on suppression.
Suppression, and also that yes, only on suppression. The 726 you have a contending claim regarding title.
Yes.
Only on suppression.
They have also stated in their application, order 39 rule 4, that we are co-shared in 726.
They have stated in the order.
Yes.
Shows that.
এই সুটে আপনারা ফাইল করেছেন তো হচ্ছে, হ্যাঁ। Kindly 7th line from top. আপনাদের তো
726. নালিশি দুটি দাগের শরিক একই নহে, এই বিবাদী পক্ষে কেবলমাত্র নালিশি বিবাদী says he has title in respect of 726.
726.
He has claimed his title regarding 726, not your
I am the defendant in that suit. বিবাদী তো।
বিবাদী পক্ষের কেবলমাত্র নালিশি 726 দাগে সত্য রয়ে আছে, 727 they have said they have.
That is my case. 727 I have nothing.
So on consent you are taking up the appeal and the application and disposing of it. Only that consent regarding that, taking up the appeal along with it. On consent of the parties, comma, in view of the short ambit of the appeal, comma, the appeal and the application are taken up together for hearing. Full stop. Learned counsel appearing for the appellant submits that, comma, suppressing the stay of operation of an injunction order passed in connection with the previous declaratory suit filed by the respondents in respect of the self-same property, comma, the impugned ad interim order of injunction was obtained. Full stop. Next para. Learned counsel further submits.
That suit has been withdrawn.
Will record your submission. Learned counsel for the appellants further submits that the respondent number 1, comma, apart from such suppression, comma, is barred by law in the respondent number 1, comma, apart from such suppression, comma, is barred by law and fact in obtaining injunction, comma, since the sale deed executed in respect of one of the suit plots, that is plot number 726, comma, has been produced by the appellants in the court below, as well as the LR records of rights recording the name of the appellants. So next para, learned counsel appearing for the respondent number 1, plaintiff stroke respondent number 1 submits that the previous suit, comma, in connection with which initially an injunction order was granted but subsequently stayed, comma, has been withdrawn since by the plaintiff stroke respondent number 1. It is further submitted that in the appellant's application under order 39 rule 4 of the Code of Civil Procedure, comma, filed in the present suit for vacating the ad interim order impugned herein, comma, it has been virtually admitted that the respondent number 1 is a co-sharer in respect of plot number 726 as well. Full stop. A copy of the said order 39 rule 4 application is handed over in court today and kept on record. Full stop. We find, comma, however, comma, that in the application under order 39 rule 4, comma, there is no clear admission on the part of the appellants as to the respondent number 1 being a co-sharer in respect of the plot number 726. Full stop. Rather, comma, the appellants have categorically stated therein that out of the 2 suit plots, comma, the defendant stroke appellants are owners of plot number 726, whereas they do not have any title regarding the other suit plot bearing plot number 727 by 807. Full stop. Next para. We consider the submissions of both sides and come to the conclusion that the fact of the previous and a fact of the injunction application injunction order passed in favor of the plaintiff stroke respondent number 1 in the previous suit regarding the self-same property having been stayed by an appellate court was germane for adjudication of the present injunction application as well. Full stop. Thus, comma, having suppressed such relevant fact, comma, it tantamounts to suppression of material facts
for the purpose of obtaining the impugned order of ad interim injunction. Full stop. Accordingly, we are of the opinion that the ad interim order should be set aside on such ground alone. Full stop. Thus, comma, FMAT 156 of 2025 is allowed, comma, thereby setting aside the impugned order bearing order number 2 dated January 28, 2025, passed by the learned civil judge, senior division at Diamond Harbour, District South 24 Parganas, in title suit number 28 of 2025, and directing the you have filed your objection.
I have to file my objection.
Directing the appellants to file their written objection to the temporary injunction application in connection with which the impugned order was passed within a week from date. Full stop. Next para. The learned trial judge shall dispose of the temporary injunction application as well as the application filed by the appellants under Order 39 Rule 4 of the Code of Civil Procedure together as expeditiously as possible, comma, positively within 4 weeks from the communication of this order to the learned court below. Full stop. It is made clear that we have not gone into the merits of the contention of the parties insofar as the final hearing of the injunction application and or the hearing of the Order 39 Rule 4 applications are concerned, and it will be open to the learned trial judge to decide the said applications independently on their own merits without being influenced in any manner by any of the observations made above. Full stop. Can 1 of 2025 is also disposed of in the light of the above observations, no address to cost.
Could
Thank
that
you.
1 week be 2 weeks?
1 week.
My lord,
They are
great.
suffering. It a judgment for me.
Great.
Thank you.
My lord, I am for the appellant led by Mr. Moore. He is appearing, my lord.
Yes, Mr.
Yes, I'm appearing online, my lord.
Yes.
Lord, your lordship will recall, my lord, your lordship was pleased to pass an ad interim order of protection. But the scope of the suit, my lord, was very limited to the fact that, my lord, certain notices were issued, my lord, in derogation of the bylaws and the rules, my lord, framed by the All India
What about
Bank.
service? All have been served.
My lord, respondent number 1 and 2 have been served. My lord, 3, my lord, I believe has left. Lord, my learned junior would, my lord, apprise your lordship, my lord.
If the premises.
My lord, 1 was served through hand. 2, my lord, unclaimed. 3, my lord, left without instruction.
Left is not good service.
Yes, my lord. 1 and 2 have been served, my lord. 1
Yes,
is the,
you had got the injunction, short injunction in respect of all.
Yes.
Yes.
It was against an ad interim refusal.
Yes.
Ad interim refusal, my lord.
So serve again on the defendant number 3. Can come back.
Yes, my lord. But now, my lord, what has happened, my lord, we have also prepared a supplementary affidavit. My lord, today, my lord, how we are, my lord, put out, my lordship will find, kindly have a look at the supplementary affidavit. My lord, one of the contentions, my lord, if your lordship recalls, is that, my lord, the president, my lord, who is acting today, cannot act as a president, my lord, in view of Rule 4B. My lord, the tenure of the, my lord, the period, the tenure is, my lord, 2 years, which could maximum be extended till 3 years. Now, my lord, that expires on 15th of May 2025. He was appointed on 15th of May 2022. Lord, in spite of that fact, Lord, he is still issuing notices. Lord, that is
if you grant relief regarding that, that will be
yes, well, that will be beyond the scope of the suit.
beyond the
Lord,
scope.
that is why, my lord, what I intend to, my lord, for the interest of justice, my lord, if your lordship grants me, my lord, liberty, my lord, may I place those facts by way of an amendment in the plaint? Because otherwise, my lord, several suits will have to be filed every
There
time.
is no bar. There is no bar in your filing an amendment application in the trial court. Do that.
No, my lord, the difficulty is if your lordship puts 2 lines, my lord, that would, my lord, help us because the, my lord, the court in a straight jacket manner mechanically rejected my prayer.
Because this is an appeal against an ad interim order. The
Yes,
suit
my
is
lord.
pending. You go there.
Then my lord, kindly records, my lord, that would help me because the subsequent facts.
No. We don't want to help you so much.
Lord, what happens? I'll tell your lordship what happens.
For the present, be satisfied with your supplement, your interim order here.
Lord, what is the difficulty? I'll tell your lordship, my lord. Every time, my lord, they will issue a new notice, my lord, we have to file a new suit. That's the
not,
difficulty.
not that. You can pray for further injunction also. You know what to do.
Yes, my lord.
Learned counsel for the appellant files seeks leave to file a supplementary affidavit. Full stop, such leave is granted, and the supplementary affidavit filed today be kept on record. Full stop, from the affidavit of service filed today and kept on record, comma, it is apparent that although the respondent numbers 1 and 2 have been served duly, comma, the respondent number 3 could not be. Full stop, accordingly, fresh service of the application along with the supplementary affidavit shall be effected upon the respondent number 3, indicating that the application shall be listed on July 8, 2025, when an affidavit of service to that effect shall be filed. Full stop. Learned counsel for the appellant will record something. Learned counsel for the appellant seeks to incorporate new facts in his pleadings. Full stop. However, comma, since the present appeal is directed only against an ad interim order of refusal of injunction, and the scope of this court is limited to that extent, comma, it will be open to the appellant to take appropriate steps in that regard in the trial court.
I'm grateful to your lordship.
Thank you. যদি না বলে থাকি মেঘনাথ, fresh affidavit of service shall be filed on the next returnable date to that.
Sir, more or less, the scope of the suit, my lord, is gone. The respondent, my lord, would perhaps not appear.
That amendment is in any event necessary.
Yes,
Let us
lord.
see.
Yes,
Let us. Yes.
I'm grateful.
Lord, in item number
I beg to
38,
appear, my lord, for the appellant in this
I
matter.
appear for the respondent. There is a contempt application along with this appeal address. I appear for the alleged contempt. My lord, I'm led by Mr. Mitro. My lord, I was only seeking this, my lord. Is stuck in traffic because of the rain, my lord. If your lordship could pass it over for a few minutes.
Lord, in that case, my lord, I will be praying for, may I file the supplementary affidavit served? They have used an opposition.
Yes.
Opposition we have received on 11th of June. Lord, grants us 1 week's time. We shall come back with a reply and we'll argue, my lord, the content.
Will, because you are filing this, you give a copy to them.
Yeah, that's
they'll-
given. They have used the opposition.
They've used an opposition against the supplementary
Yes,
also,
I have.
as well as against the main.
Yes, yes, yes.
Achha,
Lord, I have only 1 week's time, Lord, that will.
do that.
Very well. Grateful.
The supplementary affidavit filed today be kept on record. Full stop. On the prayer of the appellant, the time for filing composite reply to the opposition filed by the respondents is extended for a week from date. Full stop. The application shall next be listed under the same heading on June 25, 2025.
And the composite opposition is also on record, my lord. Today filed. To
That has been filed on a previous occasion.
to the supplementary and the main.
No, you have already filed
No,
it.
no, today only. Just
Oh, acha.
to that they are seeking to
The
file.
composite affidavit in opposition filed today be also kept on records.
Obliged, my lord.
Grateful, my lord.
Give your names, all of you.
Well, item number 39, madam, appearing for the plaintiff appellant before your lordship, madam.
Defect, Mr. Chattopadhyay?
Well, defect, madam, there was a section 5. Section 5, madam, is the defect? Well, I have not checked, madam, the defect, madam. Defect, it's within time, madam.
Certified copy of the appellate degree does not reflect the other appellant's names. The parties you have implemented are proper. Otherwise, we will send down the appeal, the decree, appeal court's degree.
Others lekha ache.
Oh,
It has been written as others.
others.
Don't understand. Yes,
Rashida Khatun and others, madam, lordship will in the decree.
only that.
Only.
We'll send it down.
Yes.
Let us hear the order for 20.
Yes. Madam, this is a suit for eviction, madam, on the ground of reasonable requirement, madam, wherein the trial court has come to the finding, madam, the relationship between landlord and
Your
tenant.
suit or their suit?
My suit. Well, I am for the plaintiff landlord. Now, madam,
Both courts.
both courts, madam, I affirm. Now, madam, question is in respect
The
to
ground of what was the ground for eviction?
the ground for eviction, madam, reasonable requirement. And also default, madam, we have taken at.
Default was not allowed.
No, what has happened, my lord? At first, my lord, the defendant came with a written statement. After that, my lord, the learned lawyer was given several chances to appear and to, my lord, but they have not. That is also recorded in the order.
Not done what?
But to cross-examine or anything, they have not done. Now, my only question is there, my lord, in respect to the landlord-tenant relationship, the court has come to the finding that I could not establish that. Now, my lord, from the 17 application, I will show before your lordship that has not been, that has considered but has not, my lord, overlooked by the court. That in the paragraph 2, my lord, the tenant has admitted him that I am the landlord, and my lord, there is no relation, no dispute in respect to the relationship is concerned. And in written statement also, my lord, they have come to the, they have specifically stated that till that date I have paid that rent to the plaintiff.
No, that was the only ground on which it was dismissed.
Yes, Lordship will kindly seize.
The court did not go into reasonable requirement.
No, no. The reasonable requirement has come to the finding that once the commissioner went to the in the suit room, he could find defendant number 2, who is as per our case is concerned, the premises was sublet by the original tenant. So that was the case. That has been case, so that is on that ground.
Subletting was not your ground.
No, subletting was also that was also okay.
You said only default and
subletting was my main ground was reasonable requirement, and the court has not gone into all these things. Only court in every inch and every issue decided that I cannot establish my relationship between.
Let us see that.
Yes, Lordship will kindly takes impugned page, internal page 7 of the trial court order.
Yes.
Issue number 3. The plaintiffs, the owners of the suit property. Is there any landlord-tenant relationship between the plaintiff and the defendant? As per law enacted under 1956, an eviction decree cannot be granted unless the grounds for eviction so and so are proved. Reference may be made to the decision of the Honorable Court at
Abdul Majid, Exhibit 4 is in Abdul Majid's name. That is tax receipt.
Yes, now
where is your title deed? For reasonable requirement, you record to be the owner.
This is a Thika tenanted property. This is a Thika tenanted property, there is no dispute in respect to that. Abdul Majid is my predecessor, I have filed for an affidavit in chief, which has remained unchallenged. Even I have not cross-examined to that effect, but the court has not gone into that affidavit in chief.
Thika tenancy, where is it admitted?
Lordship will kindly see in affidavit in chief, I have specifically stated that Abdul Majid is my predecessor. Lordship will kindly see yes.
And in your oral evidence, you supported that?
Yes. Lordship will kindly seize, my lord.
Was there any cross-examination or demolition?
There was no cross-examination.
No cross-examination?
No, nothing. Why, I'll also...
Cross-examination at all or on this point?
Nothing. Never. Lordship will kindly... I'll just read for your lordship.
Not cross-examine your witness at all?
Nothing. Internal page 4, paragraph 5. Despite being given repeated opportunities, the defendant did not adduce any evidence in support of his defense case. Even neither cross-examine me. So, 138 of the evidence Act, Lordship knows, I will be taking that point, that they have chosen not to cross-examine.
Carapiate and all.
Yes, ma'am. And Lordship will kindly seize, affidavit in chief, paragraph 2. That originally my grandfather, namely Abdul Majid, was the sole Thika tenant in respect of the premises number so and so, formerly Belgachi, at present Khudirambo Sononi. So, this was my
subtenants also it was said that the mere presence of pro forma defendant does not mean that exclusive possession was given, which is quite correct.
What
is the finding on reasonable requirement?
Yes, reasonable requirement same, all are interconnected. Lordship will kindly see that is on page. Yes. Excellent. Yes, that is the issue number. Page 13, issue number 8, paragraph 14.
Yes.
Do the plaintiff reasonably require the suit property, is now taken up for discussion and consideration. The plaintiffs have sought for eviction on the ground of reasonable requirement by invoking section 13(1) FF of the 56 and adduced into evidence the final report of Advocate Commissioner along with annexes marked Exhibit 10 collectively.
You said you were in occupation of 4
rooms.
Exhibit 10 says 7 rooms.
What has happened, Lordship will kindly seize, during the pendency of that, what has happened if your Lordship goes to...
So you're in occupation of 7. What was your requirement as per the
plaintiff? My requirement was, I am a family of 25 persons. 25 persons.
What is the size of the suit room? How many rooms?
Yes. In the commissioner's report, 5 into 4 square, 20 square feet, 30 square feet, that has been the commissioner has came to the finding.
No, what is the extent of the tenanted premises, that suit premises?
The tenanted premises, exact, as per the plain case is concerned, I could not.
How many rooms?
Occupation is not no less than
The commission, there was no commissioner's report on that.
But commissioner's report, Lordship will kindly see. Commissioner report ta dao,
no, tell us. Commissioner's report says something about the suit room. In your plaintiff have described suit room?
No, plain room, I should be very candid before your lordship. I could not show before your lordship the specific, the defendant is in respect to the rooms, they are.
Even if your ownership is suppose that is taken into consideration,
Now,
then
today-
also court has on merit said that you failed to prove bona fide requirement because 7 rooms you have not amended your
7
plaint.
rooms, if your lordship.
Commissioner's report, you said you are in 4 rooms.
Well,
Commissioner's report says so 7 rooms.
They have break, the 20 square feet room and 30 square feet room has taken into consideration. That has to be also lordship will. If your lordship wants, I can produce. This is with me, man. Now, my only contention with your lordship is that today, it's lying vacant. There is no tenant resides over there.
How many rooms were your requirement as per the plaintiff?
My requirement was.
How many more rooms?
Yes.
Total, how many rooms do you require according to you?
In the written statement, may I read for your lordship? The plaintiffs are in occupations of big size rooms and also a veranda measuring. They have converted into 3 separate rooms by partitioning them same, and as such they are in occupation of 7 rooms beside kitchen, privy and bath. Moreover, during this period, out of the tenants had vacated the plaintiff, instead of utilizing the same for the occupation, they again let out the same to the tenant. Now, if your lordship, 4 big size rooms,
Yes, but you suppressed. You said 4.
But they are also saying 4. Lordship can go once.
No, subsequently you got occupation of 7.
What has happened?
They have stated that you have converted to 3. They are in occupation 7.
Which they have converted into 3 separate rooms.
Achha. And what is your requirement? We are asking you.
Requirement, I should be very.
How many rooms are your requirement as per the plate case?
What I comment, there was no specific requirement, but only the defendant's possession, because as per my case is concerned, defendant is yes. Lordship will kindly excuse me.
Let us see the plaint.
Yes, ma'am.
Where have you stated about your requirement? There has to be a pleading.
Yes, paragraph 6. Yes, 6, 7, 8. Yes, ma'am. Paragraph 6, 7, 8, ma'am.
Thicker tenancy also did not prove anything.
Yes, that lordship, lordship allows me, I have also filed a order 4127.
How can you do that in the trial?
Yes.
Both the courts below did not do that.
Thicker tenancy, in the maintainability point, the court has not gone into that merit.
Not maintainability. You have to show your right in the property. No document has been adduced into evidence by the plaintiffs to show that they are joint thicker tenants.
Joint thicker tenants, I have, madam.
Now, you had to do it before the appellate court.
Yes.
It's your document. Why should you consider it even?
Now, I should be very specific on this, all these documents were shown before the court, and that is also recorded in the judgment, but were not marked as exhibited. If I can show before your lordship,
1 minute.
Yes. Exhibited property tax receipts and true copy of ration cards were there.
What is their defense to your? You must have stated it's a thicker tenancy in your plaint. Did they deal with that?
No,
The
they
written
have-
statement. Where is your abandonment that how you become the owner? Let us see from the plaint.
Now,
Yes. First paragraph you have stated. Let us see how they deal with that.
C, they have admitted Abdul Majid at page 2 of the written statement that the said Abdul Majid was a thika tenant and not absolute owner, and on the death of said Abdul Majid, his legal heirs who are Indian citizens inherited the thika tenancy is a falsehood to such the plaintiff. Then they have stated.
So they have denied.
Abdul Majid they have admitted. Lordship will kindly see,
But you have to show that you are the heirs of Abdul Majid.
Yes, for that
Question of fact.
Affidavit in chief.
What is the substantial question of law, Mr. Chaudhary?
To be very candid before Lordship, these all documents were produced before the appellate court, and the trial court.
Not
but were
exhibited.
Not exhibited.
Then-
But, that has been recorded. That has been recorded in the order. Now, today, Abdul Majid, I have been affidavit in chief, I have shown that I am the son of, I have the legal, my predecessor is Abdul Majid, and Abdul Majid is nobody's denied. But even the written statement, they have specifically stated Abdul Majid, they are also claiming tenancy from Abdul Majid. And second thing is that in relationship, Lordship will kindly see paragraph.
No, they have
Paragraph
denied.
8.
Please come to para C of the written statement. that the said Abdul Majid was Thika tenant and not absolute owner, and on the death of said Abdul Majid, his legal heirs who are Indian citizens
1A, my lord.
inherited is falsehood.
Paragraph 1A, my lord. That before going into the merits of averments, this defendant states that he was inducted a tenant in respect of the suit premises by one Abdul Majid in the year 1968. So, my lord, it is not a denial from their side also.
But they have denied your heirship of Abdul Majid.
That for that reason, I am also carrying a Faraz Nama that I have produced before your lordship, with full order 427, and also affidavit in chief. Today, landlord is seeking a relief before your lordship only on the ground that I cannot show this document. And excellent. Defend and paragraph 8, lordship will kindly see.
Of what?
Of the written statement. 17(2)
Yes.
But that with regard to the averments made in paragraph 3 of the plain, this defendant states that the averments made therein are absolutely vague, and this defendant craves leave to file additional written statement as on particulars as to the default is furnished. The defendant, however, states that rents up to January 1987.
This appeal will be heard on the following substantial questions of law. 1. Whether in view of the uncontroverted oral evidence adduced by the plaintiff stroke appellants in support of their plaint case, to which there was no cross-examination by the defendant stroke respondents, both the courts below committed perversity in dismissing the suit for eviction on the ground that the plaintiffs have failed to prove the plaint case of landlord-tenant relationship with the defendants, as well as on the grounds of eviction as pleaded in the plaint. Roman 2, whether in view of the respondents having admitted in their written statement as to the predecessor in interest of the plaintiffs, namely Abdul Majid, being a Thika tenant in respect of the suit property, and inducted the defendant stroke respondents, as well as in the teeth of the admission in the written statement that the defendants respondents had been paying rent to the plaintiffs appellants directly, the courts below substantially erred in law in overlooking such material evidence to arrive at the finding that the plaintiffs have failed to prove landlord-tenant relationship with the defendants. Roman 3, whether the courts below failed to take into consideration the relevant yardsticks, such as the number of family members of the plaintiffs, that is 27, in turning down the eviction suit on the ground of bona fide requirements of the landlords. Next Roman number, whether both the courts below substantially erred in law in not adverting to the evidence, uncontroverted oral evidence of the plaintiff stroke appellants in arriving at the conclusion that no subtenancy was created by the defendant's respondents in respect of the suit property. Full stop. Next one is there is no scope of any interim relief.
Only
directly
injunction I have prayed, not to create any third party or anything.
if they create any third party, that will be to your benefit. It will furnish further ground anyway. Oh, you have also filed a order for 2027.
Yes,
That has
no,
been
only
filed.
Yes.
Acha, can 1 of 2025? Now, the appellant shall serve copies of can 1 of 2025 on the defendant's respondents, indicating that the same will be listed before the appropriate learned single judge having determination subject to being mentioned by the parties for enlistment. Full stop. An affidavit of service to that effect shall be filed by the appellants on the returnable date before the learned single judge. Said learned single judge. Full stop. Next para. There shall be the respondents and or the respondents opposite parties and or their men and agents shall remain restrained by an order of injunction from transferring, alienating, encumbering, and or parting with possession in respect of the suit property in favor of any third party, and or changing the nature and character of the same in any manner till disposal of the application. Full stop. Next para. Can 2 of 2025 shall be listed for hearing along with the appeal. Full stop. Affidavits, if any, in respect thereof, shall be exchanged in the meantime.
Well, I was carrying the Faraz Nama through order 4127.
The order 4127 is there, that also furnishes a further ground.
Yes. Grateful, man.
I am appearing on behalf of the caveator led by Mr. Rohan Balan.
I am for the appellant. There is some defect. I will remove the defect. I do not know.
What is the defect, please?
I have not seen.
You did not see your own appeals defect. Let us see it. You should have checked up before coming up with.
Not today is March. Not today.
You have mentioned the appeal
Yes.
for hearing and order. You did not check up the defects.
I not yet checked. I will remove it. No, not today, my.
Let us see the defects. You can remove 2 or 3 defects. You have to put in a deficit code of rupees 10. Secondly, you have to correct the description of the appeal. It's not memorandum of appeal from original. You have against appellate order. It should be decree. What is the decree? It's a regular title appeal. Then you have to move rectify the description of the appeal in the memo. So do this, and also you have to file the certified copy of the decree of the appellate court. The appellant shall file the decree, certified copy of the decree of the appellate court within 3 weeks from date. Full stop. The learned advocate on record for the appellant is granted liberty to rectify the memorandum of appeal by introducing the correct description of the appeal in words during the course of the day. Full stop. Deficit court fees as indicated in the office report shall be deposited by the appellants within a week from date. Full stop. Next para. Let the matter go out of the list with liberty to mention for inclusion in the list after the above defects are removed. Yes.
Item number 41, my lord. I'm very sorry to make the same submission. Mr. Aniruddha Mitra Sinha is leading me in this matter, my lord. The lordship is pleased to give 15 minutes, 20 minutes time. He's on his way, or my lord, not today, subject to what my learned senior friend says.
And he'll be waiting for the 15 minutes when Mr. Mitra will come.
No, my lord, I don't want that. No, absolutely not. Then not today, my lord.
Yes, Mr. Basu, what do you say?
It's only my request.
Mr. Nag is looking very angrily at you. So then,
He is facing the client's.
where is he? Which court?
No, he is facing the client's court. That's why he is
The
angry.
clients. So we'll take it up tomorrow then.
Yes, my lord.
On the prayer,
Retain his position. That's
it will. Order 41.
Time may be fixed if your lordship says. Time may be fixed also if your lordship says.
No. On the prayer of the respondents.
Number 1.
Respondent number 1, let the matter stand adjourned for the day.
I'm good.
Thank
My lord, the advocate on record is on the way, my lord.
As well as record has?
Advocate on record in this matter, my lord. He's on the way, my lord. A short passover can.
You are there.
My lord, if I go not there,
You are appearing, so what?
Hi.
Unless you are designated senior advocate, then you can appear. What are you doing?
Somebody has left the mobile. My lord, being a plaintiff, my lord, we filed up one suit for partition, injunction, and
You are for the respondent, sir.
Respondent number one.
One is the only contesting respondent.
My lord.
Or there are others?
No, my lord, the only.
only one. My lord.
Oh, plaintiff, yes. No, not
No,
sorry, not plaintiff. No, there are others also.
Others are not contesting.
As a very.
I have filed the written objection before the trial court to the.
This is against a refusal of temporary injunction. Yes.
My lord, we filed up one suit. That is for partition.
Can you please take the microphone a bit closer to your mouth? Yes.
We filed up a suit, my lord, for partition, injunction, and declaration, my lord.
Right.
Where we challenge out a deed, that is 1965 deed. That was a sale deed executed by one Gopal Chandra Samanto. That is by Saida Banu Begum in favor of Gopal Chandra Samanto, my lord. Now we say out that deed is a fabricated and a forged one. And we came out for a cancellation of that 1965 deed.
When did you file the suit?
My lord, in 24. Because we came to know, because the knowledge was there, on 2nd of April 2024, some people have come, which claim to be a people of defendant. They were cutting the valuable trees. Thereafter, we came to know, because the record of rights from 65 also, from 62 onwards, when the gift deed was executed in favor of Saida Banu Begum, the record of rights are there in favor of my predecessors. In 2023 till, the predecessors' names were there in the records of rights. Never it was been changed out. There were changes of deed from 2004, 2008, 2009.
That sale deed you are challenging, that was executed by your predecessor?
No, my lord. It's a fabricated one.
Fabricated deed was fabricatedly executed by whom? Your predecessor?
They say out my predecessor had executed, and that is in favor of Gopal Chandra Samanto, my lord. And Gopal Chandra Samanto legal heirs have.
The rest we understood. So they say that your predecessor executed a deed.
Yes, my lord. But the record of rights never been changed. Records of rights remains in my predecessor's
It's a sale deed, title deed.
Yes, my lord.
Title deed versus records of rights. Prima facie title deed will prevail regarding title.
My lord, the thing is there, what is there in the sale deed, what they have shown, it was a thumb. Thumb impression was there. Neither it was been read over, never it was been explained. Whereas in 1972, one partition suit was being undertaken before a trial court. That was in regard to some other properties, my lord. In that, my predecessor had put up a signature. She was a literate lady, an educated lady, where she used to put up the signature. Never she has used out a thumb. We have taken that plea. And the second was, when the records of rights remain from the day on when she became the owner. In 62, she got out the gift deed. From that onwards, never it was been changed. Because the chain of deeds, if take place, there also, they should have gone for a mutation also. And the second fact is, my signature should have been there. It was neither been read over, never been explained.
Why your predecessor signature?
Yes, my lord. The thumb was there, my lord.
The sale deed is a part of the records here.
Yes, my lord.
Let us see the sale deed whether.
My lord, it starts from 71.
There was no explanation, no statement in the sale deed that it was read over and explained.
No, my lord. 71 to 75, my lord, is a sale deed where the type copy is there, my lord, and page number 93 to 96, my lord. The type copy, my lord. 71 to 75 is the sale deed of 1965, my lord.
Where is the LTI? There are several sale deeds. Several sale deeds.
No, my lord. That are the chain deeds which were executed after 2004.
In their favor.
Their own
their predecessor.
Gopal Chandra Samantos legal has executed, my lord.
Where is the LTI? Where do you find the LTI? The alleged LTI, as you say. Give us the page number where the LTI is there.
এটা দেখো
Or at least that it's written LTI within
My lord,
bracket
it can be seen in page number 72, my lord.
72.
1, 2, 3, 4, 5, 6, 7, 8, 9. Page number 9, my lord. It is Begum Teep. My lord, 1, 2, 3, 4, 5, 6, 7, 8, my lord. Line number 8, my lord.
TPS.
And my lord, kindly come to
No, at the end there must be some LTI. At the end of the deed, where is that? Seal. Yes.
Here also it's written in page number 75, my lord. Begum Teep, my lord. That is 2, 3, 4, 5, 6, 7, 8, 9.
Yes, yes.
Line number 9. And my lord, kindly take to page number 76, my lord. Where the partition suit was there, my lord. Here it can be seen, my lord, at the right side, my lord. Saida Hasna Banu, my lord. That is
Sayyid Hassan Banu.
Yes,
Sayyida,
my
it
lord.
should be, yes, yes.
Here she had put up her own signature, my lord. It is 72, my lord. And here 65, my lord.
How did the learned trial judge deal with this?
The trial judge had come out to finding if the deed is there and the records of right is there, if the conflict comes out into that, the deed will prevail. But here, my lord, our thing was there. In 65 onwards, never the sale deed was been executed. Never the sale deed of
No, but the
65 came.
LTI aspect, how did the trial court deal with the LTI?
Did not deal out with it.
Read over and explain
No,
that.
no, never had
And
that.
this signature in this partition.
Never it has dealt out, never in the order it was been taken into. It was a non-speaking order, my lord.
Let us see the impugned order was.
That is 5th of.
Yes, conflict between title deed and records of rights. Yes.
It only came out of the principle of conflict, my lord, in regard to the rights of records
No,
of
no,
rights.
no. The court records document to show that present plaintiff is the except the record of right. Further transfers for plot information slip that the suit property has already been recorded in the name of Subhendu.
My lord, in 24 it came into. My lord, kindly come to page number 152, my lord. The records of rights, my lord. My lord, it has been taken in 2024, my lord.
No, court also proceeds on the basis that the records of rights in your favor.
Yes, my lord.
That's why it says that title will prevail.
Yes,
Document of title.
that was the conflict came into. And these records were been taken in 2023 and 24. The copies of this.
Yes, Mr. Mahato, what do you say? There should be an injunction.
My respectful submission is, my lord, suit is not maintainable.
Why?
On 2 grounds. Suit is not maintainable
yes,
for
why?
2 grounds, my lord.
Yes.
First is non-joinder of necessary parties. And second is, my lord, he has not prayed for recovery of possession when he has admitted that I am in possession. Therefore, because of these 2 grounds, the suit is not maintainable. And if the suit is not maintainable, my lord, interim order cannot be granted.
Non-joiner of whom? Non-joiner of?
Yes. My lord, kindly.
They claim exclusive title.
No, my lord, I am showing to lordships. My lord,
Yes.
kindly. My written objection, I am handing over to your lordship. I have taken this plea in my written objection at page 12. There I have stated that the heirs of Sharadindu Samanto, who was a practicing advocate of this High Court, my lord, after his death, he had, my lords, 1 son, 1 daughter. Name have been given. My lord, this is my affidavit in opposition. I have taken this particular plea. But in the plaint, they have not made them party. But they have stated that the Sharadindu Samanto was one of the purchaser.
Sharadindu Samanto was a party to the deed.
No, subsequent purchaser.
Achha.
So, Banu, my lord, transfer in favor of Gopal Samanto.
The present owners only, whoever is challenging their title, they should be. Oh, acha.
He is also co-sharer. he is also in possession. Matlab Saida Banu Saida Banu transfer in favor of Gopal Samant. Gopal Samant had 4 sons.
Sharadindu is one of the heirs of Gopal.
Gopal.
Then he'll also have a share.
Yes. And another thing is, my lord, so far
Was that a ground in the impugned order? It was not a ground.
No.
Who did not consider that?
Yeah. But my lord, now at the time of when my lord is granting injunction, my lord, this point is required to be taken into consideration.
All right. What is the other point?
Other point is, my lord, in the plain there is admission that I am in possession. I have taken possession of the land. If your lordships kindly come to page 35. Paragraph 4. 8th line. 7th line rather. পৌরসভার সহযোগিতায় বহু লোকজন নিয়োগ করিয়া ক তপশিল বর্ণিত সম্পত্তি নাও মাইলর কাইন্ডলি পোক্তা পাঁচিল দ্বারা ঘিরিয়া তাহার পশ্চিম দিকের দেয়ালে একটি লোহার পোক্তা গেট ইনস্টল করিয়া
34 proviso comes in.
Therefore, suit is not maintainable. My lord, in a not maintainable suit, my lord, non-maintainable suit, injunction cannot be granted. My lord, it is well settled. I am relying upon a decision of.
What do you say to this? They have taken it in their. They are relying on your plaint averment and their objection, which was.
And prayer, my lords, there is no prayer for recovery of funds.
No, that is
only declaration. All
it has been said, I hope that is recovery is there, my lord.
Recovery has been paid.
No, there is no.
Let's see.
Cancellation is there, nullis.
All are declaration and compensation.
No, the cancellation is there. The GAW is there.
Cancellation
is also part of declaration. It's a prelude to declaration of your title. That's also in the sense. Yes. Rather, you have prayed for permanent injunction.
Yes.
Nature, character.
Yes. And my lord, I produced the record of rights in my name before I produced the trial before the trial court.
Well, the record of rights what had come out in 24, they came out with.
No, true.
Till that, I was in the possession, my lord.
Their admission, my possession, and record of rights.
But they are hitting the maintainability of the suit on these two grounds.
Well, because the construction, the defendant started a construction. That was the main reason we came into.
If you are claiming title to the property, then recovery becomes a necessary relief. Then the suit is prima facie barred by that. Maybe later on you can amend or do whatever. But as on the date of the impugned order, it was barred. We'll admit and decide the appeal itself. Dispose of the appeal itself. And do whatever you like to amend the plaint or whatever. The appeal, learned counsel for the appellant submits that the learned trial judge, while passing the impugned order, dismissing the plaintiff appellant's injunction, temporary injunction application, overlooked the fact that the records of rights stand in the name of the appellant and his predecessor. Full stop. It is submitted that the impugned purported sale deed was executed allegedly in the year 1965. And in the event the same was authentic, the transferees stroke his successors in interests, that is the present defendants, respondents, would have acted on the said sale deed and corrected the records of rights in their own names. So in the absence of the same, it is argued that the existence of the sale deed itself is vitiated. So next para, secondly, it is argued that the vendor in the purported sale deed, being a predecessor in interest of the present plaintiff stroke appellant, was literate, which is borne out by her signature put on the plaint of a partition suit, which was produced in the court below. So that despite the same, however, the learned trial judge failed to consider the fact that in the impugned sale deed, comma, an alleged left thumb impression of the said predecessor in interest Saida was affixed, comma, also without any statement that the contents of the said sale deed was read over and explained to the vendor. First up, it is submitted that in view of the above, comma, a strong prima facie case for grant of injunction was made out. Full stop. Next para. Learned counsel appearing for the which of the respondents, Mr. Bhatt?
Respondent number 1.
For the respondent number 1, for the contesting respondent number 1, submits that the suit itself is not maintainable in its present form, comma, which hits the prima facie case pleaded by the plaintiff stroke appellant. Full stop. It is pointed out by handing over a copy of the written objection to the injunction application filed in the trial court by the respondent number 1 that it was specifically pleaded that the suit was bad for non-joinder since the heirs of Sharadindu Samanto, comma, one of the successors of the transferee in the 1965 deed, comma, were not impleaded. Full stop. Next para. Moreover, comma, by placing reliance on the averments made in paragraph number 4 of the plaint, comma, it is argued by the learned advocate for the respondent number 1 that the plaintiff admitted the possession of the defendant stroke respondent number 1 in respect of the suit property. Full stop. However, comma, despite the same, comma, no relief of recovery of possession, comma, which was a necessary further relief, necessary other relief to be sought, comma, as a corollary of declaration of title, comma, was prayed for in the plaint. Full stop. Thus, comma, the suit was barred under the proviso to section 34 of the Specific Relief Act 1963. Full stop. Next para. Although we find from the impugned order that the same does not deal with the aforesaid objections of the respondent number 1, comma, it cannot be gainsaid that the said objections are not new factual aspects brought before this court for the first time, but are borne out respectively by the averments made in the written objection of the respondent number 1 to the injunction application in the court below, as well as from the averments of the plaintiff stroke appellant in the plaint itself, and hence, comma, both were before the learned trial judge while passing the impugned order, and ought to have formed a part of the consideration. Full stop. Thus, comma, although we find that an arguable case has been made out, and the appeal is accordingly admitted for hearing on the grounds as taken in the memorandum, comma.
The first appeal.
Oh, this is the first appeal. Not against
FMA,
injunction.
FMA.
No,
Sorry,
no, injunction.
That is order 39 rule 1 and 2.
Admitted for being heard on the grounds taken in the memorandum of appeal, comma, in view of the considerations of the connected injunction application being coextensive with the arguments of the appeal itself, comma, instead of unnecessary keeping the appeal pending, comma, we decide to take up the same. Full stop. In view of the above findings, comma, this court is of the opinion that the learned trial judge was justified in dismissing the injunction application of the plaintiff stroke appellant, comma, although on grounds different from those attributed in the impugned order, comma, which we have enumerated above. Full stop. Thus, comma, there is no scope of this appellate court interfering with the conclusion arrived at by the learned trial judge, comma, on the although on different grounds as indicated herein above. Full stop. Next para. Accordingly, FMA 470 of 2025 is dismissed on contest. Full stop. Consequentially, can 1 of 2024 is also dismissed. Full stop. Next para. It is made clear that this court has not entered into the not conclusively decided the contentions of the parties insofar as the suit is concerned, and it will be open to the learned court, trial court, to decide the suit independently on its own merits without being influenced in any manner by any of the observations made above. Full stop. It is further clarified that nothing in the above order shall prevent the plaintiff appellant from taking appropriate steps in connection with the suit if the appellant so deems fit. We stop short of granting him liberty to file the amendment application.
My lord, altogether, the issue was altogether order 39 rule 1 and 2. The non-maintainability never came into. This
No,
time
non-maintainability, it has been held by several, in
Yeah,
several
that
judges.
is there, my
You
lord.
know that that's a
Yes.
part of the prima
Yes,
facie.
my lord.
And there are also judgments, you know very well, that if the conclusion, if you agree with the conclusion on different grounds, we can supply the grounds, and we have done precisely that. We don't agree with the grounds given there.
Yes,
You have made out, that's why we admitted the appeal, but not at the order 41 rule 11 stage. You deserved an admission of the appeal, but ultimately we agree with the conclusion.
Obliged.
Thank you, Mr. We'll argue.
Obliged.
Yes.
Item number 43.
Lordship, I'm
Appellate,
hearing
your
for
lordship.
respondent, your lord. I
So
laid by
Banerjee was
Mr.
arguing.
Yes, your lordship.
Concluded.
Not today, kindly.
Not concluded.
Not today, kindly.
Not
proceed,
concluded, my lord. He was arguing, this is with regards to that inquiry proceedings. He was arguing he would
Grant
continue
not
today.
today.
He was arguing, still he will argue in the next day also. He's on the another
Very
bench,
well.
my lord.
So we are adjourning it for the day.
My lord.
On the prayer of the respondents, the matter is adjourned for the day.
Grateful, my lord.
Thank you.
Great.
My lord, Mr. Parthopratim Rai is appearing for the
It has not been called on.
Yes, my lord. I'm waiting.
Item number 44.
My lord, Mr.
Where is your brief?
My lord, but his brief is there, my lord, but
Start it. What is the matter about? Take out your paper book, come here.
lord, I'm not aware of the facts though, my lord.
What is your name, please?
Comrade Chakraborty, my lord.
Comrade Chakraborty.
Yes.
Yes. You said on the last occasion, I, as usual, have forgotten. Yes, sorry. What is the matter about? It arises from what sort of a proceeding?
My lord, it arises out from the
Mr.
judgment.
Chakraborty, take the microphone a bit closer to you. Yes.
Yes, my lord.
It arises out of what sort of a proceeding?
It arises out from, my lord. Original suit number 10 of 2008, my lord.
Original suit means suit was for what?
For, my lord, the same status. And তারা নেই।
No, appeal of the respondent.
The will was executed before it was drafted by the scribes. The court has literally translated the Bengali saying that
Yes, my lord.
the rice taking ceremony of the child took place before the child was born. That is the exact expression used. ছেলে জন্ম হওয়ার আগে অন্নপ্রাশন হয়ে গেছে, মুখে ভাত হয়ে গেছে। Your probate application was dismissed.
Yes,
Lord, I'm led by Mr. Anjudu Chatterjee. Lord, if he wants to start, Lord, I have no problem. Lord.
Yes, obviously you have no problem.
May I conclude on the next day, Lord, if
You argue what are your points in the. I will say start with you.
no, Lord, kindly.
Why not? You have no objection if he starts, you start.
No, but the
You
thing
tell
is-
me on what grounds the probate was rejected. Support your grounds.
The thing is, we were ready with it. I don't heard it substantially, but previously, we had the point of substitution was raised
On the prayer of the parties, let the matter stand adjourned for the day.
for the day. But can you fix a date? But we should come.
Very sorry. You cannot make both prayers in the same breath. Yes.
Item number 45.
Respondent.
My lord, I am for the appellant.
KMDA.
Led by Mr. Sotiri Kalota and Sharma.
KMDA is the main respondent. Yes, Ms. Agrawal, you're for the appellant.
Yes, my lord.
Can't hear you at all.
We are led by Mr. Advocate General also.
Advocate General will never be available unless you start the matter. He has other important things for the state to do.
My lord, may I just file a supplementary paper book, my lord? One data was not there.
Ms.
It will be the leave on the last.
Have you handed over copies to them? Yes. Yes.
My lord, in brief, if I say, my lord, in fact, on the last occasion, your lordship had put me the question that why didn't I file a writ petition? The thing is, my lord, we had filed the writ petition. Then, my lord Justice Biswas was of
That
the
would save time.
that no, he was of the view that it is a contextual matter, therefore it will not lie. And then we preferred an appeal, and the appeal court had directed us to file the suit.
Then not your fault.
So we had filed the suit.
Very well.
Now, my lord, this is a matter, my lord, that my lord on 10th, I'm just looking for one copy of the list of dates after now. I may just hand over a copy of the list of dates because they are
Please.
posthumed as
Absolutely.
dates. My lord, on 10th of January 2003, my lord, a notice inviting tender was issued by the Kolkata Metropolitan Development Authority for grant of lease of a plot of land at East Kolkata, my lord, opposite to Ruby General Hospital. My lord, this is a plot, my lord, when we go from Kasbah, my lord, on the crossing of the Rajdanga main road, my lord, it is a plot on the left hand side, my lord, just opposite to Taj Vivanta, my lord.
Opposite to?
Taj Vivanta Hotel, my
Taj Vivanta, right.
Now, my lord, our client participated in the notice inviting tender, my lord, and my lord was found to be the highest bidder. In terms of the notice inviting tender, my lord, he deposited the money. And then, my lord, there was a clause that if you deposit the entire money in one go, then you will get a rebate of 5%. That was being done, my lord. My lord, when initially, my lord, in the notice inviting tender, my lord, some of the clauses I mentioned in my list of dates, my lord, also, that is most important. The plot will be offered on leasehold basis to highest bidder for a period of 99 years with an option for renewal for a like period.
Have you given a copy to them?
Yeah,
You have. Yes.
Subject
Please
to
continue.
mutual
Yes.
consent of the lessor and lessee. Now, this is one of the vital clause, my lord. The
Right.
second clause was the allotee may be allowed to sublease property with suitable compensation as decided by the authority of KMDA. Then third clause was, my lord, construction on the plot has to be commenced within a period of 3 years from the date of execution of lease, according to the approved plan of the Kolkata Municipal Corporation, failing which the allotee will be liable for compensation as decided by the authorities. Number 9 has been omitted. What are the Just a second, my lord. One term is missing. The lease of land will fetch the provisions of Income Tax Act, if any. Well, these are the basic clause, my lord. In terms of this, we had participated. So, my lord, when I participated in the tender, my lord, one thing was quite clear that my client will get a lease for 99 years, my lord, with a right to seek for renewal for further period of 99 years. And then he will be entitled to sublease. My lord, this was the basic terms and condition. In accordance with that, my lord, we had participated in the auction.
You came out successful.
Successful. And there is no default. We have made the entire payment. In fact, we had got the rebate of 5%. My lord. Then
So,
my lord,
deed was executed in your favor for 99.
that is the issue lies here, my lord. Then, my lord, kindly take on 28 January 2023, my lord. Thereafter, my lord, after 28 January 2023, my lord, when we were given the offer to avail 5% discount by making the total premium.
This should be 28 January 2003.
2003, sorry.
Right.
It is the typographical
No,
error.
it's all. Yes.
Then, my lord, at this stage, my lord, the KMDO authorities, my lord, had called upon us for a discussion, saying that the title from the land acquisition department is not yet clear. So until unless the title is clear and the lease deed cannot be executed.
But they themselves floated the tender.
Yes, they themselves floated a tender. And my lord, on the basis of that, we participated. Then, my lord, we were told, my lord, that within a very short span of time, my lord, the land acquisition department will confer the title upon the KMDA, and thereafter immediately we will execute the lease deed in favor of the client. Now, my lord, in the meantime, my lord, as a stopgap arrangement, my lord, the authority suggested that we will execute a license deed in your favor and we will put you in possession of the property. And we agreed to have the license deed executed on condition that this license deed will be automatically converted into the lease deed.
That
And it will
license
be-
deed you have annexed here.
Yes, I have annexed here. My lord, none of the documents are disputed, my lord. In fact, my lord, in trial court, they have annexed only 2 deeds, my lord. Apart from that, my lord, the defendants have not disclosed anything. Now, my lord, this was one of the clause that it will be automatically converted into lease deed, and KMDA was fully responsible for having the lease deed executed in favor of our client.
When was that license entered into? Date?
Well, it was 11th of May 2023.
11th
show
of
the
May
document, my lord.
2000. Yes.
I'll come to
11th of, you have not given the
22nd of May 2003.
22nd of May, right.
22nd of May 2003. I shall show the document, but in nutshell, my lord, in brief, I am making.
Yes, yes, absolutely.
Thereafter, my lord, in terms of this, my lord, when we took possession, physical possession was handed over. After 1 year, my lord, the layout plan was given. In the meantime, my lord, there were several parties, my lord, who contended themselves to be the owner of the property. Several suits were filed, writ petitions were filed, 144 proceedings were filed, which, my lord, status quo order was obtained by some of the parties, my lord. As a result whereof, my lord, though we were put in possession, my lord, we were not allowed to do anything with the plot of land. But in the meantime, my lord, since my client, my lord, is engaged in the business of food, my lord, and food processing industry was willing to set up, he prepared all the groundwork to set up a food industry over there. He applied for explosive license, bulk LPG gas, this thing, electricity. Then he also submitted a sanction building plan with the Calcutta Municipal Corporation, my lord. In fact, my lord, in the meeting of the MIC, my lord, it plan.
You can take your seats. Both of you can take your seats. Yes.
Oh, sir.
Yes.
In the meeting of the mayor in council meeting, my lord, building committee, my lord, the plan was approved, my lord, as subject to some of the clearances, my lord, which we also obtained, my lord. My lord, there was no default or no laches on the part of the appellant, my lord, in to have the property being developed as a manufacturing unit. But in the meantime, since, my lord, the original tender, notice inviting tender, contained a clause that we should be given the right to sublease after execution or prior to execution of the license deed, my lord, we requested the authorities that you grant us the power to sublease. That power to sublease was also granted, my lord. There are umpteen numbers of letters, my lord, I shall place before lordship. We had requested the respondent authorities that you execute the lease deed in our favor, my lord. None of the letters were being replied to, my lord. The lease deed was not being executed, my lord. My lord, the corporation authorities, my lord, municipal authorities, my lord, though, my lord, every sanction fees was being deposited and plan was being cleared, my lord, but in want of the lease deed being executed in our favor, my lord, the sanction plan was not released. Number of letters were being written. Now, my lord, on all of a sudden, my lord, in the month of December, 30th December 2007, my lord, a SOCO's notice was being issued, my lord, that my client had contravened the provisions of the license deed, having not completed the work of construction within the period of 3 years, my lord. This is one of the basic clause, and other 2 clauses were being taken. And we were called upon to show cause. We replied to the said notice. We appeared at the time of hearing, my lord, but we were not allowed to give any participate in the physical hearing, my lord. The written submission was there. We annexed all the documents. We produced all the relevant documents, showing that we have complied with all the terms and conditions.
You had made a construction. You said you made a construction.
We had taken all the steps, including the setting up of LPG gas bank.
But you had
and
not made
explosive
the
license.
construction.
No, we could not, because without the plan being sanctioned by the Kolkata Municipal Corporation, my lord, no construction could have been made. However, there was a structure over there, my lord, of measuring 2,000 square feet an area odd where my client had started running its showroom over there, my lord. That was being done, my lord, and it was being done for substantial period of time, my lord. In fact, when 2008, then thereafter, my lord, they cancelled my license deed. That I have not completed the construction within a period of 3 years. This was challenging the same, my lord. We filed the writ petition before this honorable court. They tried to take possession of the land in the year 2008, my lord. We intervened. Then, my lord, we approached this honorable court. Then the writ petition was being heard by my lord Justice Janto Kumar Biswas for a substantial period of time. Then the writ petition was dismissed on the ground that the writ petition is not maintainable on the contractual matter. It is a contract between the KMD and the petitioner. Thereafter, we preferred an appeal. The division bench relegated us to a suit. We filed the suit before the Alipur court, my lord. My lord, in the suit, my lord, we had produced and exhibited all the documents to show that there is no delay and laches on our part. The entire premium in respect of the land was paid by my client, my lord, within the time stipulated. In fact, for the timely payment, my lord, and a one-go payment, 5% rebate was being granted. And thereafter, license deed was merely a stopgap arrangement. And
Where the main allegation was that you had not made construction within 3 years.
3 years.
Regarding the other parts, there was no
They are
substantial
not
condition.
very relevant. In fact, I shall show, my lord, the
Yes.
SOCO's notices have other clause, and my termination is on other clause.
So basically, your grounds are threefold on that construction. One is that you applied and obtained all these necessary certificates. You did your level best. One. Secondly, you were running a very small showroom from a part of the structure. Two. Thirdly, more importantly, KMC was not granting this sanction because there was some cloud regarding the title. According to KMC.
Yeah, according
And
to
your
this.
clause said that you have to make construction within 3 years as per approved plan of the KMC.
KMC.
So KMC
Now,
plan
my
was not being given, therefore you
That,
could
that
not.
was one of the reason, my lord.
Right.
Now, my lord, the basic issue, my lord, that has arisen and emerged in this case is this, my lord, whether my client had was a mere licensee, or the circumstances of the terms and conditions were that my client was a lessee with the KMDA.
But the deed said that you are a licensee
No.
because this could not be given to
I
you.
shall place to your lordship the case that they have run in the written statement and the document they have disclosed. According to them, they had the title deed in 2006 and 1992. Then, my lord, it was not my fault. It was incumbent upon them to execute the deed of lease in my favor. These are the only 2 deeds, my lord, which have been disclosed as the defendant's exhibit.
So they had title in the property.
According to them. Because, my lord, I do not find, my
But
lord,
it was contrary to the statements recorded in the license deed.
it was contrary to the statement, and since the KMDA was holding the property.
Yes.
And KMDA was in a better position to say whether the KMDA had the title deed at the title over the property at the relevant point of time or not, my lord.
So those are exhibits A and B.
Yes,
All right.
my lord. Now, my lord, this is the basic. In the meantime, my lord, what had happened, my lord, that in the suit, my lord, the court below, my lord, had dismissed the suit merely on the ground that the pollution certificate was obtained by me in the year 2006.
6.
This is the only sole ground on which my suit has been dismissed.
So what is your answer to that?
My lord, in fact, my lord, before obtaining the pollution license, my lord, we had to obtain various other licenses and all documents have to be supplied with. These we have arranged for. And there were order of injunction, order of status quo, which debarred us from dealing with the plot, my lord, in any manner whatsoever by third parties, my lord. In fact, there are later gallows, my lord, where the KMDA, in fact, tax has not been paid by the KMDA for the tenure for which they were required to be paid. Then we had applied for electricity, explosive license, all other relevant licenses, more than 35 to 36 requisites which were to be complied with were all being done by our client, my lord. There was no delay, no default. And a huge investment was being made in procuring all these licenses, my lord. My lord, kindly first, my lord, I shall show that the notice inviting tender, my lord. My lord, I have annexed a copy, my lord, but since it is in a color, my lord, Xerox, my lord, there are black spots. So I prepared a color copy for your lordships.
Whatever you hand over, Ms. Van
Yes,
Peekel,
there, my lord, I'll just give him after reading it out.
after hearing, what is the use of giving?
No, after reading it out, my lord.
Oh.
I'm not saying that after reading. I'm just now I'll give. I'll make another color Xerox also, but it is annexed to the appeal also, my lord, exhibits part of that. But the clauses which I had
This is the brochure, this is the tender document.
tender document. And in terms of this tender document only, my lord, that we had applied, the plot number C5, my lord, you will find on the top, is there, my lord, and this
Yes.
is the plot on the Raspberry connector. Now, plot will be, my lord, that was the main term and condition, that plot will be offered on leasehold basis to highest bidder for a period of 99.
If this is not disputed, then why are you placing? I mean, need not.
There is no dispute. There is no dispute with regard to
If
this.
unless you want to rely on any particular clause or
Yes.
something.
No, my lord, only clause 8 kindly.
Clause 8 is the relevant clause, yes.
Yes.
They rely on that.
Clause 1, my lord, I'm not reading the entire one.
Need not.
Then, my lord, kindly come to clause.
1, 2, and 8 you have already placed
Yes,
for us.
8 is very important. My
Very
lord, kindly
important.
see
Yes.
the difference. Construction on the plot has to be commenced within a period of 3 years from the date of execution of lease deed, according to the approved plan of Kolkata Municipal Corporation, failing which the LOT will be liable for compensation as decided by the authority.
No, but they did not execute a lease deed according to them.
No, yes.
So therefore, the time limit did not start.
Time limit did not start. However, the license did have their time limit, my lord.
But your case is that was a lease. So
That
therefore,
was a lease. Kindly see, and it was, if there was any delay, my lord, at best they would have been entitled for compensation and not to cancel the entire deed, my lord. Now,
no, you will be entitled to compensation.
I no, if there is any delay, my lord, in making construction, that I shall be liable to pay.
Construction on the who is the allotee? You are the allotee.
I am the LOT. LOT will be liable for compensation as
Oh,
decided.
acha. Right.
So I shall be made liable to pay the compensation.
Right.
Paper book the account.
So they cannot cancel the contract.
They cannot cancel the contract. Now, my lord, in fact, what has happened, my lord, there is a connecting application also. During the pendency of the appeal, my lord, they had tried to take forcible possession of the plot of land, my lord. We immediately filed an application for injunction before the Honorable Division Bench, my lord, presided over my lord, my lord Justice Sen and my lord Justice was also there. Your lordship would remember that when the matter was going on, my lord, KMDA with the help of bulldozer demolished my entire shop, break open the boundary wall, and installed a gate to take forcible possession, my lord. And then this honorable court had recorded the same and it passed an order of injunction, my lord. And my application is there for restoration of possession, my lord, which is Ken number 4 of 2022, my lord. Now, first of all, I shall take your lordship to the letters, my lord, after I had made the payment, full payment to the authorities concerned. Second volume, Dada. My lordship takes the second volume which contains the documents, my lord, exhibits.
Yes.
Kindly take page exhibit 4, my lord, the first annexure at my lord, page 5. We have made an offer for premium price for lease with a right to sublease of the above plot, but during the discussion with Mrs. Roshni Sen, special
Page 7.
page 5.
5 is a continuation of this brochure.
Yes. No, my lord, it is a
5 is the continuation.
Yes.
This is what.
Then my
Letter,
lord,
letter is at February
number is
11th.
mistake.
February 11th February letter.
11th February 2003 letter.
That is page 7. As per your index also. Thank you.
Yes, yes.
Okay.
My pagination is wrong.
Yes.
We have made an offer of premium price for lease with a right to sublease of our plot, but during the discussion with Mrs. Roshni Sen, Special Secretary Land, we have come to understand that the title of property was not yet cleared from LA department, and she suggested us at present the plot will be registered as a license deed, and the said deed will be automatically converted to lease deed with a right to sublease after clearance of title from LA department. In this connection, we inform you that we have no objection to register the plot as a license deed, which will automatically be converted into lease deed after clearance of LA department, and your department will take full responsibility for clearance of title from LA department as assured to us. This was the first letter, my lord, 11th of February.
This was your offer.
No, we had accepted their offer, recording that it was being offered
Achha.
by Mrs. Roshni Sen, Special Secretary,
Right.
which we had agreed to accept by
Yes.
this letter.
Right.
Huh? Chalo.
I do not know whether my junior has said or not. In this matter, my lord, I am led by the learned Advocate General.
We told him in answer that Advocate General will always be busy in some greater matters of the state.
Standing counsel is there also engaged here.
You are there, that is sufficient. Yes. Let us continue with
In
you.
fact, my lord, my learned friend was throughout in the proceedings, from the starting from inception to
If
the
throughout Advocate General was briefed, whoever was the Advocate General, he would be busy otherwise. Yes.
Then, my lord, this next exhibit is not so relevant, my lord. I shall not. That we had submitted the project report. Then kindly come to exhibit 6, my lord. Which is
Page 10.
Page 10. Page 10. This is to inform you that the KMD authority of competent authority of KMD has accepted your sealed bid submitted on 24 January 2003 and willing to offer you an allotment of land measuring more or less 122 kathas bearing number C5 at the East Kolkata Area Development Project at the rate of rupees 6,60,111 per katha on license basis in terms of application dated 11th February 2003 for establishment
It was still using the old letterheads. Stingy of KMDA. Very miserly. See, they're referring to themselves as KMDA, but they use the CMDA.
Calcutta Metropolitan
CMDA.
Lord, the word Calcutta still has a charm, my lord, like High Court, my lord.
Logo is not changed.
Logo is not changed. Oh.
Logo has been changed. Or it is CMD only.
Logo has not been changed. KMD, the name has been given changed.
We still follow this logo.
Oh, acha, it's still till date you are for acha.
Yes.
All right.
At the right hand side,
Yes, is that.
Calcutta Medi.
Anyway, yes.
For establishment of a supermarket cum food processing unit, along with residential facility for company management and staff, only compatible with the project report submitted by you video later dated 4 December 2002 and subject to necessary statutory clearances and clearance from the West Bengal State Pollution Board. Then we were called upon to pay 5% of the total premium amount, my lord, as a token of acceptance. Then, my lord, next page, page 11, my lord, contains the manner in which the entire amount is required to be paid, my lord. There is no dispute about it, my lord, that it has been made. Then, my lord, page 12, my lord, a 5%, clause A is important. The land shall be allotted on license basis for a period of 99 years for the present. License deed will be converted into lease deed in due course. A 5% rebate on the entire premium will be admissible if the same is paid in one installment within 15 days from the date of issue of the letter. Then, my lord, that rebate was being granted, my lord. Then kindly come to page 12. This offer letter, my lord, was accepted by us on 20th of February 2003, wherein, my lord, we have again recorded, my lord, that we have a right to sublease and that lease deed, license deed later automatically.
If you say that this is an offer letter, then the previous one was not a concluded contract.
That-
It was not an acceptance.
Yes.
It was reopened then. You said the previous exhibit 4 was your
4.
was your acceptance. Then where is the question of a further offer and a further? Anyway, you have
But
treated
then
this two.
authorities have written it as an offer, my lord.
Even
but
if you forget the previous one, this remains.
the same, it is same.
Yes.
Then we have again recorded that later automatically converted into lease deed after
Yes.
clearance of right and title from LA department by KMDA. And
You are reading page
page 14.
14. Yes, right.
14 hour later, my lord.
Acceptance.
And by this letter, my lord, we have recorded that we are going to avail the 5% rebate by making the entire payment in one single installment, my lord. And we had, in fact, in the bottom of the letter, lordship will find there's a note for the special secretary. As per the discussion had with you on 19th February 2003, after receiving the offer letter about sublease right of the plot, you have assured us that the same will be mentioned in. You will, which will, yes, the same will be mentioned in the license deed, which will be automatically converted into lease deed after clearance of the right and title from LA department. On or verbal assurance of subleasing right of plot, we hereby accept your offer. This is for your information and taken of acceptance. Then, my lord, the first payment, my lord, is on page 16. The payment was made, 5% amount. Then exhibit 8 is the plan, my lord.
But in their offer at page 11, 12, they don't say it will automatically get converted. Because your offer was somewhat different. You had said it will automatically get converted after clearance of LA department.
LA department.
But in at page 12, they say license deed will be converted into lease deed in due course.
I shall show your lordship the lease deed also, license deed also.
All
the
right.
clause. But, my lord, they have never disputed the contention made in our letter. My lord,
Very
there is no reply.
Good.
Then, my lord, kindly come to the 7th March letter, my lord. In continuation of the above letter of allotment, you are requested to make payment of the premium amount in respect of the allotment of land. Then, my lord, they had calculated the 5% rebate, my lord, and the entire amount of 7,24,12,834, my lord, was paid by our client, my lord. The total price of the land was 8,04,69,511. Then 10% service charge after deducting the same, it came to 7,24 lakh. And, my lord, the remaining amount was due and payable was 6,83,89,358. My lord, one letter is, your lordship will not find. That is in the supplementary paper book, দিয়েছি আরো নিন কি আছে আপনার কাছেও আছে আচ্ছা ঠিক আছে পাঠিয়েছি আমি No, my lord, this is a letter of 6 March 2003, my lord. Along with that, the plan was given. This is the letter of allotment, my lord.
This is a letter of
Allotment.
allotment.
In reference to the above letter, this is to inform you that a plot of bulk land measuring 122 katha was offered to you by the competent authority in KMDA for establishment of a supermarket cum food processing unit along with residential facility for company management and staff. Now, in view of your acceptance of the above offer and on subsequent deposit of 10% of the total premium amounting to rupees 80,56,677 as security deposit, the plot measuring 121.903 kata as per site plan in plot number C5 at ECADP is hereby allotted in favor of your company at the rate of rupees 6,60,111 per kata at a total premium of 8,04,69,511. Then, my lord, terms and conditions are annexed, my lord, in that. Now, my lord, for the first time in the letter of allotment, my lord, your lordship will find it contains the same clauses are like the offer. The relevant clauses your lordship will find 1, 2, 3, and then your lordship will find 5A.
5A, right.
5A.
That same thing.
Same thing.
Due course and all. Yes.
But apart from that, these clauses are not relevant, my lord. Now, my lord, only one clause on which I would like to rely in this, my lord, the last clause, which is very important. The terms and conditions, as mentioned above, are not exhaustive. The allotee, after fulfillment of the terms and conditions above, will have to execute and register a lease deed, which shall contain detailed terms and conditions of the demise in due course. So, my lord, the letter of allotment itself says that a lease deed will be executed and registered in favor of the appellant, my lord.
So therefore, this is not the lease deed.
This-
You are making out a contradictory case.
No,
In one breath, you are saying that a lease deed was given to you. The license was a lease deed.
no. What I say that license deed was executed was a stopgap arrangement.
No, but
Was
you
not the
argued
full document.
during course of arguments. You said that the license deed should be treated as a lease deed.
No idea. Sorry, my lord, if I might have.
Whether it was mere license or a lease, that is to be considered. That is your submission.
My submission is that though there is a license deed, my lord, but the actual intention of the parties was to execute the lease deed in my favor.
Later on.
Later on. Because according to them, the title of the land was not clear, and it is because the title of the land was not clear that the lease deed was not executed by KMDA in my favor. So, my lord, but ultimately it was the lease deed which was required to be executed by the KMDA.
So
And
this was not the lease deed. This was a license
This
deed.
was a license
But
deed.
intention was to create.
Create a lease deed. That was the condition of the notice inviting tender, and the letter of allotment itself says, my lord, that detailed terms and conditions of the demise in due course, it is a lease deed. Allotment letter itself says that a lease deed, and the license deed was executed, and our client agreed to have the license deed executed because according to the KMDA, the title from the LA department was yet to be cleared, my lord.
That was to be after the fulfillment of the terms and conditions above.
Above. And though there is no dispute.
This construction within 3 years finds place here.
No. Let me see, my lord. Let me see. No, I don't find.
It is conspicuously missing here.
It is not there, my lord. It is not.
And these are different things.
No, it is not there.
No.
That clause is not there, my lord. In the allotment letter, it is not there.
No.
Now, my lord, this was the allotment letter, my lord.
Hmm.
In terms of this allotment letter, my lord, we had accepted at page 18, exhibit 10. Page 20, sorry. Wrong page. Page 20, my lord. Because since allotment letter had a clause, my lord, 10H, which prohibited us from transferring. The allotee shall not transfer possession of land and no structure erected thereon, and shall not transfer any interest over such land and structure thereon to any person without the previous permission of the authority in writing. In case of such unauthorized transfer, the allotment shall stand cancelled and the property would revert to the KMDA, which shall have the right of re-entry into the land, my lord.
But these terms and conditions are then different from the original offer and acceptance. Because there you are given a right to sublease.
Yes.
Subject to compensation being decided.
Yes. Therefore, my lord, when this allotment letter
Which
came,
are you relying on? This is the final one.
no, this is the allotment letter which they gave.
Huh.
So immediately, my lord, we took objection to this. Immediately, your lordship will find that at page 20. Because we were strictly relying on the notice inviting tender.
Yes, right.
We draw your kind attention on para 10H of your aforesaid allotment letter, which is contradictory to the object of the project. We mention here under the detailing of para for your ready reference.
Yes.
Sir, now after this, my lord, we are writing at page 21. Sir, on the one hand, you are allotting us a land for the purpose of establishing a supermarket cum processing unit cum residence for management. But on the other hand, you are restricting us to transfer and sublease the land and not structure thereon, which is prejudicial to the object of the project. We would also like to refer to our letter dated 20th February 2003, wherein we have accepted your offer letter only after the verbal commitment of allowing us to sublease the plot of land or structure thereon from all related senior officers. Then, my lord, again, my lord, page 22. While we were making the payment, my lord, we again said the aforesaid payment was made subject, second paragraph of the page 22, my lord. The aforesaid payment was made subject to amendment in clause 10H of your allotment letter. Otherwise, object of the project will be jeopardized as requested in our letter dated 10th March 2003. And subsequent discussion also had with you and all related senior officials of KMDA. We further request you to kindly hand over the physical possession of land immediately and execute the license deed, which will be automatically converted into a lease deed at your earliest, with a right to sublease the plot and land or construction thereon.
During this period, you had been making payments.
Yes, we have paid subject to the clause being amended. And, my lord, they had accepted the payment, my lord, and in fact, my lord, I shall show to your lordship.
So your part of the thing you have done.
Yes.
And did you apply for any certificates or whatever is necessary?
Yes, my lord, I shall come to now, my lord, page 31st, my lord. I'll show you, my lord, they have given us the right to sublease also. I shall come. My lord, on 21st of March 2003, my lord, at page 30, in reference to your letter, I'd like to inform you that since you have paid the full premium of land measuring 121.903 kata, amounting to rupees 8,04,69,511, only on outright basis, in respect of plot number C, this is very important, my lord, kindly note the term. In respect of plot number C5 at ECDAP, you are requested to kindly contact the concerned executive engineer to take over the physical possession of the above land, my lord.
No, you have changed your logo.
Yes.
You are not right. Page 30.
No, no, my lord, what they have changed is the.
KMDA, it has become
indicated
KMDA.
No.
Called
Right hand-
CMDA, logo is CMDA only.
Logo maybe,
Right,
but,
logo.
but this right hand side also,
Right hand
there it was written Calcutta,
Calcutta to Kolkata.
Calcutta at page 12.
Then, my lord. Now, my lord, some of the letters I would skip right now for the time being, because, my lord, I shall come first to the sublease clause. Kindly give me a minute, my lord.
Yes.
My lord, I'll show that. Let me continue continuously, but I shall show to your lordship a letter whereby the right to sublease was given to me, my lord. That is an admitted possession, my lord. Now, my lord, when we took possession,
But there are several letters. Let us come to the important one.
yes, I'm not showing you.
The terms of the license, what license was,
Yes.
these are all, or deed of license is at page 40.
I'll come that. Before that, my lord, just I would like to show the one letter of 3rd April 2003 that we were being obstructed in taking physical possession and carrying out any activity.
Yes.
Therefore, my lord, KMDA had written the letter to the chief engineer, KMDA, internal to another officer, my lord. Haldiram Limited made a reference to this office by letter dated 2nd April 2003 that when they engaged some laborers for their work, some policemen from Kasba police station had forcefully stopped the work. I find no
This
justification.
is which page?
Page 34, my lord.
Yes.
We have written a letter at page 32
Hmm.
that some persons are objecting and preventing us, our laborers, from entering into the place. So the KMD had written that there is no justification and we should be allowed to carry on the work. Then on page 35 is records that we have taken the physical possession on 26th of March. Then we will kindly come to page 36. My lord, here we have said that we have come to know that a writ petition is being filed before the High Court at Calcutta and an order of status quo has been passed. This is being recorded in this letter. My lord, we were from the middle, if I read, upon physical possession of the property being handed over to us while commencing construction of the boundary wall of the same. We were, however, prevented from doing so by the Kasba police officials on the basis of an order for maintaining status quo passed by the Honorable High Court at Calcutta on 20th February 2003 in a writ petition being WP number 1920W of 2003 filed by Gauri Shankar Roy and others inter alia against the KMDA. It has since transpired that in the said writ petition, the petitioners have inter alia questioned the right, title and interest of the KMDA over and in respect of the property sold to us. We are surprised that no step was taken by the KMDA to inform us of the filing of the said writ petition or of the orders of status quo passed in the same. We have till date also not been informed as to what steps has been taken by the KMDA to have the said order of status quo vacated. And then we said that it is delaying the entire project, my lord. This was being recorded.
Hmm.
Then, my lord, we have applied for the grant of electricity on 13th of May. Then comes, my lord, the license deed, my lord, the main document, my lord. which is the sole subject of the sole controversy.
What is this page 38?
Page 30.
Another handing over.
Actual handing over.
No, my lord, here by this, my lord,
With the
drawing.
Handing over permissive possession.
Of bulk claim. Actual handing over took place on 29th of April 2003. But your lordship will notice one thing, that in none of these letters or in the notice inviting tender, my lord, dark numbers were not there. Moja is not there, in which Moja it is situated. It has been described as plot number C5.
Yes.
This your lordship will notice.
Yes.
And if when we go to the document which my learned friend produced, my lord, we are yet to ascertain whether our deed, my lord, of the land which has been allotted to us, my lord, were formed part of those lease deeds or not, my lord. It is for the KMDA to explain, my lord.
As per the diagram, this is the corner plot of the bypass and RB connector.
Yes, it is a corner plot.
As per their
Yes.
brochure.
It is a corner plot.
in plot now.
Yes, but there must be some moja.
Yes, yes,
Some
definitely.
moja, some dark numbers.
So we meant to say that they cannot deviate from that the location of that.
Location
plot.
they cannot deviate. But whether they, if they had the title deed, my lord, in their favor
Right,
at
right.
that point of time, my lord, that then it was
They cannot show some other plot and say that this is C.
yes.
Because the location is evident.
When they had their title over the property, then what prevented them from executing the lease deed in my favor in the year
Where do
2000?
they say first that they had title? They have all along been denying that they had title.
They during course of evidence for the first time.
That will be beyond the proof pleading beyond the pleading then, because if they did not plead title,
No, in the written statement, they have said that they had a title.
they have title.
They say that the entire proceedings on the from the part of the land acquisition department was not clear. Because the land is to be acquired through land acquisition department and then the deed has to be executed in favor of KMDA. So this part, according to them, was not clear. It will be evident from page 40, my lord. Page 40 is the deed of license dated 22nd May 2003. Page 41, kindly come, my lord.
Yes, yes.
Whereas the licensee has applied to the authority for a lease of the plot of land in the East Calcutta Area Development Project mentioned and described in the schedule hereunder written, which is in the process of acquisition by the state of West Bengal. Well, this is very important. For the purpose of the authority under due process of law. So, my lord, from this, they say that it is in the process of acquisition by the state of West Bengal for the purpose of the authority under due process of law. And whereas the authorities is not now in a position to grant any lease of the after mentioned land in favor of the licensee.
But KMDA previously given impression that it was unencumbered.
Yes.
They wrote to you also.
Later also they
Later also, yes.
Also. And
Page 34.
Page 34.
Page 36. No, page 34.
34.
34, they clearly say that possession is free of encumbrance.
The land is free from all encumbrances.
Yes.
But the license deed, my lord, it records something else. Whereas the authority is not now in a position to grant any lease of the aforementioned land in favor of the license. Then, my lord, kindly come. Paragraph 2. And whereas
yes,
to grant a license in favor of the licensee for the time being. So it was that the license deed was not the only document which was required to be executed in my favor. On the contrary, it was for the time being, till the process of acquisition is not completed or the title is not clear.
Yes.
Then, my lord, kindly come to clause 2. The license under this deed shall be deemed to commence on the date of these presents, as shall continue to be operative till the execution and registration of a deed of lease in respect of the above mentioned lane between the authority and the licensee, or till the expiry of the period of 99 years from the date of its commencement, whichever event occurs earlier. So, my lord, it speaks about the execution and registration of a deed of lease.
একটু টেম্পারেচারটা গরম করা যাবে, রিমোটটা জোগাড় করুন, রিমোটটা দিন। Please continue. Yes. Yes. So this shall continue to be operative till execution of deed of lease.
Lease. Then, my lord, I shall take your lordship to clause 6 at page 42.
Yes.
Not to subdivide and or sublet the land or any building to be constructed thereon, without the previous consent in writing of the authority, which consent the authority shall have the right and be entitled to refuse at its absolute discretion. Then, my lord, kindly come to the next clause.
Therefore, they retain that.
That written. I shall show, my lord, it has been diluted later.
Yes.
Not to assign or transfer the land or any part thereof, or any structure or constitution erected thereon. Construction, it should be.
Construction, yes.
Thereon, or any part thereof, without the previous permission of the authority in writing. In case of such transfer or assignment of the land or structures and or constructions thereon, without such permission of the authority, the license shall stand terminated. Then, my lord, kindly come to page 44.
But if it's to be a supermarket come food processing, you have to transfer.
I have to transfer, they have given it later on. Then, my lord, clause 4.
Yes.
Page 44. Upon completion of process of acquisition of the land hereby licensed, and the transfer of the title to the said land in favor of the authority by the government of the state of West Bengal, the authority shall grant and the licenses shall accept a lease of the said land described in the schedule hereunder written for a period of 99 years commencing from the day, month and year above written, on the terms and conditions, and on such other terms and conditions that may be agreed upon between the parties. Therefore, my lord, your lordship will find this license deed was for the time being.
Yes, yes.
And it has stopgap arrangement, my lord, till the title is clear and the lease deed is not being executed.
Right.
Now, my lord, I shall show your lordship the clause of which they have taken shelter and they have cancelled my. That is page 42.
42.
Yes, clause 3. 5 Roman III.
Yes.
At the own cost of the licensee, within 3 years from the date hereof, or within such further time as the authority may at its option allow in writing on sufficient and reasonable grounds to erect, construct and complete the proposed supermarket cum food processing unit along with residential facility with boundary walls, sewers and drainage in accordance with plans, sections and specifications as shall be approved by the appropriate authorities on payments of such fees as required in accordance with the building rules of the Calcutta Municipal Corporation, with the requirement of any land use and development control regulation of the authority, or the requirement of any other statutory rules and regulations of any local or statutory body framed for the purpose. Now, my lord, this is the clause, my lord. They say that I have committed breach. But, my lord, this clause itself does not say that if I do not complete the work of construction, my lord, then my license will be terminated. However, my lord, to this, my lord, they refer to 7I. like, my lord, in the notice inviting tender, my lord, I had shown to your lordship that if I don't start the commencement of the work, the authorities will saddle me with the compensation. But the license deed does not say, my lord. It says that within 3 years I have to commence, and then in accordance with the building rules of the KMC and other.
So this read with 7.1 give them a right according to them
According to them.
to re-enter.
Yes. If there, Pro 7.1, if there by any breach of any covenant on the licensee's part herein contained, and to be performed or observed by the licensee, it shall be lawful for the authority at any time hereinafter to re-enter upon the land after determining this license. Now, my lord, I shall make a distinction here, my lord, that the license deed had this clause, my lord, but the notice inviting tender, my lord, did not have the clause to re-enter.
But you agreed and entered into this.
My lord, that was a stopgap arrangement, my lord. I say that I have, but your lordship will see that this clause 3, my lord, it cannot be said that time was the essence of the contract, or in case of I do not complete the work of construction within a period of 3 years, then they will be entitled to re-enter.
Read in isolation, no, Ms. Manath, but read with 7.1 it is.
That's why I have shown to your lordship 7.1.
Hmm.
Now, because they are saying this. Now, my lord, but this clause 5.1.3, my lord, says, my lord, in accordance with plans, sections, and specifications, as shall be approved by the appropriate authorities on payment of such fees as required, in accordance with the building rules of the KMC, my lord, with the requirement of any land use and development control regulation and any other local or statutory obligation.
So can you show something to indicate that you had applied for plan
Yes.
and KMC refused?
Yeah, I shall show to your lordship that there are documents, my lord, in fact, letters.
Because that will give some additional color to this section.
And then, my lord, I had shown to your lordship one more thing, my lord. I had shown your lordship a letter whereby this order of status quo
Yes.
being passed by this
Page 36.
Page 36.
Yes.
So, my lord, this period, my lord, when the litigation is pending, my lord, ought to have been excluded, my lord.
All right.
It could not have been taken into consideration. Now, my lord, kindly come to page 46. This is the document, my lord, I was searching. 6 June 2003. This is to convey that the competent authority of KMDA in its 141st meeting has been pleased to accord necessary confirmation that the reserve price of rupees 6.60 lakh per katha for plot number C5 is inclusive of permission to the allotee to sublease. My lord, the intention was lease only, and we have been given the power to sublease, assign, etc., portion of the constructed area on the bulk land without altering the basic purpose of such allotment. You are therefore permitted to sublease, sublet, or assign a portion of the constructed area on the bulk land having plot number C5 that has been allotted to you, provided the basic purpose for which the land has been allotted is not altered. My lord, a licensee, my lord, cannot have a power to sublease or to create third-party interest, my lord. This was given to us in the June 2003. My lord, before I take your lordship to the exhibits, Now, my lord, before I take your lordship to various other exhibits and documents, my lord, in my plaint, my lord, we have summarized, my lord, the steps which we have taken. In support of that, my lord, I shall show to your lordship the documents. My lord, I have summarized, my lord. Thank you. Lord, kindly come to paragraph 70 and page 35 of the part 1, my lord, of the paper.
Yes.
The plaintiff has taken all steps with regard to the setting up of a supermarket cum food processing unit cum residential facility for the staff and management at the said plot of land. The plaintiff has duly applied to the statutory authorities for getting clearance for setting up of the said project. Particulars whereof are summarized as follows below. May I just place below. Entire premium value of rupees 7 crore 64 lakh 46,035 was paid in one installment. Plaintiff applied for mutation with the municipal authorities, constructed boundary wall, applied with CSC Limited and obtained electric connection. Plaintiff cleared the jungle on the land and leveled the floor level by incurring huge expenses. Paid license fee as mentioned in the deed of license for 5 years. Soil testing done and report for geotechnical investigation on 5th June 2003, my lord. My lord, I shall show to your lordship the KMDA, while cancelling my license, my lord, one of the points that has been taken is that I have not done even the soil testing and report for geotechnical investigation. Now, until unless I do the soil testing and the geotechnical investigation is done, my lord, the plan will not be accepted by the municipal authority.
Yes.
8. Commenced business of food processing unit at the said premises by obtaining requisite license from KMC and still carrying on business, including water supply. Steps taken for clearance of outstanding taxes. This I would also show, my lord, that KMDA took a considerable time in clearing their part of the tax. Paid a sum of rupees 31 lakh 81,810 on account of municipal tax in respect of the said premises. On 20th December 2005, after mutation, submitted building plan for sanction. Applied with the West Bengal Pollution Control Board for consent to establish industrial unit and paid a sum of rupees 36,360. Applied for storage of LPG gas with the Department of Explosives Nagpur and such permission was granted. Appointed Hindustan Petroleum Corporation Limited to install bulk LPG storage system. Paid a sum of rupees 2,98,363 towards security deposit and services charges to the CSC Limited apart from electricity bills as raised by the CSC Limited regularly. Applied with the Department of Fire Service for grant of fire license and deposited a sum of rupees 1,49,010 to get necessary license on 7 June 2005. Applied for grant of mutation certificate on 30th July 2005 and deposited requisite fee on 16 September 2005. Applied for grant of no objection certificate for construction from Deputy Secretary Marketing KMDA as required by West Bengal Pollution Control Board, which is yet to be granted by KMDA. Obtain microwave clearance from Telecommunication Department, my lord. Whenever, my lord, a high-rise construction is being made, my lord, this is required. So we have also got this clearance also. Permission was obtained from the fire department.
Yes.
No objection was also received from the traffic department, my lord. My lord, I shall show to your lordship the minutes also, that MIC building had also, building committee had cleared my plan. No, my lord. Kindly come to paragraph 74. The building plan, which have been submitted by the plaintiff on 20th December 2005, being plan case number 2005/20257, though having been approved by the municipal building committee, the municipal authorities, without disclosing any reason whatsoever, have set tight over the issue and are not sanctioning the plan, though necessary clearances have been granted by the telecommunication department by issuing microwave license, fire clearance, no objection from traffic department, Lal Bazar, and the file is lying in scrutiny. And my lord, the scrutiny report, my lord, I had annexed, that is of 7th of January 2008. And we have sought for no objection certificate, that was also not being given. Despite repeated requests and or demands being made by the plaintiff, the defendant authorities have failed, neglected, and or refused to issue no objection certificate to the plaintiff, as a result whereof the plaintiff, despite being ready and willing, and despite having made huge investment on the said plot of land, is unable to start work of construction of supermarket cum food processing unit cum residential for staff and management. As already stated herein above, the plaintiff has already obtained consent to establish from West Bengal Pollution Control Board and has deposited requisite fees thereof, and has made all arrangements for supply and storage of bulk gas at the premises in question, which is required for setting up a food processing unit, and has obtained electricity connection at the said premises. Then I'll show your lordship the document of 7 January 2008. Now, my lord, a question may arise why we have submitted the plan in the year 2005, though the license deed is of 22nd of May 2003. But to this, my lord, I have an answer, my lord. Kindly come to page 90. Firstly, there were obstructions and the site plan was not provided till 2004 December. Page 29 November 2004, we have written a letter to the KMDA.
Which page should we go to?
Page 90, paper part 2, paper book part 2.
Part 2. Yes.
We request you kindly also confirm the road width. All side of the premises is 50 meter or 60 meter, including Raspberry connector. We also observe that the site plans supplied by you have some defects. The indicators show wrong direction of the north side. We are enclosing here with old plan provided by you and corrected plan for your ready reference. We request you to please confirm the correct plan. Then we will kindly come on to next letter, 17 December 2004. The revised site plan was given on 17th of December 2004. Then, my lord, next is the document, my lord, which I had said, my lord, that we had applied with the Ministry of Commerce and Industry, Department of Explosives, Nagpur, on 10th of December 2004, page 92. And approval was granted on 31st December 2004 by the Explosive Department. Is the plan. Storage plan is there.
There is LPG.
LPG.
All right.
Because food industry, my lord, if unless you have a bulk LPG tank established, my lord, by the appropriate department,
You will be in short supply then.
not short supply, but there is a chance of fire, my lord.
Oh, what?
Because, my lord, I had done a matter of another group of Haldiram only at Exide mode, my lord. A fire caught in the year 2008, my lord. And then, my lord, in one of the room, then, my lord, the fire department, my lord, had asked the Haldiram Limited, the Pratik Food Products, rather, another brother, my lord, to install the bulk LPG station. My lord, the entire thing, my lord, because directly you cannot connect the cylinder to the oven. Then, my lord, there has to be a room dedicated for the storage of the gas cylinder. They will be connected with the pipe channel, and from the pipeline only the gas will go to the oven, my lord. It can, because it, in order to avoid the fire hazard, my lord. If a cylinder is connected to the oven directly, my lord, because the food is manufactured in the huge quantity, my lord, there is always a chance of fire. So, my lord, the storage has to be in a separate place altogether. So, in case of burst of any cylinder, my lord, the main factory will be separated.
Right.
So
Otherwise, it will be huge.
it will be huge.
Like a
And
bomb. Bomb is
the
like a
Air India flight, my lord, that has crashed.
yes, yes.
So, my lord, here, so we have to take the explosive license for that. And, my lord, the like Hindustan Petroleum, Bharat Petroleum, or Indian Oil, my lord, they are specialized in setting up the tank
Right.
and the bulk LPG connection. So, this has
Exclusive license is to ensure the storage.
storage
The
of
storage is
bulk
proper.
LPG, that it is stored in a very safe manner. So, this license is to be obtained from Nagpur,
All right.
which we have also done, my lord.
Yes.
And license was granted, my lord, kindly see, on 31st of December 2004. And then, my lord, it has mounted vessel, LPG storage, stake layout plan, everything was being prepared, my lord. It is not simplicity, my lord, a construction.
10th December,
In
page
December,
page 92.
page 92. And this is the letter which they have given, that we have to fabricate the tank in the manner it has been given in the letter.
All right.
Drawings are to be approved by the department. It is not simplicity, my lord, that a building is being constructed after the foundation is being digged, my lord, and a structure is being erected. But it required various precautions.
Several ancillary
Ancillaries
functions and certificates.
So, my lord, this was being done. And these were all approved.
Yes.
Then kindly come to page 94. We had engaged Hindustan Petroleum Corporation Limited to do the necessary construction, my lord. And they had given the approval 31st of December 2004. That this has reference to our offer for installation of bulk LPG storage system and supply of HP gas at subject mentioned site, and subsequently such and such. We are now in receipt of original approval letter dated 12 December 2004 from the Department of Explosive Nagpur, along with duly approved following drawings. So, my lord, drawing was to be prepared by the SPCL only. And they had taken the approval from the ministry. And they had given this mounted vessel LPG storage tank layout plan, mounted vessel LPG storage tank side view, tank elevation, everything.
This is a very specialized task. Only a few people can do it.
Very few people can do
They
it.
are the petroleum people.
Until unless this is being cleared, my lord,
No, you
we
cannot.
have not have applied with the municipal authorities for sanction of the plan, my lord.
All right.
This was being done on 31st of December 2004. Then, your lordship, the next pages are the plans, my lord, of this.
This is required where bulk food is manufactured.
Yes. when you set up an industry, my lord,
Ah.
then you need to do so.
Alright.
And nowadays, my lord, even in the restaurants, my lord, they have to make a separate storeroom for LPG gas cylinder,
Alright. Oh, even restaurants.
even restaurants. Because, my lord, I had the experience, my lord, in 2008. I was handling this entire thing, my lord, dealing with the fire department and the corporation, and they had inspected the site. And
You are in charge of Haldiram's this part of the installation. You are I mean engaged by Haldiram.
yes, my lord, Haldiram has in Calcutta, my lord, there are 3 brothers.
Achha.
Group from Rameshwara Agarwal. This is Haldiram Limited, Prabhu Shankar Agarwal, which has a showroom in VIP and a factory in Singur.
Yes.
But the one I'm talking about is at the side crossing and the Haldiram at Baliganj
Yes.
Pass.
Understood. Yes.
Yeah. So I had the opportunity, my lord, to be part of the entire inspection team, my lord.
Oh, achha.
And then I had seen that how it is being done.
Actually done.
Actually done. Then, my lord, page 105, your lordship will find, because when you, it is a extra load we had to apply for electricity.
Yes, yes.
All these are very common, my lord. This I'm not
Mhm.
doing. Then kindly come to the most relevant document, which is page 111. The plan, kindly see, this is a meeting number 335 and meeting dated 20th February 2005. The plan case has been examined in MBC meeting. Considering the provision of ramp, the committee recommends for relaxation of ground coverage for the proposed ramp leading from ground to plinth level and ground floor to top floor. Considering that the provision of such ramp is for the handicapped worker, the plan case is recommended for sanction, subject to compliance of the other departmental requisitions, if any. Necessary clearances from concerned traffic department, WBFS, and microwave clearances from the respective department will be required. According to the requisition of CSC Limited, high tension supply is required. Above recommendation of MBC requires approval of the Honorable Mayor in order to enable the department to process accordingly is placed. This was as long as on 20th February 2005. So, my lord, their contention that I have not done the soil testing and geotechnical investigation, my lord, does not hold good, my lord. And in fact, subsequent thereto, we have taken all the clearances from the traffic department, West Bengal Fire Services.
All these things which have
all these
microwave you showed us.
Yes. All these things have been done. So, my lord, from this, my lord, it cannot be said that we had not taken any steps in the matter or we were sitting tight over the issue.
So you have challenged a particular order terminating your contract.
Yes. And we have called upon the authorities to execute the lease deed. Because what they have cancelled is the license deed.
No, in the suit you have challenged their termination of your contract.
Yes. And we have called upon them to execute the lease
sir.
deed in our favor, my lord. Shall we stop today, my lord? It's 4:30.
Yes.
When?
They can
Instead of Thursday, can we do it on the next Tuesday?
It will be in the list. It will be tomorrow also. Today we are on Tuesday. It will be there in the list. If you can reach, you can reach.
আমি তো করছি।
It's a continuing matter, so continuity will be lost. Heard in part for further hearing tomorrow. Let it be in the list. Let us continue hearing.
Yes, yes.
Let her complete.
Let her complete. Yes. এটার মধ্যে ঢুকবে নোট সেট আর এগুলো সব আজকে দিয়েছে এগুলোই মূলত